Let us pray. Almighty God, we willingly acknowledge you as the supreme being, most gracious and most merciful. Look down, we beseech you, on us who are members of this Senate, and deign to assist us in the duties that we have to perform on behalf of our beloved country of Trinidad and Tobago. Open our eyes to see the truth and help us to accept it with all its implications into our lives. Direct us, O Lord, in our deliberations so that, setting aside private interests, unwholesome prejudices, and personal affections, we may treat all matters set before us with honesty, courage, and conviction. Through all we say and do in this Senate, may we give glory and honor to your holy name, inspire confidence in our fellow citizens, and make a positive contribution to the peace and prosperity of our nation. Amen.
Oath or affirmation, announcements by the President.
Honourable Senators, I have granted leave of absence to Senator the Honourable Avinash Singh and Senator David Nakid, both of whom are out of the country, and to Senator Damian Lyder, who is ill. Honourable Senators, I have received the following correspondence from Her Excellency the President, Christine Carla Kangaloo, ORTT. The Constitution of the Republic of Trinidad and Tobago, by Her Excellency Christine Carla Kangaloo, ORTT, President of the Republic of Trinidad and Tobago and Commander-in-Chief of the Armed Forces. To Ms. Kamaria, London. Whereas Senator the Honourable Avinash Singh is incapable of performing his duties as a senator by reason of his absence from Trinidad and Tobago. Now, therefore, I, Christine Carla Kangaloo, President as aforesaid, in exercise of the power vested in me by Section 44(1)(a) and Section 44(4)(a) of the Constitution of the Republic of Trinidad and Tobago, acting in accordance with the advice of the Prime Minister, do hereby appoint you, Kamaria, London, to be a member of the Senate temporarily with effect from the 2nd of July 2024 and continuing during the absence from Trinidad and Tobago of Senator the Honourable Avinash Singh. To Karunaa Bisramsingh, whereas Senator Damian Lyder is incapable of performing his duties as a senator by reason of illness. Now, therefore, I, Christine Carla Kangaloo, President as aforesaid, in exercise of the power vested in me by Section 44(1)(b) and Section 44(4)(b) of the Constitution of the Republic of Trinidad and Tobago, acting in accordance with the advice of the Leader of the Opposition, do hereby appoint you, Karunaa Bisramsingh, to be a member of the Senate temporarily with effect from the 2nd of July 2024 and continuing during the absence of Senator Damian Lyder by reason of illness. To Dr. Tim Gopeesingh, whereas Senator David Nakid is incapable of performing his duties as a senator by reason of his absence from Trinidad and Tobago. Now, therefore, I, Christine Carla Kangaloo, President as aforesaid, in exercise of the power vested in me by Section 44(1)(a) and Section 44(4)(b) of the Constitution of the Republic of Trinidad and Tobago, acting in accordance with the advice of the Leader of the Opposition, do hereby appoint you, Tim Gopeesingh, to be a member of the Senate temporarily with effect from the 2nd of July 2024 and continuing during the absence from Trinidad and Tobago of Senator David Nakid. given under my hand and the seal of the President of the Republic of Trinidad and Tobago at the Office of the President, St. Anne's, the 2nd day of July, 2024. Honorable Senators, Senators are required to take the oath.
I, Kamaria London, having been appointed a Member of Parliament, do swear by Almighty God that I will bear true faith and allegiance to Trinidad and Tobago, will uphold the Constitution and the law, and will conscientiously and impartially discharge the responsibilities to the people of Trinidad and Tobago upon which I am about to enter.
I, Dr. Tim Gopeesingh, having been appointed a Member of Parliament, do swear by the Bhagavad Gita that I will bear true faith and allegiance to Trinidad and Tobago, will uphold the Constitution and the law, and will conscientiously and impartially discharge the responsibilities to the people of Trinidad and Tobago, upon which I am about to enter.
I, Karunaa Bisramsingh, having been appointed a Member of Parliament, do swear by the Bhagavad Gita that I will bear true faith and allegiance to Trinidad and Tobago, will uphold the Constitution and the law, and will conscientiously and impartially discharge the responsibilities to the people of Trinidad and Tobago, upon which I am about to enter.
Bills brought from the House of Representatives. The Bail Amendment Bill 2024 in the name of the Attorney General.
Attorney General.
Mr. President, in accordance with Standing Order 62(1)B, I beg to move that the next stage of the bill be taken on Thursday, July 4th, 2024.
Honourable Senators, the question is that the next stage of the bill be taken on Thursday, July 4th, 2024. Those in favour say aye. Those against say no. I think the ayes have it. The next stage of the bill will be taken on Thursday, July the 4th, 2024.
Papers.
Minister of Trade and Industry.
Thank you. I have the honour to lay on the table the following papers as listed on the order paper and supplemental order paper in my name. The annual administrative report of the Ministry of Trade and Industry for the financial year ended September 30th, 2020, and the Trinidad and Tobago Special Economic Zones Amendment to Schedules 1, 2, and 4 Order 2024. Thank you.
Leader of Government Business.
Mr. President, I have the honor to lay on the table the following papers as listed on the order paper and supplemental order paper in the names of the Minister of Education and the Minister of Finance. The annual administrative report of the National Training Agency for the fiscal year 2015-2016. The annual report of the First Citizens Group Financial Holdings Limited for the financial year ending September 30th, 2023. And the Trinidad and Tobago Revenue Authority extension of period number 4 order 2024.
Urgent questions.
Senator Mark.
Yes, thank you, Mr. President. To the Minister of Public Utilities, can the Minister indicate what actions are being taken by WASA and TNTEC to expedite the restoration of services to the various communities affected by the passage of Hurricane Beryl?
Minister of Public Utilities.
Thank you very much, Mr. President. Mr. President, I would like to start by commending the first responders from the Ministry of Rural Development, as well as the public officials from the Ministry of Works and Transport, the Ministry of National Security, ODPM, and all public utility agencies who have been fully mobilized to provide support to all communities that may have been and could have been seriously impacted by the ravages of Hurricane Beryl. And despite the fact that we have been saved from the wrath of that hurricane, our public utility agencies, together with our colleagues from the various state agencies, have been out doing great work, providing support to all government agencies. And as a result of that, Mr. President, I am pleased to report that from the public utility sector, 13 of WASA's plants have been fully restored to full operation, with 4 plants remaining out of operation. And we expect that those plants to be fully restored by 6 p.m. today. With respect to TNTEC, Mr. President, I'm also pleased to report to the national community that in Trinidad and Tobago, all areas that have been impacted by severe weather conditions have been fully restored. Their electricity supply has been fully restored, and in Tobago, 98% of the affected areas, electricity services have been fully restored, Mr. President, and we expect that by 6 p.m. today, the areas that have been out of electricity, they will be fully be restored. Let me also say, Mr. President, that in the Lansform area, thank you very much.
Time for answering urgent questions. Your response has ended. Senator Mark, supplemental.
Yeah. Mr. President, can I ask the Honourable Minister, through you, whether he can share with his Senate what were some of the main challenges faced by the utility sector as it relates to the problems faced by residents in respect of WASA and TNTEC in both Trinidad and Tobago.
Okay, that so that the minister can answer
Well,
properly.
first of all, Mr. President, through you, if you can identify some of the main challenges faced by the utility sector as it relates to residents in Tobago, TNTEC, and WASA.
Minister.
Let me read the question that was filed by Senator Mark. It had nothing to do whatsoever with any challenges faced by the utility agencies. Can the minister indicate what actions are being taken by WASA and TNTEC to expedite the restoration of services to the various communities affected by the passage of Hurricane Beryl? I am now reporting to the national community that most of WASA's plants, water treatment plants, are back into full operation, and with respect to the plants that are out of operation, by 6 p.m., they will be returned to full operation. With respect to TNTEC, in Trinidad, all of the areas that were impacted, their electricity supply has been restored, and in Tobago, 98% of the communities, their electricity supply have been restored. And that by 6 p.m. today, all of the affected areas, they're expected to have their full restoration of electricity. And that is because they have been expediting their response to the disaster and to the impact of Hurricane Beryl, both in Tobago and in Trinidad.
To the Minister of Public Utilities, can the minister indicate whether additional water trucking services will be provided to those areas left without a water supply owing to non-operational water treatment plants caused by the flooded river conditions and clogged streams following Hurricane Beryl's passage?
Minister of Public Utilities.
Thank you very much, Mr. President. Mr. President, let me also commend my colleagues in the cabinet representing the government's response to the impact of Hurricane Beryl in some of our affected communities. The Minister of Works and Transport, the Minister of National Security, the Minister of Communications, as well as the Minister of Public Utilities, have all been in constant communication with the public on this, and the Minister of Local Government, led by the Minister of Local Government. I reported, Mr. President, that areas that are impacted by WASA's water treatment plants going out of operation, the call center would be operating on a 24-hour basis, and areas that require a truck-borne supply, it will be made available to them. That is in the public domain, and I have also recognized that senior officials of the Water and Sewage Authority made themselves available, and rightly so, to the national community, doing media interviews, etc., and assuring communities that are impacted by those water treatment plants going out of operation that WASA's truck-borne supply services will be made available to them. Let me conclude by saying that on my way to the Senate, I asked the question whether there have been any unusual requests for water trucks in those areas, and I am told that because most of the plants have been restored to full operation, there has not been any unusual request for water trucks in the affected communities.
Mark.
Mr. President, can I ask the Honourable Minister, through you, which areas of the country would be in need of a regular truck-borne water supply as the utility sector, WASA in particular, seeks to address those challenges that they will eventually overcome? which communities will be
Minister.
Mr. President, I am really sorry. I did not understand. I did not hear. So I'm begging the Honourable Senator if he can clear up
Okay.
his.
Could you repeat the question for the Honourable Minister so he may answer?
I thought I was pellucidly clear. Okay. Yeah, okay. Honorable President, through you to the Honorable Minister, could you provide to this Senate the communities that would require any truck-borne water supply, given the fact that there's a deficit, as admitted by your good self, in order to address challenges faced by WASA to bring their water supply?
Got the question. Minister?
You got it? Okay.
Minister?
Mr. President, there are 4 water treatment plants that are out of operation at this point in time. I am advised by the management of WASA that by 6 p.m., those plants will be returned to full operation. And that's all I have to report on the matter.
Questions on notice? Questions for oral answer?
Senator Dr. Paul Richards.
Colleagues. Question number 124 to the Minister of National Security.
Minister of Finance. Oh, Leader of Government Business, sorry.
Thank you, Mr. President. For the record, there are 4 questions for oral response on the order paper. The government is in a position to answer all of these questions. We have a strong lineup of ministers prepared to assist the Senate.
Senator Dr. Paul Richards, if you please.
Question number 124 to the Minister of National Security.
Minister of Finance.
Thank you very much, Mr. President. With respect to Part A of the question, the pallet scanner at the container examination station is almost 20 years old and currently non-operational. However, an accelerated procurement process is in progress to acquire modern, fit-for-purpose pallet scanners using the latest technology. Other scanners in the container examination station work intermittently and have to be repaired on a frequent basis as they are somehow easily damaged by errant forklifts. I think the Senator knows what I'm talking about. Answer to Part 2. The CCTV cameras at the container examination station are fully operational. 3. Regarding the challenges associated with the surveillance and scanning equipment used for inspecting containers and imported goods, the significant challenges include the following. Limited trained personnel. Nearly 24 officers, not nearly, are currently being trained for scanning operations and will be assigned to operate the newly purchased 4 mobile scanners, as well as the pallet scanners that will be purchased in the near future. The division will be assigning a total of 40 newly appointed officers to a scanner unit of the preventative branch for the scanning of containers and cargo at its ports and transit sheds. Another issue, penetration issues due to containers with large variations in density on account of different types of materials and non-palletized cargo. The density of cargo greatly affects the contrast obtained by computerized tomography, resulting in difficulties in scanning and acquiring reliable data when scanned. The new pallet scanners will provide the necessary capability to address this particular issue. The fixed scanner, which is operational, is used for containers without large variations in cargo density. In addition, as previously mentioned, 2 mobile scanners have been procured and will be commissioned at the Port of Port of Spain in the near future to enhance the Customs and Excise Division's capability to scan significantly more containers. The manufacturers indicated that the 2 mobile scanners will be delivered by August 2024 and be operational within 1 month. Further information on this is as follows. As of July 1st, yesterday, the factory acceptance test for these 2 new mobile scanners, that's for Port of Spain because there are 4, 2 will be sent to Point Lisas, was successfully conducted in France over the period June the 20th to June the 21st, 2024. The scanners were carded for shipment to Trinidad and Tobago yesterday, July 1st, and we are currently awaiting confirmation of the shipping from the agent. Finally, restrictions on the energy levels of the scanners. The use of very high energy scanners at the Port of Port of Spain is inappropriate due to the excessive power utilized and therefore may not be employed. There are some other concerns which arise from the port's close proximity to commercial and residential premises. And finally, and the last challenge is the time required to unload, scan, and reload non-palletized cargo in containers at the container examination station, because this is a very time-consuming and labor-intensive process.
Senator Dr. Paul Richards.
President, thank you, Minister, for the response. Can the Minister indicate, given his answer that the pallet scanner is 20 years old and non-operational, how long has this scanner been non-operational?
Minister of Finance.
Quite a long while. 10 years.
Senator.
Can the Minister indicate, since, just for some context, and I'll be quick, the Customs and Excise Division officials came before the National Joint Select Committee, National Security, and admitted tardiness and in some level incompetence in starting procurement processes for a scanner which was damaged. And now this pallet scanner is 10 years inoperational. If the Minister can indicate if this level of incompetence traverses to dereliction of duty or aiding and abetting criminal activity.
Minister of Finance.
Very interesting question. Unloaded. And you are essentially asking me whether the delays in procurement of scanners and the frequent damage, mysterious damage, that is why I said the Senator is aware, because the Senator would have heard testimony in the committee about a forklift mysteriously finding its way across the shed and running into the scanner more than once. If you're asking me to determine whether it's deliberate and whether it's part of some organized operation, I am not competent to answer that. Your guess is as good as mine.
Senator.
Can the Minister indicate if this disturbing, intermittent, and curious damage to scanners and tardiness in procuring new scanners, critical scanners, is severely impacting the ability to interdict, intercept contraband, including illegal guns and ammunition?
Minister of Finance.
I'm afraid that is, you're requiring an opinion from me. And I can tell you certainly if the equipment was fully functional and was not so often and easily damaged, and the procurement was not delayed in the way it has been delayed for unknown reasons by the public servants and officers involved, certainly the division would be better equipped to determine and detect contraband.
Senator.
Can the Minister indicate if this scandalous situation at the Customs and Excise Division that is clearly negatively impacting the surveillance ability of the state, given the present criminal situation in the country, is going to be the subject of a full investigation?
Minister of Finance.
Yes.
Senator Mark.
Thank you, Mr. President. Question number 121 to the Minister of Housing and Urban Development.
Minister of Housing and Urban Development.
Thank you very kindly, Mr. President. Mr. President, contrary to the assertion made by the question, these evictions were not sudden. The HDC has adhered to a structured and transparent process, ensuring that tenants receive ample notice and multiple opportunities to address their arrears before any eviction occurs. The HDC, in collaboration with its subsidiary, the Asset Management Company Limited, AMCOL, is continuing its collection drive throughout the country. And since its inception in 2005, the HDC has primarily evicted illegal occupants of units because of illegal occupancy or arrears of rentals. In 2009, there were 18 evictions. In 2010, there were 20 evictions. In 2011, there were 28 evictions. In 2012, there were 33 evictions. 2015, there were 8. 2016, 15. 2017, 80. 2018, 14. 2019, 90. 2022, 13. In 2022, there were 13. In 2023, there were 7. And in 2024, thus far, there have been 23. 5 of them being for illegal occupancy, 17 for arrears, and 1 for subletting. Mr. President, from the 394 evictions conducted over the period 2009 to 2024, 376 were for illegal occupancy. And in 2024, the evictions are for arrears and for subletting. Mr. President, the tenants who have been evicted in 2024 for arrears were to pay monthly rentals of either $800, $1,200, $1,500, or $1,800. These tenants did not respond to the HDC's numerous attempts to encourage them to pay their arrears either by way of lump sum payments or through a payment plan. They also did not inform the HDC of any issues or challenges that prevented them from paying their arrears or honoring their monthly commitments. Mr. President, the units from which these persons were evicted are being reallocated to other persons on the HDC's database. It is expected that evicted tenants will still settle their arrears. As of April 30th, 2024, the arrears are for rent-to-own units, and the amount owing to the HDC and its subsidiary is $2,105,914.32. For persons in the licensed to occupy units, the arrears are at $91,478,355.66. For rental units, the arrears stand at $76,745,383.79. For mortgages that have been given by the HDC as in-house mortgages, the arrears are at $67,712,621.19. And for the commercial properties, the arrears stand at $3,690,186.92. Mr. President, the HDC continues to extend its responsibility to taxpayers and must collect outstanding arrears. Failure to do so may lead to evictions in various housing developments nationwide, and we will not resile from this. This measure is necessary to recover unpaid rent totaling $241.7 million, to prevent the exploitation of state resources that have been allocated to provide affordable housing to those in greatest need. The average collection per month for the last 9 months since we started the eviction, with the exception of November 2023 and December 2023, was approximately $6 million. It is imperative to highlight that the collection drive has yielded significant results, and thus far, as at April 2024, the collection has yielded an amount of $9 million collected from errant tenants.
Minister, the response time for the question has ended. Senator Mark.
Thank you, Mr. President. Mr. President, through you to the Honorable Minister. Honorable Minister, as it relates to the 17 persons who owe arrears to the HDC for 2024 and have been evicted as a result, can you inform the Senate whether any attempt have been made by these tenants to communicate with the HDC with a view to addressing their arrears, even though they have been evicted?
Minister.
Thank you very much, Mr. President. Mr. President, I indicated that we communicated with all of the persons prior to them being evicted. Mr. President, to be a little more specific, at least 3 letters were sent to those tenants, some even prior to the COVID-19 period, and others from April 2023 to March 2024. And Mr. President, the arrears owed by some of those tenants amounted to $22,000, and the range was from $22,000 to $128,000 being owed to the HDC. In fact, Mr. President, 8 tenants of those 17 owed between $81,000 and $100,000. The period of arrears ranged from 2.5 years for the tenant who was owing $45,700 to approximately 7 years for the tenant that was owing $128,000 in rent. And Mr. President, of those who were evicted, 3 tenants have in fact liquidated their arrears, and as a result, they have been given back their units, and 2 tenants are in the process of liquidating their arrears, and they will be given back their units. Thank you, Mr. President.
Senator Mark.
Yeah, Mr. President, can I ask the Honorable Minister, given the sums involved as outlined by the Honorable Minister, close to over $240 million owed by various categories of tenants under the jurisdiction of the HDC, can the Minister indicate whether there is a timeline established by the HDC for the collection of these outstanding sums?
Minister.
Mr. President, even though the HDC may establish a timeline for collection, in many instances, this does not occur. And in most instances, the HDC, because of its social responsibility, also tries to be as lenient as possible with tenants, because we do recognize the cohort of citizens that we are dealing with. So it takes a very long time before the HDC will submit to having someone evicted. But Mr. President, you do recognize, and I'm sure Senator Mark recognizes, that $241 million being owed to the state in circumstances where we are trying to provide housing for other people. It makes it very difficult for the HDC as a state agency to operate, and consequently, the decision was taken that we have to act, and there are many people on the database who are willing to take these units and pay the requisite rent, Mr. President.
Senator Mark.
Mr. President, can I ask, through you to the Honourable Minister, whether the government is contemplating the formulation of a new policy as it relates to the outstanding sums owed by these various categories, so that, for instance, a clean start can be made, having regard to the length of time that this sum will take to be collected. So in other words, Mr. President, is the government contemplating a new policy, including the writing off of these sums that are owed by tenants for decades and seem irrecoverable? Can the Minister indicate?
No.
Senator Mark.
Yeah, Mr. President, can I go on to the other question through you? Question number 122 to the Minister of Finance.
Hands.
Mr. President, Senator Mark must be aware that under the provisions of the Tobago House of Assembly Act, the provision of financial assistance to any person who incurred losses as a result of any closure of beaches in Tobago in April of 2024 is a matter that has to be determined by the Tobago House of Assembly. To refresh the Honourable Senator's memory, the Assembly's responsibilities are enshrined within the Tobago House of Assembly Act, particularly the 5th schedule, and those responsibilities include, among other things, any matters related to finance, tourism, the environment, and social welfare. The closure of Tobago's beaches and any consequential impacts of same therefore fall under the purview of the Tobago House of Assembly.
Through you, Mr. President. Honourable Minister, can you indicate to the Senate whether the Tobago House of Assembly has approached the Ministry of Finance with a view to allocating finances to address this very subject matter?
Minister of Finance.
I'm not aware of any such approach, but I want to repeat that the closure of those beaches in Tobago was a unilateral action of the Tobago House of Assembly without any consultation with the central government, as they are perfectly entitled to do under the law. And I want to repeat that under the 5th schedule, the Tobago House of Assembly is responsible for finance, tourism, the environment, and social welfare. And therefore, the decision to close the beaches was taken by the House of Assembly, and therefore it is the responsibility of the Tobago House of Assembly. And to repeat, I'm not aware of any request to provide financial assistance to the persons affected.
I ask through the Honourable President to the Minister whether the government, through the Ministry of Finance, will look favourably upon any requests by the Tobago House of Assembly to address this issue of expenditure to these persons who suffered as a result of the oil spill through no fault of them or theirs right during the period, whether the government is, once approached, will give active and favourable consideration to the THA.
Mr. President, on point of order. Standing Order 28H, 1H.
28 1H. So, Senator Mark, I mean, the question that you're asking, it could be misconstrued as a hypothetical, as the Minister of Finance may have to sort of speak to the future in relation to that. I would leave it to the Minister of Finance if it is you choose to answer. Minister of Finance.
I want to make it crystal clear, Mr. President, with your permission. The member asked about closure of beaches in April of 2024. I rather suspect that that question had to do with an accident caused by a shark. I can't see the relationship between that and an oil spill that occurred in February, which did not result in closure of beaches in April. So I think the members are a little confused.
Good.
I'm coming to you, I'm hearing somebody
Senator Mark, don't be distracted. Next question on the order paper if that's what you're doing.
I'm coming to Jindal.
Senator Mark.
Okay, yeah, sure. I'm going. Mr. President, I will now address my question to the Minister of Energy, who is anxious to respond. Mr. President, question number 130 to the Minister of Energy and Energy Industries.
Minister of Energy and Energy Industries.
Thank you very much, Mr. President. I was wondering about the electric vibrations on Senator Mark's seat. Answer to Roman numeral 1. The licensor and license granted to Shell Venezuela SA and the NGC Exploration and Production Company in respect of the Dragon gas field was by the Minister of the People's Power for Petroleum on behalf of the government of the Bolivarian Republic of Venezuela. This license, therefore, was granted by the government of Venezuela. Roman 2. At this stage, the state has not been served with any order of the High Court related to any ConocoPhillips matter or arbitral award. The matter appears to still be sub judice, as well as there were recent media reports that the High Court judge amended his original order. However, on the basis of the normal principles of company law and international law, there are no risks to the Dragon project as a result of the arbitration award to ConocoPhillips against PDVSA. 3. The application to the High Court for the recognition of the arbitration award and the subsequent recognition of the arbitration award was made without any notice to the state or to any other entity, as it was an ex parte application. The ministry was made aware of this development when the matter was reported by various media institutions. 4. As indicated, the application to the High Court for the recognition of the arbitration award to ConocoPhillips and the subsequent order of the court was made without any notice to the state. Therefore, no government ministries were involved in the application to the High Court.
Senator Mark.
Mr. President, can the Minister indicate, in the absence of any notice or information communicated to the state on this matter, can the Minister indicate whether this award or order issued by the courts of Trinidad and Tobago will have any impact or effect whatsoever on this government's relations as it relates to this impending Dragon project? Can I ask the Minister to declare?
Minister of Energy.
Thank you very much, Mr. President. That question was answered already, and I repeat, the answer is, on the face of it, in accordance with the normal principles of company law, and as well as the principles of international law, sovereign immunity, and for company law, piercing of the corporate veil, an arbitral award against a company PDVSA will not affect the government of Venezuela's dealings with this license that was issued to Shell and NGC.
May I ask through you, Mr. President, whether the Honourable Minister could indicate as to his understanding of a precedent that has already been set in the United States involving a company by the name of
Reading out a statement. Hold on. I haven't heard a question in that. You need to keep it succinct and ask the minister a very specific question as it relates to the original question that you asked.
In terms of the piercing of the corporate veil that the minister made reference to, I'm just asking through you whether the minister is aware of a precedent involving Crystal X versus Venezuela in a United States court as it relates to the piercing of the corporate veil. Is the minister aware that the corporate veil has been pierced in this matter involving Crystal X and Venezuela in a matter in the courts of the United States? That is the point I'm trying to clarify.
So, again, I will allow the question, allow the minister to answer, but in the future, just try and be a little bit more specific in how you're asking that question. What you're really asking is the minister if he's aware, which ideally isn't a full-on question in relation to what we have. But Minister of Energy.
Thank you very much, Mr. President. It is obvious that, first of all, the answer is no, I am not aware. But based on the very strained information that was provided by Senator Mark, he asked if I am aware of some entity versus Venezuela. Venezuela is not a corporate entity, so there can be no piercing of a corporate veil. Venezuela is a state, it is a sovereign state, and hence I refer to international law, which says there is something called sovereign immunity. There's no piercing of corporate, which by definition means a corporate entity when it comes to the state. So either whoever is sending the information to Senator Mark wanted to mislead him, so it may possibly be somebody from the opposition, because that's the modus, or Senator Mark is struggling to interpret what he was asked. So the answer is no, but there can be no piercing of a corporate veil when it is a state involved.
Can the minister indicate to the Senate whether, or put it in another way, Mr. President, can I ask the Honourable Minister whether he is aware as to the reasons why this order issued by the courts of Trinidad and Tobago in favor of ConocoPhillips against PDVSA has not yet to date been served on PDVSA and the Venezuelan subsidiary, that is PDVSA subsidiaries? Can the minister indicate us?
The question is not logical. You can't ask the minister if he's aware as to why something hasn't happened. So you might want to rephrase that question to make it just a little bit more intelligible so the minister could answer.
I'm trying to ask the Honourable Minister, why has that order issued by the court in favor of ConocoPhillips in a matter that is going to have implications for Trinidad and Tobago, why has this order not been served on the authorities in Venezuela thus far? That is the issue I'm trying to clarify.
So you're asking the minister why an order has not been served in another country? Okay, so Senator Mark, I will leave it at that and I won't allow that question. That's the end of questions.
Public business, government business, bills, second reading.
Minister of National Security.
Thank you, Mr. President. Mr. President, I beg to move that a bill entitled An Act to Amend the Judicial and Legal Service Act, Chapter 601.
We were told by the government.
Go ahead, Senator Mark. Point of order.
President, when the Senate adjourned last week, without the government gave an order, it was whistleblower.
Senator Mark, again, 1 second, Senator Mark. Have a seat. So the question is being raised as to what specifically is the point of order, which means there's some standing order to which you're raising. So it's either a point of clarification or point of order. Which is it? Okay.
So, Mr. President, all I'm asking is your guidance. When we last left here, the acting leader of government business gave the Senate an appreciation of what to prepare for. And the first order of business, and it's reflected on the order paper, is the whistleblower. And the second one is what my colleague is about to introduce. There was no communication with myself. I don't know if he had communication with the coordinator of the independent bench. But I find it a bit strange that they will just somersault after giving us an undertaking that this is the order that we will be pursuing the matter. And I just want to get your ruling on this matter.
Mark, as far as I understand, the undertaking that was given and has been adhered to is what would be treated with today. The bills were named at that particular point in time. As you are well aware on the order paper, it is up to the members on my right to indicate what they would start with. They have done so. So I will now invite the Minister of National Security to continue.
Thank you yet again, Mr. President. I beg to move that a bill entitled An Act to Amend the Judicial and Legal Service Act, Chapter 601, the Prison Service Act, Chapter 1302, the Defense Act, Chapter 1401, the Police Service Act, Chapter 1501, the Civil Service Act, Chapter 2301, the Fire Service Act, Chapter 3550, and the Financial Intelligence Unit of Trinidad and Tobago Act, Chapter 7201, to provide a regulatory framework for polygraph and drug testing and the biometric identification for members of the protective services and certain officers in the judicial and legal service and the civil service, and for other related matters, be now read a second time. Mr. President, I am more than pleased to present for the consideration of this honorable House the Miscellaneous Provisions Testing and Identification Bill 2022, which seeks to bring the laws governing the protective services, the judicial and legal service, and certain departments in the public service in line with the 21st century. This bill comes here from the other place with a 3/5 majority. In fact, and rather unusually, every single member of their House in the other place supported this bill. The bill seeks to give the relevant heads of the various protective services and specific branches of the public service a discretionary power to order current officers and those seeking to be so employed be subjected to lie detector testing, drug testing, and the collection of their biometric information. However, this discretionary power may only be exercised in certain specified circumstances. Work towards this bill, Mr. President, began in 2018 when, in my then capacity as Minister in the Ministry of the Attorney General and Legal Affairs, I engaged the Law Reform Commission to consider the introduction of lie detector testing, drug testing, and other measures to ensure that members of the protective services and certain officers in the public service are held to the highest standards of integrity. The Commission conducted the necessary research and subsequently prepared a policy paper on which this bill stands. entitled Introducing a System of Lie Detector Tests, Drug Tests, and Biometric Information within the Protective Service and certain departments in the public service, in which certain recommendations were put forward. The Commission also prepared the bill currently before the House, which seeks to implement the recommendations as established in the policy paper. The bill received unanimous support in the other place, as I alluded to a moment ago, with some minor adjustments to bring further clarity to some of the issues that were raised therein. In Trinidad and Tobago, lie detector tests are not utilized at the criminal investigative stage, as its use is limited to evaluating the suitability of applicants to the police service. This reform has become necessary because of the allegations and, in some cases, the evidence that members of the protective services and officers in certain departments of the public service have been involved in criminal activity. Therefore, it is imperative that a system of lie detector testing be introduced to ensure that employees and prospective employees in those arms of the state possess a high standard of integrity, which is expected of persons holding such offices. The existence of a system of lie detector tests itself will act as a deterrent, Mr. President, to those officers who may be inclined to engage in criminal activity and other forms of criminal conduct. Currently, only the Trinidad and Tobago Police Service makes provision for drug testing at the recruitment stage and randomly during employment. The laws governing the other arms of the protective services do not require members to undergo testing, neither as an entry requirement nor during employment. In several jurisdictions, such as the United Kingdom, Australia, the United States, and Canada, members of their respective police organizations, armed forces, customs and immigration departments are subject to drug testing prior to and during their employment. These matters are quite routine among them. In these jurisdictions, Mr. President, testing for cause and random testing are provided for in legislation governing the respective departments. Testing can also be required after the occurrence of a critical incident which resulted in the death, for an example, injury or damage to property. When matters like these transpire in Trinidad and Tobago, everyone wants answers. Everyone wants to know how. I am asked questions in the public as a minister of government. These measures provide the most scientific means of testing the truthfulness of participants in what we describe here as critical incidents, and incidents where the public are entitled to know some facts, the truth. Biometrics allow for persons to be identified based on a set of recognizable and verifiable data, which are unique and specific to them, such as fingerprints, a biometric system that we have been using for decades. Vein patterns, eye patterns, facial signatures, and voice recognition. The introduction of a biometric identification system within the protective services and certain departments of the public service will assist investigations into alleged employee misconduct. A facial recognition system will enable investigators to identify with greater certainty employees who may have acted in a manner that amounted to misconduct from the photographs or video recordings captured from CCTV footage. This may also assist in identifying such employees where their conduct constitutes a criminal offense. Thus, the existence of a modern biometric identification system, as proposed in the bill, will serve as a deterrent to misconduct by employees, as they stand the risk of being easily identified. Therefore, a biometric identification system is critical to promoting greater responsibility and accountability within our protective services and some branches, as specified here in the public service. This bill raises some constitutional issues. So the bill seeks to give the relevant heads of the various protective services and specific branches of the public service a discretionary power to order current public officers and those seeking to be employed to be subjected to polygraph or lie detector tests, drug tests, and the collection of biometric data. These measures would encroach on the following entrenched constitutional rights: the right to protection of the law under Section 4B, the right to private life under Section 4C, which provides for the right of the individual in respect of his private and family life, and the right to equal treatment in terms of Section 4D, which provides for the right of the individual to equality of treatment from any public authority in the exercise of any of its functions. The right to the protection of the law. In this regard, the intention of this bill is to apply the proposed measures to existing and future members of the protective services, employees of the Registrar General's Department, the Board of Inland Revenue, the Customs Division, the Financial Intelligence Unit, the Immigration Division, and the Transport Division. It is well established from the case of Gladwin Ophelia King versus the Attorney General of Barbados, a case decided in 1994, which went all the way to the Privy Council, that in relation to public officers, the state, being the employer, may alter terms and conditions of public officers. In essence, the bill seeks to alter the terms and conditions of employment by amending regulatory making powers under the respective pieces of legislation to require employees in certain arms of the state to be subjected to polygraph and drug tests and to collect and store biometric information. Therefore, it is possible that the proposed amending legislation can be challenged on the grounds that the state's alteration of the terms and conditions after appointment infringes on the employee's right to protection of the law under Section 4B of the Constitution, in that it amounts to an arbitrary exercise of the power of the state. In the case of Nerve and the Queen and Severin and the Queen, 2018, decided at the Caribbean Court of Justice, they considered previous interpretations of the scope of the right in earlier cases before the same court. And the court, the CCJ that is, concluded at paragraph 45 of the judgment that, and I quote, "The right to protection of the law is the same as due process, which connotes procedural fairness, which invokes the concept of the rule of law. Protection of the law is therefore one of the underlying core elements of the rule of law, which is inherent to the Constitution. It affords every person, including convicted killers, adequate safeguards against irrationality, unreasonableness, fundamental unfairness, or arbitrary exercise of power," unquote. Therefore, by altering terms and conditions of existing employees to subject them to lie detector tests, drugs tests, and to collect and store, process biometric information, and further to make these measures future requirements or conditions of employment, can engage the right to protection under the law. This argument can only be nullified, Mr. President, if the measures are shown to be in pursuance of a legitimate aim and are proportionate in its response to that legitimate aim. In respect of the right of life, while the Constitution does not provide an express right to privacy, Section 4C provides for, and again I quote, "the right of the individual to respect for his family life." The term private and family life has been interpreted as giving rise to two separate rights, namely the right to private life and the right to family life, by the Privy Council in the Nadiki versus the Attorney General, a 2004 case that went all the way to the Privy Council as well. The decision in the Supreme Court of India in the case of Potaswamy and another versus the Union of India and others, it is instructive on the scope of the right of privacy. In this case, the claimant alleged that a new system of national identification under the Aadhaar Act, which required residents' biometric and demographic information to be collected and stored, infringed the individual's right to privacy. In his judgment, Nariman J. said the following: privacy involves the person, that is, where there is some invasion by the state of a person's rights relatable to his physical body, such as the right to move freely. Informational privacy, which does not deal with the person's body, but deals with the person's mind, and therefore recognizes that an individual may have control over the dissemination of material that is personal to him. Unauthorized use of such information may therefore lead to infringement of this right. The privacy of choice, which protects an individual's autonomy over fundamental personal choices. The court also stated, and I quote, "The invasion of privacy must be justified on the basis of a law which stipulates a procedure which is fair, just, and reasonable. The law must also be valid with reference to the encroachment on life and personal liberty under Article 21 of the law that they were interpreting. An invasion under their constitution, an invasion of the life or personal liberty must meet the threefold requirement of 1, legality, which postulates the existence of law; 2, the need defined in terms of a legitimate state aim; and 3, proportionality, which ensures a rational nexus between the objects and the means applied or adopted to them. The scope of this right to privacy and the circumstances in which it is limited per the ruling of this case was also examined in a recent Jamaican case, and so the principle was reestablished. It also raises the right, as I said, to equal treatment, and that was decided in a case, Mohanlal Bagwandeen versus the Attorney General, a 2004 case, and where Lord Caswell, again, that got to the Court of Appeal in the UK. Lord Caswell said, and I quote, "A claimant who alleges inequality of treatment or its synonym, discrimination, must ordinarily establish that he has been or would be treated differently from some other similarly circumstanced person or persons described by Lord Hutton in the case of Shamoon versus the Chief Constable of the Royal Ulster Constabulary, a 2003 case from the House of Lords, as actual and hypothetical comparators. The comparators must be such that the relevant circumstances in one case are the same or not materially different from the other." It is in the proposed measures, Mr. President, members of the protective services and employees in the specified government departments, while falling under the umbrella of employees of the state, perform distinct functions when compared to employees in other departments of the state or the public service, for example, teachers or doctors. Members of the protective services are charged with the responsibility of protecting the public and maintaining law and order in the society. They comprise the defense, law enforcement, and border protection arms, which are critical to detection and prevention of crime, particularly against drugs, firearms, human trafficking, and such like. Employees in the Registrar General's Department process important identification documents, land transaction, land registration. And we know a lot of money laundering and financing of terrorism take place using these platforms. Similarly, customs and immigration departments are the nation's first line of defense at our legal ports of entry. Employees of the FIU, their duties involve investigating suspicious activities and suspicious transactions, which is the key to Trinidad and Tobago's compliance with the FATF 40 recommendations to combat money laundering, terrorism, and terrorist financing. Thus, Mr. President, it is submitted that there is a material difference in the functions performed by some members, by members of the protective services and persons employed with the specified departments in the public service, which can distinguish them from others. And so, Mr. President, if the measures are considered discriminatory, it can be argued that they pursue a legitimate aim. That is, they seek to identify and deal with rogue elements in the protective services and certain members of the public service as an anti-crime measure. However, in relation to the proportionality of the measures, it would be imperative to incorporate the necessary safeguards to protect the fundamental rights of persons who would be subjected to the measures. In this jurisdiction, a person who alleges discriminatory treatment by a public authority is required to prove that he has been treated or would be treated differently from similar circumstanced persons, and that the discriminatory conduct is not reasonably justified, but he does not have to prove mala fides on the part of the public authority. Mr. President, the bill contains 9 clauses and requires a special or a supermajority vote. Clause 1 of the bill provides for the short title and the commencement provision by proclamation on this occasion, of course. The commencement provision ensures that any administrative measures that may be required to be put in place to support this legislation must be put in place and will be put in place before this act comes into effect. Clause 2 provides for the act to be inconsistent with the Constitution, as I alluded to in the last few moments of my presentation. The measures proposed in Clause 3 to 9 would involve subjecting members of the protective services and certain members of the public service to intrusive processes or procedures. These include having electronic devices attached to their persons, as in the case of a polygraph, for the purpose of monitoring and recording psychosociological reactions during such an examination. It will also include sometimes that the person provide a bit of hair or a strand of hair even, urine, blood, saliva samples for drug tests. It will include having their faces and eyes scanned for biometric identification and unique identification data stored in a database, something familiar to all of us in many, many ways, even as we travel in and out of the United States. In the proposed measures, members of the protective services and employees in the specified government departments, while falling under the umbrella of employees of the state, they provide, as I said earlier, very distinctive functions. Mr. President, clauses 3 to 9 seeks to insert new sections in the Judicial and Legal Service Act, in the Prison Service Act, in the Defense Act, in the Police Service Act, in the Public Service Act, in the Fire Service Act, and the Financial Intelligence Unit of Trinidad and Tobago Act, to confer on the heads of these departments, of these protective services, the Judicial and Legal Service, and the Public Service, an express power to mandate the officers under their purview to submit to polygraph or other lie detecting tests, drug tests, and the collection of biometric information for the purposes of integrity testing. Clause 3 of the bill seeks to amend the Judicial and Legal Service Act by instituting a new section, as I said. In this case, the Comptroller of Customs and Excise, the Chief Immigration Officer, the Chairman of the Board of Inland Revenue, and the Registrar General may order a law officer to submit a polygraph or lie detecting test, a drug test, or collection of their biometric information. A law officer in this instance relates to both permanent and contract employees of the state. Clause 4 seeks to amend the Prison Service Act by inserting a new section 29A to provide similar authority to the Commissioner of Prisons, where he may order an officer to submit to a polygraph or other lie detecting test. Clause 5 of the bill amends the Defense Act by inserting similar provisions for the same purpose. The Police Service Act, Clause 6 seeks to amend it by inserting a new Section 77A for the same purpose in the same terms. Clause 7 seeks to amend the Civil Service Act by inserting a new Section 11A to provide the various heads of the specified departments to order an officer to submit a polygraph or lie detecting test on the collection of biometric data. And these, as I've already explained, these departments are the Customs, the Immigration, the Board of Inland Revenue, Registrar General, and the Transport Division. The proposed amendment applies to those officers who hold substantive posts in these departments, as well as those on contract. Clause 8 seeks to amend the Fire Service Act by inserting a new Section 15A to provide the Chief Fire Officer with similar power and authority in similar circumstances. In respect of the Financial Intelligence Unit, Clause 9 seeks to insert a new Section 7A to provide the Director of the Financial Intelligence Unit with similar authority, Mr. President. So there's some degree of repetition there, making life easier for us senators as we contemplate these. The issue of constitutionality of the measures in front of us also looms large. And I want to begin by making reference to the case of Hinds and the Attorney General, decided in 2002, in which Lord Bingham of Cornhill, at page 864, when construing the Constitution, indicated that it is not to be read as an immutable historical document, but a living instrument reflecting the values of the people as they gradually change over time. In other words, it evolves to meet societal needs and expectations. It cannot stay not only cloistered, but cobweb encumbered and anachronistic. It's a living document. Further, when interpreting fundamental rights, the courts have taken a wide and purposive approach. The general principle was stated in the AG of the Gambia, a Commonwealth jurisdiction, versus Job in 1984, where Lord Diplock stated, and I quote, "A constitution, and in particular, that part of it which protects and entrenches fundamental rights and freedoms to which all persons in the state are to be entitled, is to be given generous and purposive construction. Where a proposed act of parliament, such as the bill in front of this House today, infringes, as it does, Section 4 and 5 of the Constitution, it is necessary to examine the two-pronged test for constitutionality of an act of parliament within the terms of Section 13 of our Constitution, with which all members of this House are by now largely familiar. The first test is the need to enact legislation with a special majority under Section 13(2) of the Constitution. And the second test would be to ensure that the proposed legislation is reasonably justifiable under Section 13(1) of the Constitution. And just for the benefit of those outside of this chamber, let me quote the terms of Section 31 for the record and for their benefit. An act to which this section applies may expressly declare that it shall have effect even though inconsistent with Sections 4 and 5. And if any such act does so declare, as this does, let me continue, the act shall have effect accordingly unless the act is shown not to be reasonably justifiable in a society that has a proper respect for the rights and freedom of the individual. And sub 2 of that Section 13 says, an act to which this section applies is one, the bill for which has been passed by both houses of Parliament, and that the final vote thereon in each house has been supported by the votes of not less than 3/5 of all members of that house. The proposed measures in this bill, Mr. President, must therefore be reasonably justifiable under Section 13, and the bill must be enacted with a special majority in accordance with the same provision. Thus, even where the bill has been passed with a special majority, it may still be unconstitutional if it cannot be shown to meet the second part of the test. That is to say, it is not reasonably justifiable in a society that has proper respect for the rights and freedoms of the individual. In Morgan and the AG, a 1987 case that went to the Privy Council equally, the issue to be determined by the Privy Council was whether the restriction imposed by the Rent Restriction Act, Dwelling Houses Act, of 1981 was reasonably justifiable for the purposes of Section 13. And the case as well, Mr. Justice of Appeal Nolan Barrow, in the case of Barry Francis and the State, Criminal Appeal numbers 5 and 6 of 2010, the decision in Morgan, he is saying the decision in Morgan is a decision directly on Section 13(1) of the Constitution. Lord Templeman, without resorting to any formulaic test, considered whether the rent restriction was a feature of democratic societies and how democratic societies would ordinarily apply rent restriction legislation. In our judgment, this is more consistent with the natural meaning of the term reasonably justifiable in a society which has proper respect for the rights and freedoms of the individual. The phrase itself provides the test, according to Lord Templeman, and of course restated by Mr. Justice of Appeal Nolan Barrow. The phrase itself provides the test, and it is unnecessary to provide further formula. In Morgan, Lord Templeman equated the phrase a society which has proper regard for the rights and freedoms of the individual with a democratic society. We accept that as an ideal for measuring what kind of society has proper regards for the rights and freedoms of the individual. A democracy is the most appropriate. In deciding whether Section 13(1) of the Constitution is breached, we can compare our legislation with comparable legislation from other democracies. It requires a dispassionate and detached approach by judges. Certainly, there will be a local flavor for legislation which will require judges to bear in mind our own national and cultural peculiarities, but ultimately, the assessment must be against the norms and accepted standards of civilized nations which subscribe to democratic principles, democratic systems of government, and the rule of law. In the Freitas and the Permanent Secretary of the Ministry of Agriculture, Fisheries, Land and Housing, and others in 1999, the test applied by the Privy Council for determining whether the infringement of a statute was reasonably justifiable was whether, and I quote, the legislative objective is sufficiently important to justify the limiting of the fundamental right, whether the measures designed to meet the legislative objective are rationally connected to it. So while the objective must be legitimate, another consideration, Mr. President, will be whether the measures that we are providing to deal with it are rationally connected to it. Nothing surreptitious, nothing untoward, nothing on the bias. It must be rationally connected to it. And finally, the means used to impair the right or freedom are no more than is necessary to accomplish the objective. So no overrun. Whatever the objective is, the legislative measures must meet that and nothing else. The words of Baroness Hale in Surratt versus the Attorney General must also be borne in mind when discussing the constitutionality of these measures. And where she stated, in that case of Surratt, it cannot be the case that every act of Parliament which impinges in any way upon the rights protected in Section 4 and 5 of the Constitution is for that reason alone unconstitutional. Legislation frequently affects rights such as freedom of thought and expression and the enjoyment of property. These are both qualified rights which may be limited either by general legislation or, in the particular case, provided with the provided that the limitation pursues a legitimate aim and is proportionate to it. It is for, and I want to stress this, it is for Parliament, in the first instance, to strike the balance between individual rights and the general interest. In the case of Suraj versus the Attorney General, 2022, another Privy Council matter, the board, having upheld the constitutionality of the COVID-19 regulations, went on to provide a definite ruling on the interpretation of Section 13 and the special majority requirement. In so doing, the board affirmed the position in Surat, which I had just shared with this House. The essential learning coming out of the Suraj case is that the Parliament has a choice either to enact legislation with a simple or special majority. The board held that the rights set out in sections 4 and 5 of the Constitution are not absolute and is subject to an inherent limitation, which is the proportionality test. Thus, where legislation infringes a fundamental right, its constitutionality will be upheld once it satisfies a proportionality test. On the other hand, where Parliament acknowledges that legislation significantly restricts fundamental rights, it may choose to enact legislation in accordance with Section 13. The board explained that where legislation that infringes fundamental rights are enacted by a simple majority, the threshold for justifying the limitation will be higher on the state. On the other hand, where legislation is passed by a special majority, the court will afford greater deference to the balance struck by Parliament between the restriction of the individual fundamental rights and the interests of the community. Let me put that colloquially, Mr. President, if I may, for those looking on from outside of this House. You could do it by simple majority, and you could do it by special. Once it could pass the proportionality test, and once you could demonstrate that there is a legitimate aim, but where we do it by special majority, the Constitution and the law recognizes, the courts recognize, that Parliament represents the people, 41 members of the House. That is what the people want. So they pay greater deference to the specified or the supermajority than they would if it were done by a simple majority. And the same applies to this upper chamber with all of the noble and dignified folks who populate it. Perhaps with a rare exception. I'm sorry, I'm from another place, you know. Yes, I could not help that. The legitimate aims to support this bill is to bolster national security efforts. It is beyond question that those who are sworn and paid to protect us, those who we look to for protection, those who we pay for protection, when they turn against us and act in ways inimical to our interests, the public interest, we must attend to that. And there is sufficient allegations and evidence that we have many of those in the atmosphere. Another legitimate aim is to reduce crime. Every one of us are possibly or can be victims of crime. We all feel the pain of others when they become victims. And one of the things that, as Minister of National Security, I'm called upon to account for is the prevalence of crime. And I have full support of the opposition in this regard every day, Senator Mark and others. Crime, 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 crime. Well, today we come to deal with a little bit of it. A third aim to identify rogue elements in the protective services and government departments. Even members of those services are very uncomfortable if they feel strongly that there are those who have to watch their back, who they have to depend on in the course of their work, any hour of the day or night. Sharing information which could cost individuals in the society, institutions in the society, all that it represents. And therefore, I can tell you, one element of the public are the internal ones to these services. They would be very happy to know that all anti-slopers are found out. As we used to say in the police service, old police like I am. This helps you to determine the anti-slopers. And they are everywhere. Another aim is to tackle corruption in the services. And of course, we know corruption is near endemic in our world. And finally, to promote public confidence in the national security arms and certain departments of the public service. No one in this House wants to know that any employee, officer in the Registrar General's department is concocting forged birth certificates, marriage certificates, death certificates to steal estates, to give terrorists an identity and a nationality in Trinidad and Tobago, and they set to wait for us a Carnival Sunday night in the Queen's Park Savannah when we are all having a good time, or even in the Parliament as they have done in some parts of the world. We want to know. And while this is not an exact science, and my friends in the opposition will quickly point that out, it is like democracy. It is not the best. It is not perfect. Sorry, it is not perfect. But it's the best that we have available at this time. So these aims, in light of the current criminal climate, are sufficiently important to necessitate and to limit the fundamental rights of privacy, equality of treatment, and protection of the law of employees in these departments. Constitutional rights are not absolute, as you would have heard judges say in some of the quotations that I rendered a few moments ago. The bill has built-in safeguards, so we understand the potential for abuse. So we put some safeguards in here to protect the fundamental rights of persons. One of those safeguards is that the proposed measures would only apply to persons holding posts whose duties involve access to confidential, secret, or top secret information, or where there are reasonable grounds to believe that the officer has committed an act of misconduct. And reasonable grounds is a concept that we are all familiar with. Every magistrate, every judge, every registrar of the court, very familiar. That poses no difficulty to legal judicial officers in particular. And where there are reasonable grounds to believe that the officer has committed an act of misconduct, a serious criminal offense, or is involved in serious incident resulting in death or serious injury. A shootout. And people want to know if the police right, if they're wrong, what happened. These matters assist. Thus, the powers are only exercisable in specific circumstances where the officer performs any intelligence or counterintelligence functions, where he works in an office that deals with secret, top secret, or sensitive confidential information, where he's involved in an investigation involving economic laws such as theft, embezzlement, misappropriation, serious or complex fraud, or an act of sabotage or espionage or money laundering. Where the officer has access to property that is the subject of an investigation, where there was involved a serious incident under investigation, where someone is suspected of being involved in misconduct, where he has close ties with a person charged or convicted of a serious criminal offense under the Dangerous Drugs, the Proceeds of Crime Act, the Anti-Terrorism Act, the Trafficking in Persons Act, or the Anti-Gang Act. Don't get too alarmed when you hear where he has close ties. From the time we small, your grandmother used to say, "Watch your company. By their fruits you shall know them." They used to tell you, show me your friends, and I'll tell you who you are. And that doesn't mean physical, as though I'm close to Senator London. It means closeness and proximity in terms of dealings, movements, which again is garnered by intelligence gathering. And if it comes to a charge in court, then that intelligence has to be converted to evidence in the face of a court. And we all have faith in the courts of Trinidad and Tobago. So it's not too amorphous and difficult to grasp. Mr. President, with respect to members of the protective services and certain officers in the public service, where a person is killed or injured.
Minister, you have 5 more minutes.
I thank you very kindly. So, Mr. President, the proposed measures introduce a few new terms which are defined inside of the measures, and it will be there for all of our consideration. Mr. President, it is against this background that we present these measures before this House. We have demonstrated that we are mindful of the fact that the measures here will infringe one or other elements of our entrenched constitutional rights. But I was rather elaborate in demonstrating that that is neither novel or unique to Trinidad and Tobago. All the cases I have quoted from demonstrate that that is normal and can happen once certain conditions are met. We are satisfied that the measures in front of this House meet adequately those expectations. And in those circumstances, I put these measures before this Honorable Senate for its consideration. I beg to move.
Honourable Senators, I shall now propose a question for debate. The question is that a bill entitled An Act to Amend the Judicial and Legal Services Act, Chapter 601, the Prison Service Act, Chapter 1302, the Defence Act, Chapter 1401, the Police Service Act, Chapter 1501, the Civil Service Act, Chapter 2301, the Fire Service Act, Chapter 3550, and the Financial Intelligence Unit of Trinidad and Tobago Act, Chapter 7201, to provide a regulatory framework for polygraph and drug testing and biometric identification for members of the protective services and certain officers in the judicial and legal service and the civil service, and for other related matters be now read a second time. Senator Lutchmedial-Ramdial.
Thank you, Mr. President, for the opportunity to join in this debate on the Miscellaneous Provisions Testing and Identification Bill. Mr. President, before I begin, although I hope it does not become necessary, I may crave your indulgence for a brief break if I need it. Thank you. Mr. President, let me start off by saying that I don't know why the minister should be so surprised about the support that this bill has received in the other place, because the opposition has consistently supported good law that it deems necessary for the peace, order, and good governance of Trinidad and Tobago. We are prepared on all occasions to support legislation that requires a special majority once we are satisfied that the underlying policy of the bill pursues a legitimate aim and that there are sufficient safeguards in place to ensure that the rights of all affected persons are balanced and that no one group of persons are disproportionately affected without just cause. I am very happy to hear the minister recite all of the law that deals with special majority and to recognize that even in light of the decisions in Surat and Suraj and so on, the court gives a special and a certain level of deference when special majority clauses are included and the Parliament as a whole comes together to pass laws recognizing the legitimate aim and the policy being pursued. And we have consistently, when it is required of us, we have examined bills and we have come here to, of course, raise issues, concerns, encourage debate. That is what it is about here. But we support bills that pursue a legitimate aim and that we deem to be in the best interest of society. So I start off with that, just in response to one minister's expressed surprise about the support that he has received. Mr. President, the bill contains 9 clauses and it was introduced in January of 2022. The second reading took place in February of 2022 and it then was brought back and so on. The bill amends 7 pieces of parent legislation and it also contains a proclamation clause. These 7 pieces of legislation, the parent bills which are being amended by this, the parent acts being amended by this bill today, covers by and large a very large part, or if not all of the public service of Trinidad and Tobago, and so it impacts a vast number of persons. The objective of the bill is stated as providing a regulatory framework for polygraph, drug testing, and biometric identification for members of public service and certain officers within the GLSC, as well as the civil service. And Mr. President, the bill goes on to provide in certain circumstances that for confidentiality of the test results, and generally that there's exemption from disclosure on the freedom of information and so on. Mr. President, it is important for us to look at the scope and the reach of the proposed amendments to the Parents Act, and they are generally similar. There are certain things that may be a little bit different for the protective services, like, for example, where someone dies as a result of a discharge of a firearm and so on. But by and large, the requirement to subject certain officers to the different types of testing are consistent across all of the sections of and all the clauses of the bill that deal with the different aspects of our public service. So I'll just raise a couple of things one by one, and we can go through them. The entire protective services and the FIU, the JLSC, and the civil service perform very important functions. There could be no denial. And corruption within any of those services, in any of those divisions or departments of government, can, in fact, contribute to the widespread criminality that we are facing here today. We all recognize that. And so it is important, and it has already been implemented in various areas of the protective services, where as a sort of a screening or filtering process, we are administering drug testing and polygraph testing before we allow persons to enter our protective services. The bill seeks to now subject persons whilst they are in the course of their employment to that similar type of testing in order to determine whether or not they are contributing to crime, whether they are facilitating, procuring, and assisting criminals in various types of conduct, or whether they are assisting them to conceal their criminal conduct by virtue of the access that they have to certain amounts of information. There can be no doubt that persons within Trinidad and Tobago feel that there is a level of corruption, there's a level of assistance being rendered to criminals, and that is what makes detection and conviction so difficult. And so we understand, therefore, that there is a legitimate aim to be pursued, and the question is whether we are going about it in a manner which is the correct way, one, and secondly, that there is no overreach in any regard whatsoever in terms of the affected persons. In terms of the JLSC, it covers legal officers in a department or an attorney at law employed by the state on contract in a department, and it limits its scope to Customs and Excise Division, Immigration Division, Board of Inland Revenue, and Registrar General's Department. So the attorneys who are working within these divisions can therefore be subjected to the testing that is introduced by this bill. I understand the need for drug testing as it pertains to members of the protective services because of the nature of the job they carry out, the need for them to carry firearms and so on. But I'm a bit concerned about drug testing for lawyers who work within the departments identified here. So as I said, the provisions tend to be a sort of consistent regardless of which category of employees we are looking at and which service commission they fall under and which parent legislation they are governed by. But I am not certain, and I would ask speakers that come after me, or perhaps the minister is winding up, to say whether or not he feels that that particular type of testing may be justified in relation to the attorneys working in these divisions. The use of drugs, when you're dealing with someone who has a firearm, who might be involved in pursuing someone, physically pursuing them, when you are dealing with someone whose judgment and so on can be impaired whilst they are on duty by the use of particular types of drugs, not just illegal drugs, but even drugs like that containing medications and so on that might impair their judgment while they are out on duty. Those things, I could see it as being very legitimate that you would want to subject police officers, persons in defense force, etc., to that type of testing. Attorneys who are dealing with documents and files and so on, apart from some, unless you suspect that they are involved in trafficking of drugs, I cannot, I'm not 100% certain that drug testing in this case would meet the requirement of being reasonably justified and being proportional when you consider the type of work that they do. Because it's not just looking at the department in which someone works that we have to do here. We have to look at the type of work that they are undertaking. So is someone in the Registrar General's department who could possibly, falsify deeds and birth certificates and create false documents and so on, is their use of marijuana something that we want to be able to drug test for and then look at as we go on down the road? You see, all of these things we have to consider as in light of the consequences that may flow, and I'll get to that in a little while when we talk about consequences. With respect to the civil service, we are looking at officers both on contract, Customs and Excise Division, Immigration Division, Board of Inland Revenue, Registrar General, and the Transport Division. Again, drug testing, I'm not certain. Polygraph and biometric testing and so on. Certainly, if you want to deal with, I know that there's an issue with documents appearing and disappearing from some of these departments. You may wish to have people's fingerprints on file. You may wish to have other biometric information stored about them. So, because I assume we would be moving towards sooner or later digitalization of these files, and you may want to implement digital access type technology to determine who has access to certain files, so that's fine. But drug testing persons working in these specific divisions, again, I raise it as a concern because I do not know that we want to be sure. We want to be sure when we as a parliament pass this piece of legislation that there's absolutely no aspect of overreach with respect to any group of persons who might be covered and who might be affected by this bill. And with respect to the protective services, as I said before, Defence Force, Prisons, Fire, and FIU, they are captured. The scope of the bill goes on to capture persons, including experts, consultants on contract, and their employees assigned to specific jobs with the relevant agencies, as well as the contract employees. Now, the application of these amendments to the parent law are limited. And that's true. And that's one measure that helps with the proportionality argument. So it's limited in terms of the work being performed. It's limited in terms of the type of access to information. So, for example, the bill seeks to limit the applicability to only people dealing with top secret, confidential, sensitive information, and so on. And it also limits the applicability in terms of involvement in ongoing investigations, access to property files, instances where there's reasonable suspicion of involvement in a matter. And then there's, of course, the issue of the proximity, which I have to admit did cause me some discomfort, because sometimes it's very vague and it's very unclear and it could be very subjective. So if you, to determine who is in proximity to somebody else, I'm forced sometimes to be in proximity to members opposite. I hope that is not a stain on my character, but it could be. It is sometimes we have to work with all kinds of people, and we have to in a government office, or whether you interact with someone and how you interact, what kind of proximity you have to a person is a very subjective test, Mr. President. So it could be that if a person is charged or convicted of a criminal offense under one of the bills that is listed here in this, under one of the acts listed here in this bill, how do you judge who is in proximity to that person, and will that person now become a candidate to have their privacy and their private life invaded by this bill so that they will be subjected to testing? So is it that if the person sitting on the desk next to me within a government department has been found guilty of stealing or producing false papers within the Registrar General's department, and I am the person sitting there who has vision, they're within my line of sight all day, and they think that I may have known what this person is doing. Am I now to be subjected to polygraph testing or some other type of testing because I am in proximity, I eat lunch with them, we travel home together, whatever it is we do. So within our workplace environment, it is a term like in proximity is extremely vague, and I think that we have to look at whether or not that can result in some overreach. Now, the overall need for these amendments, because we determined that there's corruption within the state and that has been a factor contributing to crime, there's really a limited amount of information being put forward as to how the results of these tests would be used to then tackle the issue of corruption when it is detected. Because we understand screening people before they come into the job. That's fine. But when people are on the job and you decide that for whatever reason, be it proximity, be it the type of information they have access to or whatever. So the bill passes, it is proclaimed. Next week we decide all the analysts at the FIU who have access to private and confidential information, we're going to polygraph all of you. And let's say it have 10 of them and 5 of them fail the polygraph test. What are you going to do? How are you going to use the information? Polygraph testing is not admissible in a court. Is it that you're then going to send the information to the police and ask them to investigate these persons? Is it that you're going to initiate things? If you drug test all of them and 5 of them come back positive for THC, are you going to, institute disciplinary proceedings? I think that information ought to be given, because the minister mentioned that one of the objectives and one of the aims being pursued by this legislation is to bolster public confidence in our protective services and in the public services who deal with this, who are, subject to corruption and where we feel we need to tighten up on corruption. So if you want them to have confidence, and if you want to have buy-in, and you want to not have, a lot of objection to this type of legislation being passed, intrusive legislation that we all recognize and admit infringes on certain constitutional rights and freedoms, we must have more information about how this type of these tests and the results of these tests would be collected. The only thing the bill says, going beyond the actual power to test, is that it will be confidential. It doesn't say anything more than that. And I think that's a major shortcoming of this bill. It does not have accompanying regulations. And even though it says that the regulations, and I'm happy we don't have to fight for it this time, I think it says that the regulations would be subject to affirmative resolution. Doesn't it? Yes, I just double-checked it right. Affirmative resolution. It would have been very good in this debate and in deciding whether to lend support to this and in convincing the public that this deserves the support of all members of both houses of Parliament, if we knew what those regulations are and if we knew exactly what would be done with those test results and how it's intended to be used. So just saying that it's going to be kept confidential or that there's a requirement for confidentiality really doesn't treat with that concern. And I've noticed after the bill was debated in the other house that some of the associations who represent the employees to be affected by this bill have raised concerns. The Police and Social Welfare Association is one of them that comes to mind because I read it in the newspaper. But that's the second thing, and that's a second shortcoming that I find requires, or we need the government to address in this, perhaps in the wind-up of the debate. The minister mentioned that this policy began in 2018. They started preparing the policy paper entitled Introducing a System of Lie Detector Test, Drug Testing and Biometric Identification within the Protective Service and certain departments of the public service. And from 2018, we are now in 2024. So if you are working on a policy from 2018, and we are now in 2024 debating this, did you circulate that policy or a draft of this bill to any of the associations that represent the persons who would be affected by this? The Police and Social Welfare Association, the Law Association, the Public Service Association. Were any of them aware that this policy was being drafted? Were any of them given the opportunity to contribute or to comment on that policy? Did you have stakeholder consultation? I mean, that is a very important part of the lawmaking process. All of us who went to law school read Zander. The lawmaking process, consultation, green paper, white paper, all of those things are an important part of that process. Was that process followed? Or was this simply a policy that made its way to cabinet and then a bill was produced and it has been brought here? Again, those things bolster confidence and buy-in in legislation, which is what you want to achieve and is what you want to get. You cannot simply come here and say, there's corruption within the services, we need to tackle it, crime is out of control, we want the opposition support. We're prepared to give it. We are prepared to give it because we understand the serious consequences. We understand that we are in dire straits when it comes to crime, which is out of control in this country. But that doesn't mean that we don't ask for a high standard when it comes to drafting and presenting legislation to this House, Mr. President. And so I think that whatever consultation took place, if any at all, ought to be shared with us, and we would like to know what were the comments coming from those associations. The service commissions who are involved in hiring, firing, disciplining officers who would be affected by this legislation ought to have also been consulted on this matter. Because the logical, the logical thing that might flow from some of these tests being done, we're not just administering these tests so we could store it and keep it, right? There may be consequences to flow from it. And those consequences may automatically involve disciplinary proceedings. And those fall under the service commissions. Are the service commissions empowered to discipline for some of the things that may arise out of these tests being done? Are the service commissions empowered to perhaps transfer people out of departments where they are dealing? Would it be sufficient for them to be able to transfer an employee who is subject to the test under this bill and fails? If I work in the Registrar General's department and there's some board paper scandal and I am subjected to a polygraph test or fingerprint, my fingerprints are used to determine that I was the person to access certain files or something like that, would I be transferred out of that department pending an investigation? It is the Service Commission who has to do that if I'm a public officer. So we need to look at those things, and I would have hoped that that level of consultation and that those considerations would have taken place before this bill was brought to the Parliament, and that we would have had some more information about it, Mr. President. Could I just have 1 minute, please? Mr. President, the other concern that I wish to raise very quickly is the issue of contract officers. Contract officers are being captured by this bill, and they have no security of tenure when they work for the state. Almost all state contracts are 3 years long. Most people get 3-year contracts. There's been quite a bit of uproar, particularly amongst lawyers employed by the state who are even on short-term contracts, 3-month contracts. So if you are employed on a 3-month contract, but you fall and you are captured by this bill, you could actually be asked to forego your right to privacy and private life and supply biometric information. You could be asked to subject yourself to a polygraph test. You could be asked to give blood, saliva, all kind of bodily fluids to be tested. And you're on a 3-month contract or even a 3-year contract, and that information could be held indefinitely because there's absolutely no limit as to the time. And I mean, in a society where we understand you can have breaches of security. We had a whole debacle this year involving hacking and so on at state enterprises and agencies and all of that, and people's personal financial information and so on being leaked. I worked for the state on contract about 15 years ago. If I was subjected to this bill, it could be that they would still have my information now. And somebody could hack it and somebody could get it. They could get any type of personal information about me. And that is where it is important for us to understand what is the use of this information. And I think that another safeguard that ought to have been considered is a time limit for storage of the information that you're collecting here, particularly where it pertains to contract officers, because I don't know that it's proportional. It may be proportional to collect it if you have a suspicion for the term during which a person is employed, while they have access to the information, while they have access to investigations, while they can undertake or do something that could corrupt the system. But when they leave and they go away and they retire or they give up their contract after 3 years, is it really justifiable to continue to hold this person's biometric information and keep it in storage indefinitely? I understand that investigations, you may have to look back at things that may have happened, but even under the proceeds of crime and FIU, and when you collect financial information, and when you have to keep records and so on, there's a 6-year limit. There's a 6-year limit for record keeping. So I think we ought to consider, and I think that if we haven't yet considered a limit for the time of the storage of this information, that again, it bolsters the proportionality of the measures. Yeah, and yes, that's about having a custodian and having all those things in place, because it isn't, I think, proportional enough just to say that it shall be kept confidential. When it comes to persons who are, and I'll give you the example of the Prison Service Act, the amendments made to the Prison Service Act, Mr. President, when I read this, I thought it was quite interesting that an officer includes an expert or consultant on contract or an employee of such an expert or consultant on that particular job with the prison service. Now, again, it goes to proportionality, because you are not simply saying persons who have voluntarily become employed with the prison service, whether it is they're coming in or they are presently employed, will be subjected to this. IT is a good example of an area where almost all of our public services contract out. They bring in contractors. You're setting up a new, they call all them fancy shelving thing and storage and whatever it is, IT systems. Most of the times, they will contract a company to come in and do those things. You want in your own data center. Data center is the word I was looking for. You want your own data center installed. You want your own network, you're doing all these different types of things. All of those things, you hire a contractor. A company will contract with the government to do work, let's say, in the prisons, to set up a data center or something like that. And any employee that has access to information, whether it is criminal records or something like that, who works for that particular contractor, will now also be subject to this bill. So there are very, very far-reaching consequences. And if someone becomes employed with, I don't want to call the name of any particular company, but a large multinational IT services company, they are governed by a contract of employment. And would their contract of employment now be subject to this requirement because that company has engaged in a contract with the government? It could be seen as a change to the terms and conditions of their contract. So private enterprises who do work for the government would now have an issue with their employees being covered by this. And that's a serious matter as well. Was there consultation? I know that there's no association to represent all the different companies that consult, but was this taken into account? Was it taken into account how private contractual rights between employers and employees could be affected when this provision was included? And is it proportionate? Is it proportionate to ask the private citizen working for a private company where there's corruption within the public service? That is because remember, let's go back to what is the aim and objective here. Let's look at what the bill says. The objective of this bill is because we want to tackle the corruption and the need for us to have persons who are beyond reproach when they are working in certain divisions of government. But can you affect private contractual rights with those things? So these are some of the concerns that we have, Mr. President. I think that it would be necessary in certain circumstances to limit the types of tests that are being carried out with respect to the different services. I would ask the government to consider strongly whether drug testing ought to be implemented across all the different 7 identified groups of persons here. As I said before, I don't know that all of them ought to be subjected to drug testing. I think that the overall need for the amendments, because we are tackling corruption within arms of the state, it is a noble pursuit by the government. I commend that they are, when we listen to answers given to questions here today that insinuate that we don't have enough scanning taking place at our ports of entry, and we all know, and the insinuation is that it's deliberately so, and scanners are being deliberately perhaps damaged, and that's why we don't have, or that's why we have the massive influx of firearms and ammunition into this country. We all understand why it is necessary to encroach on some people's rights in order to detect and to weed out those few bad apples that spoiling the whole barrel. But we have to balance that, and that's what we're here to do. We're here to do a balancing exercise, and so we have raised these concerns in the hope that it would assist as much as possible in creating a good law, a law that can withstand a Section 14 challenge, because nothing in Surat, Suraj, Hinds, all them cases that we read here today, like if, all of that, really says that somebody cannot challenge it. Someone could. Someone can challenge this law and say that even though it was passed with a 2/3 majority, and even though you get the support of the opposition and all members of both houses of parliament, they can still cherry pick aspects of this bill and say that it is not reasonably justifiable in a society that has respect for the rights and freedoms of individuals. And if we go one step beyond what is necessary in relation to any particular group of persons covered by it, and I said, when I started off, I said there's a very large group of people that could be affected by this bill. We run the risk of having this bill, despite how legitimate its aim might be, of this bill being struck down by a court. And so that is why we raise these concerns. I want to say finally that I would hope that a bill such as this, involving the collection and storage of personal information, and if we are passing laws like this, that it would work as an impetus to the government to fast-track the implementation of the Data Protection Act, because it has been far too long that the Data Protection Act has been languishing. It has come before joint select committees that I sit on. Even before I was here, I think there was a committee that considered it. We keep hearing that it is being looked at again, and it's being revised, and it has to be modernized to come up to terms with new standards and so on. Legislation has to keep pace with what our country is doing. And if we are passing laws to collect people's private and personal information, and to keep information about them, whether they are subjected to drug tests, polygraph tests, or whatever, data protection is an important tool in the armory of the state to ensure that there is a proper balance of rights for persons in this country. So with those few words, Mr. President, I thank you.
Senator Vieira.
Thank you, Mr. President. Happily, unlike the whistleblower protection bill, there's no controversy on whether a special majority is necessary for the passing of this legislation. Clearly, a special majority is required, especially having regard to the general matter of invasion of privacy and other rights and freedoms. So let me say from the outset, I have no problem with the provisions relating to drug testing and to the collection of biometric information, but I do not support introduction of polygraphic testing, especially when research shows that the verdict is divided on the accuracy and reliability of polygraphic testing. And so I'm going to largely confine the thrust of my contribution on polygraph tests. Now, even though this technology has been around since the 1960s, the use of polygraph tests for screening prospective employees remains a very controversial topic, with both supporters and detractors. And in fact, there are oceans of disagreement between the two camps. The detractors posit that there is no scientific evidence that polygraph tests work, and that it's very easy to throw off the baseline. Critics argue that the point of the test is not to catch a person lying, but to scare them into telling the truth. In effect, the test is only as good as the examiner. Well, for me, that raises legal and ethical issues and concerns. Because if polygraph tests cannot be shown to be 100% reliable, if there is a high chance of fallibility, if we know that innocent people can fail and guilty people can pass, then why are we using them? More so when the mover of the motion has confirmed that it will abrogate enshrined fundamental rights. Why should we pass a law based on suspect or unreliable technology that could negatively impact a person's job prospects or how they may be viewed at work? Now, I know people who are bright and honest, but they freeze the minute they are put to do a test. Now, why should their future hang in the balance over a test that can induce stress and anxiety, when the test itself can affect the results and potentially unfairly disqualify them? The polygraph examiner may be seeing dishonesty when the candidate is simply projecting anxiety, unrelated guilt, or some other form of arousal. Now, this technology comes out of the United States, yet in that jurisdiction, the Employee Polygraph Protection Act generally prohibits the use of polygraph tests for most private employers. True, that act will allow exceptions for security-related jobs and for cases where an employer is investigating specific incidents of, say, theft or loss. But the very fact that those tests can be disallowed for one group, while at the same time being allowed for another, well, that strikes me as incongruous, inconsistent, and contradictory. Now, I'm not blind to the arguments in favor of polygraph testing. For example, proponents for polygraph tests posit that they can serve as a detriment against dishonest behavior. Knowing that they may be subjected to a polygraph test, a candidate might be less likely to lie or to engage in unethical behavior. They argue that polygraph tests can be used to verify the accuracy of information provided by candidates, such as their past job history or any criminal activity. And for roles in national security, law enforcement, or other sensitive areas, such as the judiciary, polygraphs can help ensure that candidates do not pose a risk. Those are the arguments, but I'm not convinced. Besides concerns regarding the availability of qualified operators, and I could see in Trinidad and Tobago, we're going to have all kinds of cultural and other issues in administering these tests. For example, if you have a white polygraph examiner interrogating a little black boy, how is that going to work out? What kind of language are you going to be using? I see potential for prejudice, stereotyping, and abuse. For example, where questions may concern union activity, sexual orientation, political affiliation, family problems. Most importantly, I have reservations that despite decades of judicial, legislative, and scientific discussion, no consensus has as yet emerged on the accuracy of polygraph tests. After all these years, the much vaunted lie detector remains unproven, especially having regard to the possibility of what they call false positives and false negatives. So to me, the attempts to justify its use seem spacious and unsatisfactory. Consider, for example, notwithstanding their long use in the US, from which this technology comes. How might this technology have held up where people like Donald Trump, Steve Bannon, Giuliani, and others were able to attain high office? How did it serve as a guardrail against Brett Kavanaugh and others from sitting on their Supreme Court? Now, I'm not going to comment further, but I wonder how effective lie detectors tests really are when the rubber hits the road. All things considered, I'm not convinced that polygraph examinations reliably identify truthful and untruthful individuals. And in fact, it seems to me that polygraph testing lies more in the realm of pseudoscience rather than actual science. And in any event, I think we may be better served using traditional alternatives, such as background checks, reference checks, structured interviews. Now, perhaps I'm being sentimentally idealistic, but it seems to me that the tried and tested alternatives can provide the necessary information without the drawbacks, ethical implications, and potential risks posed by polygraphs. In terms of balancing the pros and cons, it seems to me that the negatives and the uncertainties of polygraph testing outweigh any purported benefit as a means towards determining deception and untruthfulness. Are the costs worth the gains? I don't see it. So I find no compelling reason to give polygraph testing my support. However, as I stated from the outset, I have no issue with the use of drug tests and the collection of biometric information. And with those few words, I thank you.
Public Administration.
Yes. Thank you, Mr. President, for giving me the opportunity to contribute to this very important debate. I will start, Mr. President, by giving you a story of an incident that occurred while I was in the private sector. I was invited to attend a training session a management training session in the US. And as part of that session, successful CEOs of successful companies were invited to talk to us. And the CEO that impressed me the most was the CEO of Disney. Because what he said to us was that Disney, to ensure they identified what kind of experience they wanted their clientele to have. And to ensure that that experience was manifested in the operations, they started with their recruitment process and managed from the recruitment of the employee to the entire employee's life. They managed how those employees would interact with the public by creating a whole ecosystem. So from the design of the entranceway to how you were greeted when you got in, to the test you gave, to who interviewed you, all of this influenced the kind of people who Disney not only hired but retained. And because of that, those of us who have been to Disney can testify that you are almost always guaranteed a positive experience when you go to Disney because it's so carefully managed. Now, as a Minister of Public Admin, when I try to apply that to what we do in the public service to determine that we have the right employees, I appreciate that we started off from a place where we are far away from that. Chalk and cheese is what Disney does. But in trying to put things in place to ensure that we have a better public service, I can tell you that the objective of the Ministry of Public Admin is not to ensure that government is the highest employer in Trinidad and Tobago. That we are not the people that employees come to as a last resort when they can't get jobs elsewhere. What we want to ensure is that we have a cohesive unit that provides proper, adequate, efficient services to the people of Trinidad and Tobago. And so we are trying to create an ecosystem that allows us to have that in terms of the buildings we put them in, the re-engineering of processes, the digitalization of services, and so on. But one of the critical things that we need to do is to ensure that we have the right people in the right jobs. And this is one of the things we're trying to do with this bit of legislation. Now, we have all heard the stories. We have heard the stories about the cop who stops you on the road, and if you offer him something, he will let you pass without a ticket. We have heard the stories of, more significantly, policemen getting a tip-off, going on a significant raid, expecting to meet certain things, and when they get there, there's nothing going on because it is alleged as a tip-off. We've heard the stories about licensing officers taking aspirant drivers out on the streets and saying, well, if you give me something, I'll give you a pass. We've heard the stories, and it happened, including when I was at the Board of Inland Revenue, about Inland Revenue officers taking away tax returns from the building to take them home to do whatever needs to be done to ensure that the person doesn't pay more tax than he or she desires to pay. We have heard the stories about people going onto the Inland Revenue system and adjusting tax assessments down from $11 million to $1 million. So in all walks of life, in Trinidad and Tobago, we have people who do a disservice to the people of Trinidad and Tobago by getting involved in corrupt activity. Trinidad and Tobago has so much to commend it. Up to today, when we were talking about how Beryl passed us like an express bus, and we are so lucky to be able to say time and time again, we had the earthquake last week, we had Beryl this week, that Trinidad and Tobago is blessed. And that God must be, and in recognition of all the Tobagonians who are taking over our parliament, that God must be a Trinbagonian, and I would like to take this opportunity to welcome Temporary Senator London. God must be a Trinbagonian because he has blessed us and continues to bless us with so much. But if we do not fix this fundamental flaw in the character of some of the Trinbagonians, who give us a bad name throughout the world, who undermine what we are trying to do, who undermine the security of our nation, then we will not give credit to the fact that God has treated us and continues to treat us so well. So this is an area that we need to address. So how are we seeking to address this in relation to this particular bill? The bill seeks to provide a regulatory framework for polygraph and drug testing and biometric identification for members of several services: police, prisons, defense force, fire, immigration. Those are the ones that are national security related. So we keep asking ourselves the question, how is it that in Napa, you can't receive a call because it seems as though the connection is blocked, but you're going to a prison that's supposed to have jammers and you can make calls and receive calls at will. In the defense force that we have traditionally regarded as our last bastion of protection, where the police have failed us, we can look to the defense force. We are hearing stories coming out of there too, that guns issued to officers of the defense force are being used in criminal activity, that members of the defense force are involved in shady activity. Fire, immigration, all of these people, although the majority of people in these services serve us well, there are elements that bring us all down. In addition to that, we are looking at the Registrar General, Customs and Excise. We've heard the stories there too. We've heard the stories, for example, both with respect to the police and with respect to Customs and Excise, of drug seizures taking place, and when you get to court, half the drugs have been eaten by rats. You know, we've heard those stories. We have the FIU, who is looking at anti-money laundering and anti-terrorism, and we need to ensure that all of these agencies are doing their jobs in the way that they need to do them to protect life and limb and our financial security. So this legislation confers on the heads of these various agencies the express power to mandate officers under their purview to submit to polygraph testing or other lie detecting tests, and the collection of biometric information for the purpose of integrity testing. Let me try to deal a bit with Senator Vieira's concern. Because I understand, Senator Vieira, that you are concerned about the fact that despite the years of it being a tool that's been used for various purposes, that there continues to be concerns about the efficacy and the accuracy of polygraph testing. And while I acknowledge that, a couple of things I would like to say, and I'd leave the best for the scientists in the group to deal with. But a couple of things I'd like to say on that. One is that there are control tests in the whole polygraph system to limit the likelihood of somebody being condemned as lying because they are uncomfortable, because they are nervous about the testing. There are control questions to treat with that. Secondly, it is not being proposed that we use the polygraph test to provide as evidence in court, for example, to prosecute anybody for anything that has been done. What we are trying to do is secure a series of tools to allow us to better assess whether and how we can rely on people who are serving us in different areas. So, for example, if we are about to embark on a particularly dangerous police exercise, and we need to know whether we can rely on these group of people to keep it confidential and to act properly, then in those circumstances, a polygraph test could be one of the tools we could use to determine how we pick the team. Because at the moment, or so far, what has happened is that when we have got to these sensitive criminal activity areas, we have found that nothing is going on, so we don't arrest anybody and we don't seize anything. But what could happen is that a rogue officer can lead a team of specially trained officers who are seeking to serve Trinidad and Tobago, can lead them into a situation of danger where they can lose their lives. So we are trying to minimize the likelihood of that happening. So it may not be that we can use the polygraph test in a way that we can negatively impact on the freedom or even the career progression of the officer. But we can use it to limit the areas of risk and exposure to the team that officer would otherwise be working with. And I think it is important to be able to give the heads of those divisions that are charged with those important responsibilities sufficient ammunition to be able to provide as much protection as possible to the officers under their charge. Where the officer is assigned to certain, we can use them to determine which officers we are comfortable assigning to different units, we can use it to determine which officers we are happy to share information with. And this leads me to a point raised by Senator Lutchmedial-Ramdial, where she says, should lawyers be subjected to drug testing? And again, I would say that what we are doing is seeking to give the leaders of the relevant units the ability to determine whether and in what circumstances these tools are rolled out. So I wouldn't expect every attorney in the various units that are impacted to be drug tested every week. But what I would expect is that if a supervisor determines that there is reason to be concerned about an attorney in a particular unit, and we have to remember that attorneys, because of the role they play, tend to have access to all relevant information involved in any particular operation. So they have a wealth of information, and because of that, they're potentially dangerous. So if they are compromised because they are using drugs, then the supervisor should be in a position to be able to assess that, to determine, is this person the right person to put on this exercise, to share this information with, or would that be too much of an exposure? So should attorneys be included in the list? I say yes. What we need to do is judiciously determine how the power to call for those tests is exercised. The results of the tests, as we have all recognized, are to be treated as confidential and, very importantly, are exempt from the disclosure of the Freedom of Information Act. The officer who has access to property, to information, or to files that are subject to investigation should be, and the legislation is seeking to make them subject to the tests that we are seeking to introduce under the amendments that we have brought before this House today. If there is reasonable suspicion, because the legislation lays out the circumstances in which these tests can be called for, and we have tried to be very circumspect in how we identify those circumstances. So it is not abuse, it is not too wide a power, it is very reasonable, it is very circumscribed, and so will protect the officers and their privacy unless there's reason to believe that there's something suspicious is going on. And in those circumstances, we do need to give the supervisors of those officers the right to call for the test, and if the tests prove that the officer is fine, then we move on. But if the tests prove there's reason for suspicion, then we create the circumstances which will allow us to more successfully police the citizens, issues in Trinidad and Tobago, and to protect the officers who we put on the front line to treat with these dangerous circumstances. I cannot overemphasize the fact that these officers who work in these special units are placed in highly dangerous, volatile positions. And if they cannot rely on and trust the people that they work with, then how can we reasonably expect them to ask them to continue to put their lives on the line to protect the rest of us? We need to protect them as much as we are asking them to protect us. And how do we do that? By identifying and treating with potentially rogue officers. So as I said, if it's only a suspicion, there may be nothing that we can do about the officer and his career path or even prosecution. But what we can do is say, let us exclude the officer for safety's sake from this investigation so we reduce the risk of exposure of the rest of the team to any danger. I don't think in these circumstances that is an unreasonable request. So what will introducing the authority to the ability to bring these tests do? It will enhance the trust and integrity of the various arms of the state that are all involved in very significant activity. Now, while we focus on criminal activity and therefore the police service by and large, along with the defense force and so, I would also remind you, as a former Inland Revenue person myself, that we are not only seeking to protect the lives of Trinidad and Tobago, but we are seeking to protect the financial stability of Trinidad and Tobago, because as one of our studies that was done when we were looking at whether to bring the TTRA or not demonstrated, and we would have indicated that in previous debates, that our tax collection is short by about $14 billion a year. Do you know what Trinidad and Tobago could do with even half of $14 billion a year? Apart from get rid of the deficit, we'd be able to take care of all our citizens. The Minister of Social Development will have all the money she needs to take care of the indigent and so on. We can build all the homes that we want and all the schools that we want if we can get those funds. So if we can identify and treat with the miscreants in the tax authority who hamper our ability to collect the amount of taxes that we should be collecting, then we will be far advanced. So that is one of the reasons I fully support this debate in respect of the Inland Revenue and the Customs and Excise. Even as we try to shift from the traditional Customs and Excise and Inland Revenue to the TTRA, we need to ensure that the people we bring into and retain and promote and give serious positions in the TTRA are the right caliber people, who are approaching their jobs in the right way, who are not minded to be corrupted by a bribe or whatever else, so that this suite of legislation, this bill that will impact the suite of legislation, will allow us to protect our citizens from physical harm, and will also allow us to protect Trinidad and Tobago from financial harm by these few miscreants in the public service and elsewhere who are intent on enriching themselves at the expense of the rest of Trinidad and Tobago. Another issue that we need to bear in mind that will be supported if we pass this bill is that as we become more and more of a global village, and as we acknowledge that to treat with international crime in particular more effectively, we have to work with and cooperate with international entities who are also trying to do the same thing. So one of the areas that the Prime Minister has led us to within recent times following the crime symposium a year ago was to collaborate with the US in terms of identifying and seizing ammunition to prevent the flow of ammunition in Trinidad and Tobago. As part of that exercise, it's possible that law enforcement in the States may want to work with law enforcement in Trinidad and Tobago. And what we are coming to recognize is that law enforcement agencies outside of Trinidad and Tobago are less inclined to work with our law enforcement if they are not persuaded that we are not applying these tests to understand the mettle of the people that we are putting out there, because they are not prepared to put their people at risk because our people may not be trustworthy. So if we are to allow ourselves the opportunity to engage in activity with other law enforcement and other units, then we have to equip ourselves with the right people and be able to demonstrate that by being able to have access to the use of these tools. This tool will also allow us to combat organized crime. Retired UWI lecturer Darius Vieira noted that the bill is crucial for policing national security effectively and keeping ahead of transnational organized crime. There have been concerns expressed about how wide-reaching the bill is. And while the bill needs to be wide-reaching enough for us to be allowed to do the testing in the various areas that we have identified, among the units that we have identified, we have taken care to put safeguards in the bill to minimize the encroachment on the rights of the individuals who will be impacted. We have defined the scope of the bill very carefully, indicated which units will be impacted, who has the authority, the circumstances in which they have the authority, and when that authority can be exercised. So we are trying to carefully circumscribe how this authority is exercised, but the authority we must have, or we will not move forward. What the bill will allow us to do is to not only test people as they come in, which we can do because it can be, we have acknowledged that if it is a condition to enter, then it is not an infringement. You make the choice as to whether you put forward your name as a candidate or not. But once you are in the system, all we can do currently is to ask you, please, to subject yourself. And in the past, persons have said, no, we are not going to subject ourselves. And while action has been taken against those persons in terms of moving them out of that particular unit, that particular sensitive unit, in a litigious society like we have, even those decisions may be challenged. So we do need the legislative authority to be able to test people as they grow in their career. Because even if you come in and you're perfectly fine and naive and not involved in anything, as time passes, that may change. So we need to be able to test you from time to time to ensure that you continue to be the right caliber of person for the jobs that we are assigning you to. So Director of the Police Complaints Authority fully endorses this approach, because in trying to ensure that he can identify who rogue officers are and how they should be dealt with, he sees this as a tool that is necessary to give real teeth to that authority and to be able for us to treat with those rogue officers. We have put in the confidentiality provisions that prevent the information from being shared generally. Now, Senator Lutchmedial raised concerns about the fact that we haven't stipulated all the details in the regulations and they should be ready now. I would like to remind Senator Lutchmedial that the bill does provide that the regulations must be passed by an affirmative resolution, which means that it has to come back before this place, and we will have a full opportunity to debate and to amend and to fix and to perfect what the regulations will look like. But as is our traditional approach, we seek to pass the main legislation, and then we treat with the regulations, which we have every intention to do. Senator Lutchmedial also questioned whether we had any consultation or whether it was a secretive exercise to put this bill together. I'm sure the minister in his wrap-up will advise you, as he did to the House very recently, that there was wide consultation with all the stakeholders who will be impacted by this, and they have all accepted the reasonableness of this approach and are happy to support it. So we have come to this House unusually with a bill that requires a special majority. Because it is important, because it is required, because I know despite whatever side on the fence we sit on, we want a Trinidad and Tobago that functions well, where crime is under control, where we are collecting the right amount of taxes, where we can expect service because service is due to us and not because we're prepared to pay an officer to get the service. So bipartisan support and consensus is what we are seeking this afternoon. We are seeking the support of everyone in this House, because with that support, we will show to the nation that we recognize the significance of this bill, that we are trying to do something about the corruption that everybody in Trinidad and Tobago is beginning to accept as a part of life. And as parliamentarians, we cannot afford to accept that this is a part of our life. We have the opportunity today to put measures in place to minimize corruption. I don't think we can ever eradicate it, nobody ever has, but certainly we can minimize it so it becomes the exception rather than the expected norm. And that is the reason why we are seeking to ensure that we can send a strong message to the citizens of Trinidad and Tobago that the entire Senate, as did the entire House, is in support of this bill because it recognizes the importance of it and it recognizes what it can do for Trinidad and Tobago. On the passage of this bill and the proper implementation of this bill, we expect an improvement in public confidence, because we are saying to the public that we are looking at the officers, we know they're rogue officers, the plan is to identify them and to ensure that they do not get in the way of your safety, of your protection, of your financial stability. This bill will say that the Parliament is serious, I don't want to say the government, the Parliament is serious about addressing corruption and crime. We have to send that message and we have to do something about this thing that we keep talking about. The bill will say, passage of the bill by the House will say that we are in step with international standards, that we will have the confidence of our international partners who will want to work with us, but want the confidence of knowing that we are choosing the right people for them to work with. And that we are doing the things that the international community has identified as reasonable and required to ensure that we minimize corrupt activity and corrupt officers. The bill has the potential to reduce corruption and misconduct, which can directly impact on our economic and social benefits, as I indicated previously. By supporting this bill, the Senate will help to create a more stable and attractive environment for investment and development, ethical governance, and business practices. So before I wrap up, let me just address a couple more of the issues raised by Senator Lutchmedial-Ramdial. I dealt with the attorney issue. Just to clarify, Senator Lutchmedial-Ramdial seemed to misunderstand what the minister who piloted the bill indicated. When we talk about proximity in the bill, we are not talking about proximity in terms of who is next to you. We're talking about proximity in terms of who you interact with. Because who you interact with may point to who you involve in your nefarious activities. And if we are trying to identify which are the corrupt officers involved in this transaction, we will not only look at you, but if you interact frequently or interact in a particular case with a group of people, then we may want to look at that group of people as well. So that is what proximity means. It is interaction. It is, as the minister said, show me your friends and I'll tell you who you are. How will the test be used to combat corruption? Now, at the moment, we are one of the nations, and not all nations are like this, but a lot of them still are. At the moment, we are among the nations that say polygraph testing is not sufficiently scientific for us to use it as evidence in court to convict somebody for crime A or crime B. And that will continue to pertain as it relates to polygraph testing under this legislation. But as I indicated in response to Senator Vieira's position earlier, it can be used as a tool to indicate where we can minimize risk in respect of various activities that the state is involved in. And the one that particularly concerns me is where we put our police and other law enforcement officers at risk when we send them out there to do work and they're not sure who has their back. So we need to put them in a position where we can say to them, we have carefully selected this team, we have tested this team, we are satisfied that this team can be trusted, and therefore you can go out there and expect the team to have your back. As opposed to saying, well, you know, Senator Mitchell has been around for a while, so we promote him into the unit, but we're not sure about him. No, we have to move away from that. We have to be able to say to people, these people, based on our tests, can be trusted. And where we think somebody is questionable, we have taken them off of the team because we want to ensure that you are as safe as we can make you. It is important for us to do that. So I'm asking for you to support even the polygraph testing, even despite the fact that it hasn't got a perfect scientific rating, because it is a tool that will allow us to draw certain conclusions as to who we can rely on for what purpose. And that is all we're seeking to do. We're not seeking to fire somebody. We're not seeking to prosecute somebody. We are seeking to ensure that the people who we give responsibility to, we can safely rely on them to fulfill those obligations. In terms of contract officers, Senator Lutchmedial raised concerns about whether contract officers should be subjected to these tests because they don't have security of tenure, and we are securing information on them that I guess is not consistent with the fact that they're not there for a long time. But in response to that, I will say to Senator Lutchmedial-Ramdial, look at the alternative. Because contract officers at the moment are in high number in the public service. So they will be used for significant activity. And they can put somebody in a precarious position if they cannot be trusted. So should we test contract officers? Most definitely we should. As we complete the job evaluation exercise, and we determine what our public service should look like, the need for contract officers will be reduced, but will not be eliminated. We will continue to need contract officers, for example, for short-term exercises. Like a mass digitalization rollout exercise may not be something that will be required 20 years from now, it's required now. So we may not hire a significant number of permanent and pensionable public servants to work in a digitalization unit, but we will require a lot of contract officers. But any officer, regardless of whether they're contract, short-term, or whatever, who has the knowledge and information and access to negatively impact a significant matter of the state has to be subject to these tests. You can't say because the person is only there for 3 years, but that person has information on a significant raid that the police are going to make, that no, we can't test him because he doesn't have security of tenure. Yes, we do. We have to be able to test that person because we have to be able to rely on the integrity of the officers who have the information that can be used to the detriment of persons in Trinidad and Tobago, or perhaps the whole of Trinidad and Tobago.
Minister, you have 5 more minutes.
Thank you, Mr. President. We have to have the authority to test these people. So it doesn't matter whether he's contract or not. Final question Senator Lutchmedial asked in respect of several of her submissions, is it proportionate? And my view is, if you look at the downside of having a rogue officer in these significant areas with access to the kinds of information that exist, in particular in national security, that could put us all at risk, then having an ability for a supervisor in the relevant prescribed circumstances to be able to call for the testing of an officer is more than proportionate in my view. You are talking about the rights of an individual, yes, but against the safety of a nation. If that is not proportionate, I don't know what is. So, as I indicated before, I would really ask the entire Senate, every individual member, to give favorable consideration to this important bit of legislation. We have seen the escalation of crime. We have seen its use in all of the various agencies that we are seeking to address. And we know that the state has been putting different measures in place to improve the circumstances. This is a measure that I think will have significant impact in reducing the level of corruption in the police service, the defense force, the inland revenue, the customs and excise, and all of these areas that we have ourselves complained on from time to time. So I ask you to favorably consider providing your support to this bill, and with those views, Mr. President, I thank you.
Senator Bisramsingh.
Mr. President, I thank you for the opportunity. Mr. President, I thank you for the opportunity to contribute to this debate today. What we have is a bill that touches on the balance between security and privacy. We are Trimbagonians. We know the crime rates in our country. We know about the level of corruption in society and where we stand on the corruption index. So we understand the need for legislation like this. However, we must be careful and we must do a balancing act. We must weigh the benefits with the risks. Now, let's start with the first part, the drug testing. It is without dispute that drug testing is a crucial part of the screening process for officers in our protective services. There is no argument to that. We understand the advantages that would come to that those persons to be regularly tested. We understand that, no disputes there. Now, let's move on to see who this bill would apply to. Now, the category of persons that had me a bit concerned was the category of legal officers. And this can include an attorney at law in various departments. I know Senator West would have indicated that consultation was done, but I am uncertain whether consultation was done with the Law Association of Trinidad and Tobago. The bill speaks about the category of persons that would be subjected to these new measures. And I understand the need for those categories. Person who they may be a subject of an investigation, they are involved in certain types of activities, suspected of certain activities. So I understand the need for all of that. But what I too have some concern with is with the proximity part. What does that mean? Is it a relative? Is it a friend? I know Senator West tried to alleviate some concerns there, but this bill does not clearly define what proximity means. And that provision can be used loosely to essentially find a way to make everyone be subjected to these measures. Now, when I read this bill, I couldn't find what we were going to do with the results from these tests. Yes, I understand why we are collecting it. I understand the persons who we're collecting it from, but I don't know. I am uncertain still about the use of it. Again, I know Senator West would have tried to alleviate some concerns there. But I have concerns with whether when this is collected, whether it's going to be or sought to be used in court. I have concerns there. I have concerns with where are we going to draw the line? Is it that an officer who is suspected of some criminal offense and who is subjected to this polygraph testing and who fails that polygraph testing, is it now that the results of that can be used in the prosecution of him in court? Is it that we no longer going to have a trial? I am uncertain with that. And as a criminal attorney, I am also a bit concerned with how are we balancing the polygraph testing with the right I have not to incriminate myself. So I have a little bit of concern there as well. Senator Vieira went into the reliability of polygraph testing, how subjective it can be, the different conditions that can influence the different results. So I don't even need to go into that and talk about how uncertain and unreliable this can be. What I would like to know is that whether persons who are subjected to these tests and whether they fail, whether they have a right to review or challenge these results, and what would be the process of that? How would that work? And with respect to the point of the biometric information collection, I have some concerns with respect to this bill that is before us. It is not clear and it is not specific. It is silent on the exact collection, storage, and the use of the biometric data. We also don't have safeguards with respect to unauthorized access, hacking, those sorts of things from happening. What is also important, and this bill is silent on, is the retention period for this data. There is no data retention policy indicated. Again, we don't have the regulations, so much of it is we just guessing. We don't know, we don't have the specifics of it. So all in all, we are here, we would support good law. But with good law, we need some specifics. We need the regulations. We have some concerns and that they need to be answered. This bill as is, we need more information, the more nitty-gritty of it in order to be able to have the full support, in order to have good law. And we are here and we will support good law. I thank you.
Senator Deoroop Teemal.
I thank you, Mr. Vice President, for the opportunity to contribute to the matter before this Honorable Senate. Mr. Vice President, I think that the challenge before us is not just to look at the strength of the legal framework for any legislation that is before us, but also that as legislators, we need to assess the effectiveness of the legislation, the provisions within the legislation itself that would address the effectiveness of the legislation. And at times, it may take us outside the purview of this exercise because we often would have to use a context-based approach to assessing effectiveness. And sometimes it may be necessary to address some of the factors that shape the context of legislation that is before us. Now, I would totally agree, with all the contributions thus far in terms of the need for legislation to address the chronic corruption in most of our institutions. And any attempt to bring such legislation deserves support. But at the same time, whilst providing that support, I think we need to also have in-depth reflection and in-depth identification of the ramifications and the impact that such legislation should have. Now, in this particular case, the Honorable Minister of National Security, in piloting this bill, would have gone to lengths to explain to this House the context, one of the contexts in which this bill is being presented, particularly in the context of not being in accordance with Sections 4 and 5 of the Constitution. And the major part of his contribution was dedicated to that. And of course, I do not intend to challenge anything that was said within that, but to acknowledge the laying of the groundwork and the basis for the legislation before us by the Honorable Minister of National Security. Like my colleague, Senator Vieira, my concerns are not really about the drug testing and the biometrics, but I do have some reservations about the polygraph testing. Now, one of the questions uppermost in my mind before this debate began would have been, what would the results of polygraph testing done under this Act be used for? Because in going through the Act itself, it is not explicitly stated, in my opinion, what it would be used as a basis for, what it will be used to inform, what actions arise out of polygraph testing. And the Honorable Minister of Public Administration did spend a lot of time in her contribution addressing this. But despite that, I would still like to raise some concerns. And because what I gathered from her contribution is that the polygraph testing is being used primarily to address deviant officers within the respective agencies. That falls within the 7 agencies being covered by this piece of legislation, or the term rogue officers within the TTPS. But the question is, using polygraph testing, because polygraph testing does not come cheap. It is an expensive procedure. It calls for a lot of training requirements. It calls for investment in equipment, and it calls for investment in human resources. So it does not come cheap. And if we are putting forward that one of the primary objectives of the polygraph testing is to identify, like rogue officers and defiant officers, but then we stop short there by saying that we are not going to involve them in exercises, or in other words, most likely we are going to sideline them. And this has been the tradition, particularly in the TTPS, where we have so many officers on suspension at the expense of the state, because we continue to pay their salaries and all of these things whilst they are on suspension. And if the polygraph testing is being aimed at, when these guys fail these tests, sidelining them, well then, how much of the problem are we really solving with such an approach? And are we going to look to take it, bite the bullet, take it forward to be used as a basis for disciplinary charges so that it justifies the expenditure rather than just sidelining possible termination of employment and the initiation of indictable proceedings based on the acts that they are involved in? Or, as I said, is it a question of intelligence gathering, which is what I seem to be getting in order to build probably more informed, to have more informed decision-making and have more effective action being taken by the respective agencies to curb or to minimize corruption. Now, polygraph testing in itself, also referred to as lie detector testing, is a contentious tool in law enforcement. We heard from Senator Vieira, some of the reasons. Accuracy of polygraph tests is a major concern. There's no doubt about it. And various studies have shown that polygraphs can either produce false positives, indicating deception when the person is truthful, or the reverse, false negatives, indicating truthfulness when the person is deceptive. I think Senator Vieira did also mention persons may also experience stress or nervousness during the test, which can affect the results. And nervousness can be misinterpreted as deception, leading to false positives. And of course, this can lead to wrongful accusations or overlooking of deceit. The Honorable Minister of Public Administration did mention that the way that the testing is conducted in itself could address this issue. Now, there is no scientific consensus on the validity of polygraph testing. And critics would argue that polygraphs measure more physiological responses that can be triggered by various emotions and not just deceit. Other than that, using such tests can damage the trust between officers and their employers. And this, I think we have to bear in mind in the context of what the Minister of Public Administration did say, because by trying to identify rogue officers, yes, there's a positive there. But if the very system that we are using to do that damages trust within the units, within the operation units, then we need to also address that. There is a potential for abuse or misuse of polygraph testing in law enforcement, and the results might be used selectively to support preconceived notions or biases. And the reason I would mention this, selectively choosing persons to undergo polygraph testing could be abused based on preconceived notions or biases that have come to the department head through other reports from other persons, both internal and external. Now, being subjected to polygraph testing can negatively impact the morale of officers, and it may create an atmosphere of mistrust and suspicion, which can affect teamwork and overall job satisfaction. It was mentioned that polygraph testing requires extensive training, and of course, misinterpretation by adequately trained examiners can lead to dangerous and erroneous conclusions. Now, I have just expressed some of the concerns, and it highlights the complex nature of polygraph testing in law enforcement. How do we address these concerns? I know there are provisions for regulations in the Act before us, and I trust that the regulations will fully address the issue of accuracy and provide guidance and procedures to mitigate against questionable accuracy, as well as personnel management strategies by the respective agencies and departments put in place to address proper training and work environment concerns. And that regulations would also include persons who believe, recourse for persons who believe that they are wronged by the polygraph testing, maybe in the way that it was conducted, in the interpretation, or the manner in which they have been selected to undergo polygraph testing. But again, it relates back to what the testing is going to be used for, and if it would enter the arena of disciplinary charges, termination of employment, or the institution of indictable proceedings. Now, in the context of everything that I've said, would other alternative methods for assessing truthfulness and integrity be considered prior to resorting to polygraph testing? If we are to admit the limitations of polygraph testing and the challenges of polygraph testing, and the invasion of privacy rights of individuals with polygraph testing, what other alternative methods are there that can mitigate against the disadvantages of polygraph testing and provide or add to the reliability and the ethical means of evaluation? There is the behavioral analysis interview, or the BIA. A lot of us would be familiar with that. And it's a technique that involves structured interviews where trained professionals look for behavioral cues and inconsistencies in the interviewee's story. And the focus is on observing non-verbal cues, body language, and facial expressions. Also, there is the method of cognitive interviewing, where this method encourages the interviewee to recall information in a more detailed and thorough manner. It involves asking open-ended questions and allowing the interviewee to describe events in their own words, which can help identify inconsistencies or fabricated details. Psychological testing, another alternative method, where various psychological tests and assessments can help gauge personality traits, moral reasoning, and susceptibility to dishonest behavior. And there are several psychological tests that are commonly used. And then, just one more I would highlight, situational judgment tests, or SJTs as they are called, where these tests present hypothetical scenarios relevant to law enforcement and ask candidates how they would respond. And the responses, of course, are then evaluated to assess decision-making, ethical reasoning, and integrity. Mr. Vice President, I am of the view that by considering alternative methods or a combination of alternative methods with polygraph testing, law enforcement agencies can create a more comprehensive and reliable approach to assessing truthfulness and integrity, thereby reducing reliance on a single method that could be questioned because of substantive lack of scientific integrity. And thereby, such a combination could improve overall accuracy and fairness. And it is all in the interest of mitigating against privacy rights as enshrined in our Constitution. Just one minor thing, one more point before I close, in that the way that the legislation is drafted, the heads of the department of the various, of the 7 agencies or entities are the ones who would order polygraph testing for respective officers within their management. But I need to ask an uncomfortable question. In the case of the heads of the department themselves, who authorizes the polygraph test? Because I think the situation we are in, it is not a facetious question, because, I mean, from what we have seen, the extent of possible corruption could extend all the way very high in the organization. And in such a case where we are talking about we need to assess the integrity or truthfulness of the senior-most officer. Actually, the names are presented in the... Yes, please.
Is, of course, a very important question. I spent some time with the FBI a couple of years ago on a program, 3 weeks, and would discover that every single member of the FBI, except the director, is polygraphed. In the case of Trinidad and Tobago, the police regulations now permit the use of polygraphs on entry and in certain circumstances while they are in the employ of the service. The Commissioner of Police, in the process of his or her appointment by the Police Service Commission, part of it from the presidential order is vetting and integrity testing. And the Commissioner of Police is polygraphed. And this legislation is intended, of course, to create a framework, a broader framework for its systematic implementation, because what exists for the police now does not exist for the Defense Force or the Fire Service or the Registrar General and such like. So you've raised a rather important issue, and it's going to be taken into account in the progression of this society as we go forward. But we are off to a great start today. Thank you.
Yeah, thank you very much, Honorable Minister, for your intervention. Because the reason I ask as well is because, you know, we are seeing that, you know, in terms of applying a law to officers, and then others seem to be immune from that law. I mean, we have the recent example of what is happening in the United States, where the president seems to be totally above the law and subject to immunity, irrespective of what is considered. And it's just a guard against that we are setting up such a situation, and that we have options to ensure that if it goes to, if the current practices do extend to such high-ranking officers, that we are in a position to take action and bring about the results that are intended by this bill. With that, Mr. Vice President, I thank you.
Minister of Technology, Senator Bacchus.
Thank you, Mr. Vice President. And just to be clear for the record, Minister of Digital Transformation. Yes. That would be me. I thank you for being given the opportunity to join this debate. It is it's one of the few when it came up on the agenda. I thought it might be a good chance for me to come in and use some of my technical acumen. On the face of this bill, and obviously from the consensus that we had both in the other place and here, the bill is not considered controversial. And I think that is a testament to, one, its intent, but more so its framing and the way in which it is being promulgated between here and the other place. So I think we're in good shape where that is concerned. The items contained within, and I'm not going to go through the sections, they were well dealt with already, and I'm sure more will be dealt with again. But the three things, the polygraph testing, the drug testing, and the biometrics, I think are things that we can quantify to a certain extent in the science. Let's start with the easy one. The easy one, I think, is drug testing. I think very few people will have queries about the science of drug testing. It's employed and deployed all over the world. It's done by people within their own homes. It's done, in law enforcement. It's done in a number of cases. And I have not found very many instances where the technology itself is being challenged, drug testing. The one case I found that really stood out for me in that the accuracy of the test was queried, the procedure and the chain of custody of the things associated with were queried, and eventually did not lead to vindication of the individual involved, despite winning in multiple courts of law, goes back to a case in athletics. Butch Reynolds. And I don't know how many of you would know who Butch Reynolds is, but he was the world record holder in the 400 meters. And after a meet in France, I think in Lausanne, he was selected for a random drug test. It was done. He was found to have been, in that case, doping. Both A and B samples came back positive, and he was banned. Subsequent evidence came out around that indicated that, it wasn't him. Wrong guy. Proven in 2 courts of law. But the people that ran athletics at the time refused to allow him back. This not only speaks to one part of what we're talking about, the drug testing, it also speaks to the biometrics. The biometric component of the drug test still didn't match, and they still did not allow him back. That doesn't speak to a failing of the science. That speaks to a failing of the processes and the people involved. As we go through these things, it is very important that we always have to remember that there are people who eventually have to work through this. And Senator Teemal, I think you were quite right in trying to figure out how we are going to address all of the things all the way to the top of where this goes. So it's one of the things that can happen. It is not typical, but it can happen. In the case of biometrics, I don't know that we have any issues with biometrics. Biometrics, by definition, is a fairly broad term, but it can be broken down into 2 categories, primarily, and then it could be further subdivided. But you're really dealing with the physiological part of it and the behavioral part of it. The physiological part of it deals with things that we're kind of accustomed to: fingerprints, hand shape, finger vein patterns, eye and retina scans, face shape, etc. And the biological parts really deal with DNA, blood, saliva, all the other pieces like that. Behavioral, voice recognition, gait, signature dynamics, and gestures. All of these things, when combined, you would think will give you a 100% accuracy for the identity of someone. Even in the face of all of those things, it still isn't 100% accurate. As a measurement for investigative purposes, biometrics are considered the most appropriate and the most reliable. And you could understand why I've given all the pieces that they have. And these are the reasons why. They're universal, which means you could find them on almost all individuals. They're unique, making it possible to differentiate one from the other, and that's specifically what you're trying to do. They're permanent to some extent. They don't change significantly over time. They're recordable, they're measurable, allowing for future comparison, and they tend to somewhat be forgery-proof. It's very difficult for someone to show up as you and not be you. But yet, despite all that, biometric measurements rely on statistical algorithms and therefore cannot be 100% reliable when used alone. So even in the things that we consider to be foolproof, there are still levels of error associated with those things. I was talking to a group of people recently, and I asked them, where do they go for truth? It was an interesting conversation. Where do you go for truth? So first one came up, the internet. Well, unfortunately, that is not a good place to go for truth. But strangely enough, when interviewed, 90% of the people interviewed said they would use information from the internet as true. So even if it's inaccuracies, people still believed it. And it is not only inaccurate, it's inaccurate to a really bad way. False news, according to misinformation studies, are more likely to be retweeted than true ones. False, and that's just a physiological thing. In a 2018 study, the Pew Research Center indicated that 64% of American adults believe fake news. Let's use a simpler one. A perspective offered in 2019 by the Oxford University found that 30% of the news shared on Twitter in the lead up to the 2018 elections was from dubious sources and suggested that the information was inaccurate. Yet people consume it. It is interesting when we talk about truth, where do we go? Do we go to the individual? All of what we're doing here is to figure out whether or not the individual is being truthful or not. So you can't go to the internet, you can't go to the individual. Where do you go? What we are trying to do is to create the avenues that will give us the best way to get to what we think the truth is. There are no absolutes in this game, and I think that is something we have to almost consider from the start. But at the same time, you don't want to be using bad technology in the pursuit of what you're doing. A key component of something that was said, and I think, again, Senator Teemal, I think you addressed it in a way that I think I would like to address it as well. And that speaks to the fact that none of these things are designed to happen in isolation. You called on a number of additional investigative methods. Number of them. I wrote them down, all four of them, and I know you have more. The interesting thing is, on the technology side, I have 9 that are separate from your 4. That if used together, and they also have various levels of accuracy. But think about this. A cognitive interview is about your ability to recall. Suppose you just happen to be one of those people who have a good memory. What happens to you? Do you pass? Are you being discriminated against in any way? Situational judgment test. A lot of the results of what you're doing come back to some subjective method that cannot be 100% accurate. And therefore, you want to, again, use these things in combination. There is nothing in the legislation that I have seen that says anything that is being done here is exclusive. As a matter of fact, the only way it's going to work is if it is in combination with other things. And there are other investigative methods that happen here. Because to today, without polygraph, there are still methods that are being used. You add this to that, and you get another piece to it. Let me deal with the polygraph piece. So biometrics, really, really good. Drug testing, also really good, but not as good as biometrics. Polygraph is the most of the ones where the most concerns are coming. Polygraph technology, commonly known as lie detection, what does it do? It does the same thing. It measures physiological responses, heart rate, blood pressure, respiration, skin conductivity, and so on, in an effort to determine truthfulness. The accuracy, again, I don't need to speak to that because there are studies on both sides that indicate whether it's good, bad, or otherwise. But I am going to raise some statistics here which have, and I have the citations that will go with them. I'm sure there are citations that can be made on the other side. But let's just look at these. Let's talk about accuracy rates, polygraph testing, field study accuracy. This was done by the Department of Defense Polygraph Institute, and this is obviously in the US. Based on real-world applications of polygraphs typically report accuracy rates ranging in the high 80s to 90% in detecting truthfulness and deceptive responses. These studies account for the complexities of stress and of practical scenarios. And the thing is, the control lab studies that they did subsequent to that with the National Research Council. So in other words, they did field tests, high 80s. They did control tests in a more controlled environment, in a laboratory settings where variables are more vigorously managed. Accuracy rates were slightly higher, ranging to the low to mid-90s. These studies provide a more, idealized assessment of polygraph performance, but obviously it might be difficult to replicate that in the real world, I think, for the complexities they have. This was done by the National Research Council of the US. There are some other components to this, specificity in some cases and sensitivity. Those numbers are in the 90s. If you want to know what that is, specificity refers to the polygraph's ability to correctly identify truthful responses. And they've separated those into different categories, but truthful responses. High rates in the 90s indicate that they're very effective, polygraphs are very effective at confirming when someone is telling the truth. This was according to polygraph and lie detection test that was done in 2013. Sensitivity, another key thing that they're looking at to determine what it is, measures the polygraph's ability to correct and detect deception. So specificity is for truth, sensitivity is for deception. And that rate's slightly lower, in the 80 to 85% range. You see where I understand where the doubt comes in, but notice the percentages. And these suggest that polygraphs are fairly effective at detecting lies. And of course, there's a margin for error. And there is the citation for this is from Vieira, I'm not sure how to pronounce that. And this is a lot older study that was done in 2008. The false negatives and false positives, which are the things, again, Senator Vieira, both you and Senator Teemal spoke about. And you gave the description, but just for the sake of clarity, I'll repeat it. A false positive occurs when the truthfulness of an individual is incorrectly identified as deceptive. You're telling the truth, but they're saying you're being deceptive. Rates of false positives for polygraphs vary, but they occur in about 10 to 15% of cases. So, false negatives. False negative are the opposite. A deceptive individual is incorrectly identified as being truthful. This, however, is a bit lower, between 5 and 10%. So just like AI, which is good at certain things and not good at others, for example, AI doesn't count well. Polygraph testing has its idiosyncrasies, but these are known idiosyncrasies. And if combined with a lot of these other investigative techniques that you've described here, I am sure we can get to some ground where it represents value and not that it's just to be completely discarded. It is key also that there are multiple factors that influence the accuracy of these tests. Some of them you've stated, both of you colleagues have stated that. And because these factors can influence accuracy, it is important that those things be kept to the highest standards. What are we talking about? The examiner's role. Well, the examiner is the key man. Skill and experience of the polygraph examiner are crucial to the accuracy. Well-trained and experienced examiner interpret polygraph data more accurately and help minimize the same things, false positives, false negatives, again from the National Academy of Sciences in 2013. Test conditions are key. Put them in the wrong type of environment, you can't get what you want. So the environment and the conditions under which the polygraph is administered. Notice the difference between field and lab. So if you could get it in the ideal environment, your chances of getting the information in the clearest way is important because it tends to create stress-free environments and yields more accurate results. Again, this is according to Nelson et al. In 2011. Subject influences, things again. Senator Vieira identified things, anxiety, etc. These are things that will influence it. The types of questions that are asked are things that will influence it. All of these things have to be taken into account and will be addressed. I'm sure as the went past, of course, when they start to implement these things, because of the stringent controls that are required, in the way in which polygraphs are administered generally, and of course this will be done under the guidance of experts, you would expect that all of these factors, because they are known, will be considered and addressed as we go ahead. The other thing, of course, is that this technology is not stagnant. If you go from the early beginnings when you started it to where it is now, there have been significant advances and changes into where it is. It is a lot more precise a science it is now, for whatever that's worth, than what it was 10 years ago, or 15 years ago, or 20 years ago, going all the way back to when it's done. As we would expect, there would be supportive and critical views, but ultimately, there are some summary and key statistics that I think we should be aware of. The American Polygraph Institute, again, indicated that the meta-analysis of various polygraph studies reported an overall accuracy of around 87%. And the APA advocates for the proper use and interpretation of polygraph results when ethical and legal frameworks are put together, like we are trying to put together today. So in isolation, when put into a framework such as what we're proposing in this bill, that is when these things come to work. I have the list of references, and I will, for the purposes of to ensure that people will understand I wasn't just making this up, I will distribute it so that we can all have it, and you'll see all of the references. There are actually as many as 13 references included in the information that I just gave. So I'm not saying it to say that polygraphing is an absolute science, certainly far from that. I am saying that there is evidence that it can be fairly accurate, and there are things that it's good at and things that it's not that good at. But in combination with the other things that we have, some of the other investigative techniques, some of the fact that the framework itself is being put in considering that these things do exist, and it's not a precise science. Its combination with drug testing and its combination with biometrics all give us, I think, the best chance to get as close to the truth as we can using the technology that we have here. There are some other things I wanted to address. One of them deals with, and it was quickly mentioned because this is not a debate on that, on the Protection Act. It was Senator Lutchmedial-Ramdial that spoke about that and the Data Protection Act. I had given a commitment in this chamber, which I will stand by, to produce and have and ensure that I bring the necessary here to allow for the Data Protection Act to be proclaimed in the time frame in which I specified. I will not renege on that. That promise was given, and we will make sure that that happens. In the meantime, though, it is important to note that a lot of the information contained, drug tests and so on, are covered under proclaimed parts of the Data Protection Act in terms of the high levels of confidentiality and otherwise. So it is not that in the absence of the unproclaimed parts of it that we are left wide open. There are components of this, and again, in that debate, those things were addressed. But my commitment to you today is that the commitment I gave then, I hold to, and I will certainly ensure that we get to that place as quickly as we can. There are also a couple other things that I want to talk about in this. I know the data privacy considerations are also a key component of it, where things are going to be stored, how secure they're going to be, where they're going to be housed, etc., etc. These things represent significant parts of what has to be addressed at the Within the infrastructure that is going to be there, the Ministry of Digital Transformation continues to build and build out some of the technology that we have to put those things into the most secure environment that we can. Our cybersecurity components for this are also critically important. There are new cyber threat actors coming out every day. I had a briefing only yesterday with some new guys on the block. They're extremely good. I think they seem to have replaced Lockbit as the #1 guys on the block in terms of breaking into and hacking your services. We have to continue to be vigilant where that is concerned, and this type of information represents the type of information that people would love to get their hands on. So these things have to be kept in the most secure environments, and not just secure from the point of view from other people getting to them, but secure from the point of view of making sure you could get to them when you need it. Because the work that is happening now in the cyberspace is not only about stealing your information, but locking you out from getting to it. We have to make sure that those things are there, and again, consideration for that will be handled as the infrastructure is put in place, and we go ahead with where we're going. The last thing I want to address here is that we have to remember that this is not the only component of this journey that we're on. You know, there are a number of general thematic areas that the Prime Minister would have spoken about when he did his New Year's message. There were 5 of them, but the one that is relevant to what we're dealing with now is item 3. And it speaks to a renewed attempt at parliamentary intervention in the support and the work of the agencies and institutions, and this is in the support of the fight against crime. This represents another one of those interventions that we're doing to get us to the point where we have legislation to support the efforts that are required to reduce what is a significant piece of what we're dealing with is crime. I am not going to get into the benefits of all the things we have. I think people are well aware of what those are. But I really just wanted to make that brief intervention to get to the point where the technology is understood to a point and backed up by the science. And while not being 100% where we want it to be, I think we can rely on it when put into the right environment and used in conjunction with all of the other techniques that we have. I support this bill. I think it is key and important for us as we progress and we move to becoming a more digital nation. I think, and would implore all of you, all of my colleagues here to support this bill. I think it is worthy of your support, and I think the results coming out from this over time will bear fruit that we would have done something really good today should we show unanimous and general support for this bill. With those few words, Mr. Vice President, I thank you.
Senator Bacchus, I'd just like to put on record my apologies for not addressing you by your proper title. Senator Mark.
Thank you. I thought they were going to forget my colleagues' nomenclature. Thank you, Mr. President, Mr. Vice President, for allowing me the opportunity to intervene and make my contribution to this very important piece of legislation before us in the form of the bill that is before us. Now, Mr. Vice President, it has been said that the road to hell is paved with good intentions. And I think that we can agree on one thing before I get into my contribution in a detailed way, and that is that the government and the opposition have agreed to the legislation. But there are concerns. Not only in this chamber, but outside of these chambers. And I think that the Honorable Minister of National Security, who seemed to be in a generous mood, would want to consider, as we get into the final stages of this debate, some of the concerns that have been expressed, so that at the end of the exercise, Mr. Vice President, we would all be justly proud of the quality of the legislation that would eventually gain passage. So we know what this is about. The minister has outlined it. Some of my colleagues have reiterated some of the key mileposts or objectives or goals of the legislation. What we are seeking to achieve as a civilization, challenged as we are. So it's about security, dealing with crime. And how can we confront this monster? It is also, Mr. President, about public trust, the public interest. And of course, it is about corruption that's like a cancer eating away at this nation in various facets of our nation today. So nobody in this parliament could be against the objectives and the goals, Mr. Vice President, of what we are dealing with here today. But of course, there are concerns, and I think it's only fair that those concerns be looked at and addressed, because there are many people who are not within our environment here in the Parliament who have expressed concerns. Now, the Honourable Minister, when he spoke earlier in his presentation, did indicate, Mr. Vice President, that this has been in the making for some time now. That is the law that is before us. So I was therefore, I don't know if the Minister of National Security, through you, who was a former police officer, was surprised as I am, or I was, when we learned through public statements that the President of the Police Service, Social and Welfare Association, Inspector Gideon Dixon, is on public record as saying that his association, Mr. President, was not consulted. I can't believe that the Minister of National Security, who has a close relationship with his colleagues in the various protective services, would not have been consulted on this measure. And this is why I made the point, Mr. President, that it is useful for the government to pay attention to the concerns of the police officers, because they are very critical for the implementation of this piece of legislation once it is passed. And if they are unhappy with this legislation, you're going to get some resistance on its implementation. In fact, we were told that this said association is examining its legal options. So we don't know if they are going to take it to the courts. We don't know. And that is why, Mr. President, I rose today to ask the government to pay attention to some of the concerns being highlighted in the public space. We know, according to the bill before us, Mr. President, that several acts are being amended. And these various acts that are being amended would have certain bodies fall under their jurisdiction. So like, for instance, when they talk about the Civil Service Act, as an example, where the Board of Inland Revenue would fall. Immigration would also fall, as an example. The Transport Division would also come under. These are areas, Mr. President, that workers and their representatives are located. So again, I asked the Honorable Minister when he's winding up whether he found the time to consult with these various associations, be it police, be it fire, be it prisons, be it the Public Services Association, so that you could get their inputs. So at the end of the day, Mr. President, once you have the inputs of these associations and bodies, the rich outcome can be forecast because they would have had their say in the final product. So I would like to appeal to the Honorable Minister to really pay attention to this aspect of our discussion. And as I'm on this matter, Mr. President, one of the issues that the police are concerned about, and only the government can answer this question, Mr. President, under this matter of polygraph tests, Mr. President, is what would happen to a police officer who has committed no crime, but who, Mr. President, through all kinds of nervousness and anxiety, fails the polygraph test. I don't know if the minister could share with us, when he's winding up, what will happen to that police officer? Is he going to be demoted? Is he going to be removed from the police service? Is he going to be subject to a loss of benefits? We don't know, because we don't have regulations, Mr. President, to guide us on these matters. And it is quite unfortunate, because I would have thought that the Honorable Minister and the government would have at least laid draft regulations simultaneously with the legislation, so that, for instance, both could have been considered at the same time, so that it would have calm the fears of so many persons who are outside of the Senate today. So I would ask the government, to give an undertaking at the end of this debate to have those regulations, which are going to be subject to an affirmative resolution, Mr. President, to be tabled within a very short period of time and have it circulated for public consumption. And I dare ask the Honorable Minister to make sure that those regulations are sent to the Police Service Social and Welfare Association and all their colleagues, prison, fire, the PSA, including Mr. President. Mr. President, we have all agreed, even the Honorable Minister of Digital Transformation has put on the record that in terms of biometric data and the gathering of same, at least there's agreement that there is some degree of greater accuracy that you can extract from that through DNA testing. The drug testing is another area that we know as we speak exists in the police service since 2008, 2009, for incoming recruits. The polygraph is also there for incoming recruits. But those persons who are in the various services captured under the 7 pieces of laws that have been amended, Mr. President, they have been working for 15 years and 20 years, and they have not been subject to these critical tests, polygraph, biometric, and the other one that I mentioned earlier, Mr. President, the drug test. So I think it is concerning to them, and the Parliament of Trinidad and Tobago, the Senate, would need to give these various arms, organs of the protective services and the civil service and the judicial and legal service bodies and the FIU the assurance that there will be fairness in whatever they are being subjected to. And they will not be victimized and discriminated against. We have to ensure that the regulations concretize fairness. I don't want no words from a minister. Words are cheap. We want concrete regulations so that we can give the assurance, Mr. President, to those who are not here and they're concerned. We have to give them the assurance and the undertaking and the commitment that we will protect them as the Parliament, and we will ensure their rights and their freedom and are safeguarded and are not abused by those who might have nefarious intentions, sinister intentions. So that is where, Mr. President, we as a collective can ensure that whatever we do it in the interest of the people of TNT. We must protect their rights, because I listened to my colleague very carefully, the Minister of National Security, and he went through. First time I was shocked when I heard my colleague, Mr. President, detailing all the fundamental rights and freedoms that are being impacted upon by the legislation. He went out of his way to outline them. The right to family life and privacy there too. The protection of the law, Mr. President, that all of us are entitled to. And also equality, equal treatment before the law. These are fundamental human rights that are entrenched under our Constitution. And the policemen out there, and the prison officers out there, and all of those categories, Mr. President, captured in the legislation, they want to ensure that those rights are indeed protected. And Mr. President, I also paid attention to this argument. I think I want to follow in the footsteps of the Minister of National Security and become a lawyer. Because, you know, he taught us, when I say footsteps, I want to be a lawyer.
Okay, but not them.
Yeah, no, well, a lawyer.
Good lawyer.
A good lawyer. But he talked about the whole question about legitimate aim, Mr. President. That is the Suraj judgment out of the Privy Council. Yes, Dominic Suraj. It have Surat and it have Suraj. Yeah, Dominic Suraj. So, Mr. President, what we were told is that there are some principles that can allow a law to be passed without a special constitutional supermajority. That is what we were told. Once the legitimate aim has been established, that's what we were told. Once there is proportionality, and once the policy can be proven to be in the interest of the public, all of these things, when you combine them together, Mr. President, can see that special supermajority going at the wayside, going by the wayside. So I understood that, and I said, boy, well, look, I learned something, boy. These fundamental principles governing the Dominic Suraj ruling in terms of the Privy Council. So we all I'm saying, Mr. President, no, we just want the government to ensure that whatever concerns that have been expressed, Mr. President, by our colleagues out there, we would like the government to pay attention to it. Mr. President, I just want to bring, in closing, I'm not going to take too long. Mr. President, I don't know if you're aware, and the Honorable Minister, but there is a case, there's a case which I would like to draw to the Minister's attention, because he quoted a number of cases. I want to bring one to his attention. It's CV 2023-01042. It is the case, Mr. President, of Christopher Stanislaus versus the Chief of Defense Staff, right? And a court judgment was delivered in this case, Mr. President. And in paragraph 37 of that court judgment or decision, this question of the polygraph came up. And here what the judge had to say in paragraph 37 of that ruling. And I quote, Mr. President, polygraph tests are not foolproof. And factors such as nervousness and anxiety may affect the outcome and lead to a failed result. End of quote. Very short. So, Mr. President, there's case law from our courts in Trinidad and Tobago that is telling us that we have to be very cautious, we have to be very careful in us adopting this methodology, this testing methodology in determining whether someone is being truthful or being untruthful. Because the court is telling us that it is not foolproof or foolproof. Okay? So we need to be conscious of the reality. And there's one final point I want to bring to your attention. In the United Kingdom, Mr. President, there is an act that deals with offenders. I think it's the Offenders Management Act. And they use in the United Kingdom polygraph testing to deal with offenders, those sex predators who have been found guilty. And for some reason, they have to track them when they leave the cells. And every so often, they have to interview them. They use polygraph tests in order to track down sex offenders. Those are people who are guilty, found guilty and convicted of criminal activities. So in the United Kingdom, based on this particular piece of legislation, that is how they use it, Mr. President, to deal with the guilty. In Trinidad and Tobago, I'm a policeman, I'm a prison officer, I'm a member of the Board of Inland Revenue, I'm a law officer, legal officer. I have committed no crime. I'm not guilty of any crime, but I'm being subjected to a polygraph test that can be highly inaccurate. So I'm just saying, Mr. President, that these are matters that we need to pay attention to. We have to address these issues, and the regulations, to my mind, Mr. President, would be the best way of really concretizing these concerns. What we are dealing with here are the bones through the legislation and the provisions that contained therein. What we want would be the meat. And the meat will come, Mr. President, through the substance manifested through the regulations. And I hope, Mr. President, that this limited intervention on this matter would demonstrate the need for us to pay attention to concerns that are being raised outside of our debate here and the support that we are going to extend to the legislation. But we have to pay attention to what others are saying outside here. And I think that we have a duty and a responsibility to address those concerns when the minister is doing his closing remarks or presenting his closing remarks. And more importantly, Mr. President, when those regulations are being tabled for debate in this Parliament. Mr. President, I thank you very much.
Senator Maharaj.
Thank you, Mr. President. I think we can all agree, based on what has been said, that there is consensus on the objectives that this bill pursues. However, what we cannot afford at this time, when we are closing in on about close to 300 murders for the year and numerous other crimes, we cannot afford to give the public something, legislation, that is ineffective, has too many loose ends, because all we will be doing is breeding and deepening the cynicism about legislation. And for that reason, I want to make some suggestions, because we all know the terrible cancer of corruption that is destroying the value that we create every year in the various institutions designed to protect us. We are all aware of it, and that it's spreading, and the consequence is an extent of criminality that we are now beginning to take for granted as that is life. I heard the Minister of Digitalization and Transformation respond to Senator Teemal's four areas for protective, and I think 9 you said you had, or 12. But I think there's more, and I don't think it's just in the science. There are two main themes have emerged here: the reliability of the science and the privacy issues. And I'm afraid that those areas leave so much scope for lawyers to get work. And then we will blame the lawyers who want to pursue this and that. But we have to make it as watertight as we can so that the public will have confidence. And on the side of privacy, I think the minister should deliver on the data protection, the full proclamation. The Office of the Information Commissioner is very serious to giving the public the confidence that that is an office to which people can take their concerns about data protection and privacy. That should be there before we bring laws and have people worrying about the privacy, the trust, the process, the systems. Introduce that office, and you just have until September. You've committed to delivering on the 18-month that I think the Senate gave you last year, March, I think. The reporting I see in the media said September, but 18 months from last March, right? And yes, that will be the budget year. It's just in September. You have the chance to put that critical piece of legislation in place. Assure the public that you are protected. Then the other thing that we must do is ensure the integrity of the process of collecting, storing, using, and disposing of data, and that is the regulations. We don't want to pass law and say, well, the regulations will come and we will deal with that. And we want to give, this Parliament should want to give the public complete protection and information and reason to trust this, and not wait from when the regulations are ready. Prioritize these things. This is an urgent situation. We can't pass a law and tell the public we have this law and then find it's not yet operational. We have enough of that already. So deal with the data protection, create that office, get the regulations. We're talking about the polygraph things. And I heard the Minister of Public Administration say, well, that's just in a case, like we're sending a team of police officers on, a really serious piece of investigative work, and we have some questions and we will just have a polygraph of everybody. That is going to create so many problems if the whistleblowers bill comes into effect. Because what the person who has taken that test and did not pass it, I know that bill has not yet come here, and you can't say, well, we're taking disciplinary action because that is really for your information. But the person says, I was supposed to go on that raid. I was sidelined. I have not been promoted because there are so-called questions over my head. I want to see it. What are you going to say?
because it's going to be challenged for the very reasons that Senator Vieira raised and Senator Teemal. Lawyers, again, are going to get into that and say that is not reliable, and now you have a set of lawsuits. So I don't want to say or repeat what people have said, but the regulations, this piece of legislation, I urge the government and the minister, give yourself and give the public the best chance to get operational, effective legislation in this critical and urgent matter that the country faces. We can't stagger it. We can't say bring the bill and then bring the act and then bring the regulations. That piece of the Data Protection Act will answer the questions that so many people have. Bring it back. Bring it back, September, October. Okay? And with that, I think I've made the few points I'd like to make. Thank you.
Senator Ibrahim.
Thank you, Mr. President, for recognizing me at this time in the debate for the bill at hand. And we all know why we are here and what bill we are commenting on. What I would like to start off by saying, Mr. President, and remind everyone here today in this chamber, is that this bill really points towards the protection and the well-being of the citizens of Trinidad and Tobago. It is a bill brought here which has been passed in the other place with consensus, and not just because the other house has played trump, we expect the opposition to follow suit. Because it does take a certain level of convincing and understanding of the true reason why we are here. Senator Bacchus, Minister of Digital Transformation, did say earlier on in his contribution that it was one of the pillars that was spoken to the public and the general public and the population by the Prime Minister. And that is, and I'm glad that you reminded me about that, and reminded us all about that. And that is for the Parliament to have that core responsibility in passing legislation that serves the people in this aspect. But, Mr. President, many a time we read ad infinitum many things within the editorials, many things within the letters to the editor, and what the people say is what we are trying to answer here. Who polices the police? Who will guard the guards? And that is really one of the core reasons of this legislation. For the first time, collectively, we are seeing a great effort to allow all sides to weigh in on an important matter, to build one of the most important lacking aspects of our community and of our population. And that is the loss of confidence in our institutions, especially as it applies to matters of national security. And as the minister who piloted this bill stated earlier, he says it is a good framework to start upon. This bill speaks to the concept of the maintenance and the reestablishment of integrity of office holders within the security arms of our nation under the Ministry of National Security, to actually come forward and be counted, to stand up and be counted. It speaks to the core of rebuilding trust in the institutions that we depend on to manage our borders, our seas, our air, our first responders, our army, our regiment. It even goes so far to touch on financial institutions in the FIU, which is core to our existence. We have sat here, if you followed the Senate recently, or in the past, or the other place, if you continue to follow it, you would hear argument upon argument upon argument, point being made by the Minister of National Security, points being made by ministers within our presence, that one of the Achilles' heel of progress is corruption. The Achilles' heel of our progress as a nation is corruption. When it is ministries have to spend more than 10% of their time fighting corruption, sometimes it's even 20%, wastage, spoilage, materials going elsewhere. How many people do we know? How many people do we know who get away scot-free per annum in taxation? When are the individuals in this country, the people who we serve, the people outside there, going to actually see us and see government, whoever it may be, as the holders and the vicegerents of their democratic rights, of accountability, of transparency, and of honesty? No system is perfect. The minister said it in his opening statement. No system is perfect. But what we're putting forward here, Mr. President, is actually your best foot forward. And collectively we can do so. When you listen to the Minister of National Security and all the matters that he has responded to over the years, he has always alluded to rogue elements. Always alluded to rogue elements. We know about the bad apple theory. We know about the spoiled fruit theory. But the reality is, what are we doing about that? Yes, we can come now and say, let us hire based upon these processes. Let us stop, reverse, bring it back next term or next session. Formulate certain things before we start. But in an ideal world, we will start over from the very beginning. But at what junction do we start off from that allows us to move forward? What can we do as a collective parliament to allow the nation whom we serve to get that level of confidence in the system that is there to run them? I recognize that one of the sore points of the debate and one of the question marks of the debate is actually, Mr. President, the presence of or the recommendation of this biometric testing, individual biometric testing, the polygraph testing. And let me spend a little time, Mr. President, by trying to explain and understand, for individuals to understand, and if it is that one thing I will contribute to today specifically will be the polygraph testing. This is because, Mr. President, ascertaining an individual's honesty is of great significance, especially in such important fields as national security, judiciary and criminal investigation, security screening, recruitment, and employee theft. For instance, in criminal investigations, Mr. President, if investigating teams fail to establish the truth, It may help several genuine criminals deceive legal systems and escape from punishments, and at the same time, it may force innocent crime suspects to receive punishments if evidence is not in their favor. How many times do we hear that we are going towards, an investigative team is going towards a matter and nobody is caught? How many times have we tried to go into an area where we know we would find an individual and that individual escapes? How? Is it a worm element? Is it a mole element? Is it that we are going to allow the criminal element of our society continue to get the better of us when it is we have the opportunity to put a plug in it, create an environment whereby to work I have to be honest, and to be counted you must stand up with integrity. This is an opportunity that collectively as parliamentarians we cannot miss. Polygraph testing is a solution to this dilemma to a very great extent, Mr. President. They are lie detecting devices that help ascertain individuals' honesty based on physiological indicators. The testing apparatus will have specific devices to record particular physiological indicators, and that is where the gray area lies. That is where the gray area lies, because the basis of my polygraph is not the basis of your polygraph. And for individuals to be subjected to a test, that individual creates their own ground zero line with trained, qualified forensic staff, forensically trained staff. The individual, Senator Bacchus, spoke about it. He spoke about the high levels of accuracy when it comes to coming into, he spoke about all the studies that I have here as well. Those studies indicate there was not a single study that came in under 85 to 88%, controlled or uncontrolled. I don't know about you, but if I score 85% in an examination, I'm pretty happy. However, when it comes to admitting evidence into court, we all know it has its weaknesses. It does have its weaknesses, but we are not saying this is the beyond and end all. We are saying this is a tool in the whole part, a tool of the part. Senator Teemal stated earlier on that he had a good question, and he said, what is going to happen? What is going to happen when it is that individuals are pushed to the side and others come forward within an organization because they did not pass that test? You know what I am fed up of hearing? The good ones say they don't choose me. The honest ones and the diligent workers, they say, I say, why don't you stand up if you speak to an individual? And why don't you stand up, and how come you're not part of this team? They're like, well, you know, they like the people inside there. This is an opportunity for honesty and integrity and hardworking individuals, no matter which part of the society you lie on, no matter which part of the divide you belong to. It gives them an opportunity based on their ability and their natural born integrity. Yes, we can bring in biometric tests for hiring purposes, as the Minister of National Security has said, and he has stated, for the purpose of hiring and part of the screening of the ministry of the top cop position, this is one of the tests that they must go through. And that is great. But the reason why my system and my test and my ground zero is different from your ground zero is that we have to understand physiology. We have to understand physiology and the human anatomy. And if it is we don't take time to understand that, and understand what the basis of the tests are, because it's a physiological test. You have the central nervous system, Mr. President. That is the brain stem, and that's the brain and the spine. And then you have other systems. Dr. Gopeesingh will probably agree with me here. You have the autonomic nervous system, and you have the parasympathetic nervous system. However, what we are talking about here is not the flight and fright and the willingness for me to look at you and point. It is how the human body reacts. And let me break it down for the person on the street. We could be all here playing a nice game of All Fours. But if Senator Roberts is holding a bare jack and he's able to give us his best poker face, trust me, his heart rate, his respiratory rate may be very, very, very different, especially as he knows that his partner holding no face guard. And that is what I can't tell you. You go still pass it. You go figure out a way. But you know what? To pass it, you'll be catching pressure. And that is what it measures, the measurement of catching pressure. Yeah? Yeah. When it is that we establish in a comfortable environment a ground zero for an individual in this testing, and I'm just saying we, not as parliamentarians, but we as a scientists or we as a trained staff, what we're doing is getting a natural reaction of an individual throughout the processes of a normal questioning period. Then we ask, the real questions are asked. That skin galvanic conduction, that heart rate, that breathing is measured upon truth, which is then correlated to the questions that have been asked. It is not a perfect system, but it is a system that is based upon an individual's basis to answer under two different circumstances. And that is what that test is based on. It means that we take and we weigh the regular against the situational.
Right.
I will tell you this. I have been in parts of industries that fell to the same fate that society is falling in. Crookedness. You're getting a salary, but you want something else on the side. And how do you get that something else on the side? You thief and you fight, and you hide. Either you build some hours extra, you help pass a box, you look away when somebody was passing something, which points towards the same situation that Senator Ramdial was speaking about, by association. You've heard it throughout our existence in the recent past. If you know something, say something. If that is not working, you have to find out who knows something. How else are you going to know something if they're not saying something? When will we, as individuals, allow ourselves an opportunity to start in the right direction? Yes, Senator Maharaj, it is a framework legislation. But we've also promised something here that even Senator Mark couldn't quarrel about or oppose. And that is, we're promising affirmative resolution. We're coming back right here when we have to decide what the next step is. We are saying we are equal peers. We're not taking a high-handed approach and stating because we see government be saying that, we are allowing it to be subjected to affirmative resolution for the purpose of the growth of this movement towards attracting integrity and maintaining integrity, honesty, and most of all, what hurts our country is the lack of efficiency because of the above. $14 billion, Minister West, you said we lose per annum. $14 billion in lack of collection of taxes, and probably what we know on the outside is that somebody collects something and they get a certificate. Our country is bleeding. It is hurting. And the long tentacles of those who are persistent upon corruption is reaching further and further into our entire system of governance and our entire system of public sector, of the public sector. And it's sad, because I can't stand up here and I can't be in this house with Mr. President, I can't be here within this body and not speak the truth about what is out there, because at the end of the day, that is what we're here for. And it's an opportunity. Mr. President, last Sunday in a Newsday article, the PCA Director, Police Complaints Authority, Mr. David West, in a Newsday article, calls the passing of the polygraph bill in the lower house a positive step towards rooting out bad eggs in the police service. He even went so far to say that it can lead to a better and more trustworthy service and a more trusting public. It is a start. He went on to say he is not a specialist, but he believes it should be used regularly within the police, and suggested a regular biannual testing for officers. And officers operating in sensitive units should be polygraphed frequently. Retired university, according to the same article, retired UE lecturer Darius Vieira also supported the passage of the bill, but he also believes that it should have been passed many years ago. He created it necessary. He called it a necessary instrument that needs to be used often to understand its effectiveness. But Mr. President, I would like to take the opportunity to make the case that we are not alone on this. Where does the rest of our CARICOM nations and our Caribbean counterparts stand on this matter? So let's look at the application of the polygraph in the Caribbean. It should be noted from the outset that not many countries utilize legislation, Mr. President, for the use of polygraph testing in the civil service, protective services, or any other similar state institution. Most Caribbean Commonwealth countries have implemented policies for polygraph testing. We are going a step further. We are creating legislative framework with guardrails for it, and we are creating regulations for it. Jamaica introduced polygraph screening for police recruits in 2016 in an effort to eliminate police corruption. This was pioneered by Dr. Carl Williams, the Jamaican police commissioner, upon researching the statistics related to crimes committed by police officers. It is the policy of the Jamaican Constabulary Force, the JCF, to polygraph all JCF recruits as well as officers within the force who are seeking promotion, not just entry, who are seeking promotion and assigned to specialized units. Therefore, it is vital for the JCF to have a well-trained and well-staffed polygraph unit, Mr. President, along with a secure space for polygraph examinations to help identify and eliminate potentially unethical recruits and officers. Jamaica's major organized crime and anti-corruption agency, the MOCA, officially opened a polygraph center with funding support from the United States and Canada and the Canadian government. The unit is the first of its kind in the Caribbean, and it is regarded as a center of excellence for polygraph work within the region. Recently, up to last week, we had a visiting delegation from Jamaica who stated the Speaker of the House, Her Excellency Ms. Holiness, the Prime Minister's wife, and in her closing remarks at a dinner we attended last week, she stated that the Parliament of Trinidad and Tobago has offered her so much knowledge and recognized how much less organized they may have been or less advanced that they may have been. But she believes that you do not need to recreate the wheel. Why is it, if it is that we have a polygraph center within one of our CARICOM counterparts, why do we have to worry about costs and how expensive and training when it is we can send certain officers to an off-site, relaxing trip in a different environment to subject themselves to something that is for our benefit? It's something to think about. JCF members are internationally trained and accredited as polygraph examiners by the American Polygraph Association, Mr. President, with reassessment and recertification done annually. These experts in turn have delivered training to law enforcement organizations within our region, including Grenada, Montserrat, St. Lucia, and the US Virgin Islands. Let's shift from Jamaica now and let's go to Barbados. As early as 2010, amidst concern that staff members of the regional security system, a joint mission of the OECS, and see if this sounds familiar, in Barbados were being approached by, and in some cases, cooperating with drug dealers or violent criminals. A decision was made to adopt a polygraph policy. According to all reports, Mr. President, all existing member staff were required to pass polygraph tests before being assigned to special RSS missions, as such persons would have entered their system prior to rigorous testing that was adopted thereafter. It is of due note as well as that in 2014, Barbados hosted a 10-week training course attended by police officers from St. Vincent and the Grenadines, Antigua, Barbuda, Dominica, Grenada, St. Kitts and Nevis, as well as local officers in basic polygraph training. In 2018, the Assistant Commissioner of Police indicated that while polygraph testing were already in use, the frequency of such use would increase because they see the worth in it. Police officers who sought to become detectives in Barbados Criminal Investigation Department, their CID, must undergo polygraph examination. The Assistant Commissioner has also been reported as stating that all officers at some point may undergo a polygraph. You know what? They're moving forward with it, and it is bearing fruit for them. Our even closer counterparts to South America, Guyana. There exists no clear legislative framework for polygraph testing in Guyana, none. However, some of the government departments or agencies subjected to polygraph testing either during the recruitment process or randomly during the span of employment are as follows. See if this sounds familiar. The Guyana Energy Agency, Guyana Customs and Anti-Narcotics Units, Guyana Customs Department, the Guyana Police Force, Mr. President, Guyana Revenue Authority, and the Board of Ichadi-Jagan International Airport and the Guyana Specialized Organized Crime Unit. Polygraph testing was introduced by the then government of Guyana as a way to reduce what? Corruption. In 2015, the Minister of Public Infrastructure stated that he would seek Cabinet's position on polygraph testing after receiving complaints from employees of the Guyana Energy Agency. However, it is uncertain whether such note was brought to Cabinet. Mr. President, I can name a couple more examples, but I would choose to sum it, and I would say that let us not lose the opportunity to gain the trust as an institution of the public by doing what is right. We have an opportunity in front of us that will allow us that would allow us forward motion and a great start towards bringing out the best and letting those who are so inclined by human nature to do otherwise come forth and do what is right. Mr. President, I thank you.
Honorable Senators, 1 second. So before I call on the next speaker, I think at this point in time, it behooves me to say that I've heard quite a bit in relation to polygraph testing, as well as the fact that, we don't have regulations at this point in time. So for all senators wishing to join the debate at this point, we have 10 clauses in the bill. It's quite formulaic, and as much as polygraph testing features in each one of the clauses, I would ask you to focus on the other clauses or other aspects of the bill, as polygraph testing and no regulations would come under tedious repetition in the standing orders at this point in time going forward. Who do I have as the next speaker? Senator Dr. Paul Richards.
Thank you, Mr. President. Wasn't planning to contribute, but given what I've heard so far, I thought it was important to make a short intervention. Mr. President, let me not even be ambivalent about this bill and start by saying I support this bill because even while not diminishing the concerns that have been raised by colleagues in several presentations, because I think the concerns raised are valid and important. And I'll outline in short order, the reasons why I think it's important. Because to me, the most important and significant existential threat and challenge facing Trinidad and Tobago as a country is corruption. Corruption in this country for decades in different incarnation, because it undermines institutions, critical institutions. It undermines functioning of almost every single agency in every single sector, which we've outlined for decades in the first Republican Parliament, the second, third, fourth, fifth, sixth, seventh, eighth, ninth, 10th, 11th, and this 12th Parliament. Because it undermines the functioning of the country. It undermines critically important public trust in institutions. It undermines almost every way of life that we've established as a civilization, as a country, and it facilitates crime. So sometimes we think crime is the biggest challenge, but really it's the corruption leading to the crime and facilitating the crime is the issue in the country, and we haven't been able to, as a country, get to the source of it and curtail it and rally it and bring it under management or minimize it to the point where it's almost irrelevant in the country's conversations. It undermines competitiveness of Trinidad and Tobago as a country. We don't sometimes make these linkages, because when we are focused on finding out where the corruption is, new avenues of corruption arise, because we seem very, very talented and gifted at this for some reason. And of course, we're here debating what is commonly known as the polygraph examination, which is an examination, a psychophysiological detection of deception interview, and testing process encompassing all activities occurring between a polygraph examiner, and this is very important, a polygraph examiner, an examinee, during a series of interactions that include a proper pre-test interview, recording of physiological data, analysis of test data, and the rendering of a professional opinion. All those elements in the definition are very, very important, because the elements in the definition speak to the credibility. If any one of those elements are compromised or broken, we have issues with the validity and the reliability of the outcome. It's an interesting debate, Mr. President, because whereby the bill in the other place received full support from both the government and opposition, we saw another phenomenon of a bill receiving almost with full support also. This is a welcome phenomenon in Trinidad and Tobago's recent history, because the public has been asking for this kind of bipartisan collaboration, actually begging for it in many instances. The population received these developments largely positively because they have to do with keeping us safer in Trinidad and Tobago, in an environment where law-abiding citizens have literally been under siege from the criminal element, who are aided and abetted by public officials who are corrupt. And that is the issue here, because the criminals in many cases cannot operate effectively without the corrupt agents in public positions helping them. They can't operate by themselves. That is why criminality has been expanding and becoming exponential in Trinidad and Tobago, because there's an intricate and intimate interplay between the criminals outside the public service, and sometimes in the private sector, and those carrying the guns outside. And we have to recognize that. There is a symbiotic relationship going on for decades. The population is clearly at a point where, in large regard, it's articulated the need for the employment of different approaches, in some cases controversial, as has been done in other jurisdictions, for the greater good in the public interest. And the public I speak about here is the law-abiding citizens of Trinidad and Tobago, who are by and far and large the majority. But the few miscreants inside and outside the system collaborate to undermine everything. And we have to deal with that. We can't put our heads in the stand and say, well, we have to be careful. And yes, we have to be law-abiding. We can't break the law to bring the criminals in check. But we have to be creative and use legislative measures and strengthen institutions to cut it out. Mr. President, it's rare for government and opposition to agree and come together on principle, policy, and position in critical issues facing Trinidad and Tobago. This is one of the occasions we've seen it happen in the other place, on two recent occasions, which I applaud as a citizen of this country. But like colleagues before, many questions arise, and the questions are valid in many cases. I'm hoping that the minister, in his winding up, can allay some of the fears, the legitimate fears raised, the concerns raised about critical issues related to the operationalization of this, should it become law, should it receive the requisite support here in the upper house. In fact, the mere fact and acknowledgement that this is a supermajority bill, a special majority bill, means we should not take these issues raised lightly. We must examine, interrogate, and scrutinize all implications of the passage of this and operationalization of it, so that, as Senator Maharaj indicated, it achieves its intended objectives without causing harm, without going beyond the ambits of its intention. It's our job to do that. And if it passes, I must suspect it may also be tested in the courts, but so be it. This is how we evolve, and we know if we've stayed the course or we've gone outside, and we will determine that if and when it comes to pass. I also don't think we should take lightly the rare opportunity for the bipartisanship that we've seen in the face of daunting criminality. I stressed it before and I stress it again. It is important to recognize and commend that, because what the public wants to see is more of that in their interest. It does not in any way minimize the seriousness of the Constitution and other controversial issues that have arisen. The support for this kind of measure in the other place, and potentially this place, also speaks to, Mr. President, the failure of present mechanisms and measures to identify and bring to justice corrupt public officers. We've reached here because many of those mechanisms have failed so far. We have to acknowledge that. Otherwise, if those were successful in the way we envisioned when we passed those laws, we would not be here. So we can't keep doing the same thing the same way all the time and expect a different result. We can't. Interestingly enough, we got an example just earlier on today when the Honourable Minister of Finance came to answer a question I had the honour to pose about operations in Customs and Excise. And the Minister identified that a pallet scanner, 20 years old, is non-operational for 10 years. And only now, well, this question was filed by me 3 weeks ago. So I guess they got his Zeppo and they put things in place to fast-track procurement of a new one by coincidence. Oh my God, what a great coincidence. Additionally, I have the honor to sit on the Joint Select Committee, National Security. In the 11th Parliament, we had the opportunity to go to several of the legal ports in Trinidad and Tobago and identified several gaping issues in security. More recently, public officials from the Customs and Excise came before the JSC National Security and identified several other curious occurrences. One, in a container hall much bigger than this Honourable House, a scanner, which is about 4 feet by 6 feet, in one corner of the hole, miraculously, curiously, was the subject of a collision by a forklift, rendering it inoperable. It gets better. In the whole hall, it happened more than once. Coincidence? No, I don't think so. We're not that naive. I asked the Minister, the Honourable Minister of Finance, if he thought it had gone from the realm of incompetence to malfeasance. The Minister deftly evaded that trap. And, sorry,
Senator,
apologies.
As much as you are trying to tie in what you're saying to the bill that's before us, do remember that that part of the proceedings is ended and you're sort of rehashing what was done earlier. So just be very careful how you're repeating what was dealt with earlier in this particular debate.
Thank you, Mr. President. I'm just trying to identify the point of in a critical area like Customs and Excise. We've had instances over decades of clear corruption that has gone unabated, leading to the importation of illegal guns and ammunition, leading to bloodshed on the street. But I'll move on by your guidance, Mr. President. So I'll move directly to the issue of the bill here and the questions that have arisen. Some have identified earlier on, which I think are valid questions. And one of the points that causes me pause is the Section 3. The Judicial and Legal Service Act is amended A by inserting after Section 11 the following new Section 11A, one subject to subsection 2. The head of department may order a law officer to submit to the following: A, polygraph, or any other lie detecting test. Now, you see the word other in its nebulous state is cause for great concern with me, with legislation, because I don't know what other means. And other is a bit too wide. Maybe the minister can identify it. It says polygraph, which I know what it is, because that's identified in scientific literature all over the place. But other lie detecting tests could mean A, you're lying, or what?
It could be the rock.
It could mean anything. And that, would you like me to give you, Minister, or no?
It certainly does not mean a lie. That is precisely what these measures are about. It is to take us away from that kind of whim and unsophisticatedness. In addition to polygraphing, there's the so-called eye detect. They have the eye scan, where they monitor adjustments in the pupils and so on as a way. They have voice stress analysis as two other examples of what is available in the world today. So that's what we mean by other. And we did that because it answers Senator Vieira's question. It's not altogether about polygraphing. It is that and the other technologies as they come along. And they are not to be used as the law stipulates, only one, but it can be a combination of all. Thank you very warmly.
Thank you, Minister, for the clarification. I appreciate that, but I'm still uncomfortable with the word other in lie detection tests because you've clearly identified what is meant by it, but it says other here, which could be interpreted in many different ways by many different people down the road, but I appreciate your responses. The issue of the regulations has been raised, so I'll not burden members with that anymore. The concern about the limit of time for keeping it, who has access to it, who's culpable, which hadn't been raised before. If confidential test results are leaked, who is culpable? Is it the department? Is it the officer who gave the test? And what is the penalty for leaking of such information, which can have deleterious effects on the examinee, and the results, if leaked, may go beyond the intention, the immediate intention or specific intention of the test as administered. And what are the penalties for such breaches? One of the issues I also want to flag is, it has been flagged earlier on, but not in this kind of way. There are third-party contractors who, for example, sensitive information, for example, in the instance of prisons, and a contractor who is contracted to transport prisons inmates who may receive information about the transformation routine of high-risk inmates. And they are not subject, because of the law, like prisons officers, to test to see if they have corrupted the system. And that is a parallel system working there with private and public sector, and the private sector part of it may not be covered by the law, and that may be an area of vulnerability. There's been a lot said about pseudoscience and junk science about polygraph tests. And let me tell you, I had the honor of being trained in psychology, educational psychology, and at one time psychology was a pseudoscience. Okay? At one time psychiatry was a pseudoscience. Now they are subject to rigid scientific processes and boundaries. And if you go through any of the agencies I will identify, you will see the strict measures, processes, interpretations, conditions, training, maintenance, and other mechanisms to ensure the fidelity of the process and the outcome of the results. Now, a lot has been said about the 90% accuracy as opposed to the purposes for which the polygraph tests and other lie detector tests or deception tests are identified as being the object of. But I'll tell you, in social sciences and other sciences, there is the issue of reliability coefficient, which in some cases, depending on the purposes for which the test is conducted, allows for, if it's a 0.5, something that's called an alpha coefficient, allows for a 5% error or potential chance as opposed to a convincing result. Or if it's for a higher stakes examination that may cause harm, they may go to 0.01, which is a 1% potential for error, which is acceptable in the scientific realm. Because of the issues related to human psychology and all the variables that may be taken into consideration when you're testing aspects of human mind, and certainly lie detector tests involves processes involved in the human mind and how it operates. In the Journal of American Academy of Psychiatry and the Law, in an article by Don Grubin, December 2010, under the title Polygraph Accuracy, and I quote, there are numerous studies of polygraph accuracy, some based on, and this is in a recognized, credible journal of psychiatry. There have been numerous studies on polygraph accuracy, some based on lab designs, some based on mock crimes and simulations, others on reviews of its use in field settings. Reports of accuracy range from around chance to near 100% in some cases. However, a thorough and definitive review of the research literature carried out by a committee of the National Research Council concluded polygraph accuracy in the region of 81 to 91% generally, which the reviewers described as well above chance, although considered also well below perfection. You'll never get a perfect score, hardly ever, in social sciences. Therefore, it appears to be a meaningful association between what the polygraph records and deception. In other words, it adds credence to the science, or some to the pseudoscience. I don't agree with that. The National Research Council reviews was triggered by a major security breach at the Los Alamos laboratories that was focused on the use of polygraphy for the purpose of security vetting. Sound familiar? In other words, to detect security lapses, intentional or otherwise, and to catch spies. So that's one. Among the issues also raised earlier, Mr. President, through you, are the top 10 accurate standards of polygraph examination, which I hope the Minister can speak to in his wrap-up, because I think it's important for us to know or to feel comforted in the fact that the service providers for this new approach in Trinidad and Tobago meet muster globally in terms of international best practice, because it is not as used by the FBI, as a speaker before said. It is used in some aspects of the CIA, which are highly respected international security agencies, depending on what it's used for. So the top 10 accurate standards of polygraph examination: 1, proper examination, training and certification, the use of validated techniques and question formats, pretest procedures, calibration and maintenance of equipment, which we are abysmal at in Trinidad and Tobago. Standardized scoring systems, post-test analysis, continuous education and professional development, ethical standards and practices, peer review and quality control. One of the concerns also that arises in this is the test that is chosen, or the mechanisms, or the company that is chosen to provide the services, should this bill pass and become law, is the issue of whether or not the particular test chosen is normed for populations like Trinidad and Tobago. And very often we take it for granted, well, all populations are the same, and they're not. We're culturally different than North America or Europe or Australia. And tests that prove accurate in those jurisdictions, because of the cultural and social differences, may have huge errors in Trinidad and Tobago. We have to be sure that the test that we're using here, that is chosen for here, are normed for this kind of population, are normed for the variety of our population, because our population is not a homogeneous population, are normed for the conditions in Trinidad and Tobago, are normed for the socio-cultural variables in Trinidad and Tobago, because all of these factors will lead to either, if they're not considered, accuracy or inaccuracy. And if we do not have these considerations under check in the choice and application of these tests, should it become law, it will just simply lead to a further erosion of public trust. And that will be counterintuitive to what we're trying to achieve. There are several established standards. ASTM standards, E1954, Practice of Conduct Research in Psychophysiological Detection of Deception, E2000, Guide for Minimum Basic Polygraph Testing and Education, E2063, Calibration and Functionality Checks Used in Forensic Psychophysiology Detection of Deception Polygraph Examination, E2439, Instrumentation, Sensors and Operating Software Used in Forensic Psychophysiological Detection of Deception. Examinations, E2229, Interpretation of Psychophysiological Detection of Deception, E2062, PDD, Examination Standards of Practice, E2031, Quality Control of Psychophysiological Detection of Deception. And that's just a sample of what I could go on and on about the global standards established for this type of paradigm. And I could go on and on. There are global agencies and institutions, too numerous to mention, that specialize in this. The location and test condition, and I mentioned norming earlier on. We don't develop these tests, so we certainly have to get them from somewhere. And we're hoping that that can be clarified. if they've been known in primarily Caucasian populations and not known for minority and culturally diverse populations, it can lead to error readings and diminish public trust in the process. So, and finally, we also, as one of the speakers indicated before, even though, as I said before, I'm not going to be ambiguous about this, I support this, be mindful of the fact that it is important to consult with the persons who are going to be most effective. And I'll tell you why. And I'm hoping the minister takes some time in his wrap-up to identify clearly what this is to be used for. And it's not to be used for promotion, expulsion, discipline, but although it's to be used, and I'm paraphrasing here, for a kind of screening process, the implications of that are, well, I hear you failed the polygraph test. How is that going to impact, if at all, my future chances for promotion, how I am viewed by the organization, and all of those parallel situations that may arise, even if there's not an overt leak. Because we have a way in Trinidad and Tobago of having great intentions and poor systems of protecting people's information in terms of these kinds of situations. And if that is not considered in terms of the collaboration with the 7 or 8 sectors that are to be impacted by this legislation, and understand their considerations and concerns, because they have a right to have those concerns, because this will change the way they do business. This will change the potential implications on their jobs in some way or another. And they need to be comforted so that they can participate fully in this, in the interest of all of us, all the country. So, in closing, Mr. President, I support this legislation. I endorse a clarity and understanding, hopefully from the Minister in his wrap-up, of the concerns raised, because I think many of them are valid concerns, particularly going into a new paradigm that is controversial in many ways in different parts of the world where it has been applied for decades. And I think this is one of the ways we can move a little bit further in curtailing, if not eliminating, corruption, which I started this presentation by saying is the biggest challenge, existential challenge facing Trinidad and Tobago and our future as a country. With those few words, Mr. President, I thank you.
Leader of Government Business.
Thank you, Mr. President, for recognizing me. Mr. President, it's well into the evening, but I thought it necessary at this point to make a brief contribution, particularly having listened to a number of the distinguished contributions from the upper bench comprised of independent senators in this chamber. Mr. President, I was involved in an emergency meeting of CARICOM heads of government this morning virtually in response to the hurricane that has affected several of our islands. And a point was made during that meeting that the people in our region need hope. People in our region need hope. That was one of the points that was made. And Mr. President, I just want to say in the context of this bill and in this debate, an element of hope was introduced to this society. The decision by the Minister of National Security and the Cabinet to bring forward this important piece of legislation, and fundamentally, in the other place, the reality that struck the citizens of this country was that this is a matter in the Chamber of Representatives that attracted, I wouldn't say unprecedented, but very unusual in our political context, the unanimous support of politicians across the political spectrum in Trinidad and Tobago. So I just want to underscore that reality and the fact that some hope was provided, at least in the context of certain crimes and certain threats to our welfare or well-being or security as citizens of this great nation of Trinidad and Tobago. We can find some area of consensus. Mr. President, I think that is a very important reality. Now, that is not a carte blanche. That is not an obligation of anyone in another chamber. You are not obliged to follow suit. But I just want to say it would be a pity if we here would retract or withdraw that hope from the citizens of our country. So I listened very, very closely, Mr. President, to all of the contributions that have been made. I think Senator Mark broke a record of his own in that he didn't even speak for half an hour. I certainly will want to take a good example from him this evening in so doing. But I think even opposition senators felt a little bit constrained, not just by what happened in the other chamber, but by the reality of Trinidad and Tobago. And people really want action. There's that call, and we see it in the editorials, we see it on the call-in programs, letters to the editor. What is Parliament doing about our society? What are our lawmakers doing? We have an opportunity today, Mr. President, to actually do something that can alter, maybe not completely, but alter the reality of our crime and security situation. An additional tool, already deployed in certain circumstances, an additional tool is being extended to other sensitive areas of interface between citizen, office holder, and the potential for crime and corruption. So that's how I read it, Mr. President. Some may say that that's a simplistic gauge, but I think we are in a fundamental crossroads in our country. There's a call for answers. There's a call for response from the Parliament. Some people seem to feel that the Parliament has all the answers. I don't think so at all. But where you have the opportunity to make a difference, you also have the responsibility to act. Mr. President, so I'm speaking to some of the independents in particular, but to the wider chamber and beyond. So we're talking about, there didn't seem to be much dispute about drug testing, etc. But this whole issue of polygraph, and I think Senator Richards really crystallized it. This might be a bit more novel, a little newer in our contemplation, and therefore there is a greater sense of hesitancy on that aspect of the bill. Do we want to take polygraph testing further into other elements of our service? But Mr. President, the point has been made, certainly within the Caribbean context, Jamaica and elsewhere, but even in the United States of America, our major external security partner, and I don't think I'm exaggerating there, polygraph testing in the federal sector is no longer considered controversial. In the private sector, in employer screening people, hooking them up to a lie detector test, no, that is actively discouraged by legislation. But in the federal system, such as, I'll give a few very quick examples, Mr. President, the U.S. Customs and Border Protection Agency. You're not going to go in there and put on that badge or that uniform unless you submit to a polygraph test and unless you can satisfy you can pass such a test. That's the aerospace defense companies, Lockheed Martin and so on, where you're dealing with sensitive, I'm using the language from the bill, secret, confidential information that can be accessed or processed or stored or misappropriated. Those are the circumstances where this is applied. Raytheon and those other technology companies where it's very sensitive. The Nuclear Regulatory Commission, you cannot work there unless you are submit to polygraph testing or subject to polygraph testing. The DEA, the Drug Enforcement Agency, I don't want to quote any of the old songs some of the young people used to sing back in the day to the Minister of National Security, but the DEA, it's fundamental now, it's accepted, and it's no longer deemed controversial. That's just par for the course now to serve in any of these federal agencies, the Department of Defense, the CIA, the NSA, across, I could keep you, the FBI, the district attorney's offices even, polygraph testing is applied. Parole and probation officers, sensitive aspects of the administration of that major security partner. And Mr. President, a point was made, and I always pay very close attention to the submissions of Senator Anthony Vieira. A point was made, and one of the UNC senators said something similar. This is not perfect. It's not a perfect test. It's not a perfect measure. There is room for error. You can have false negatives, you can have false positives. But as a former public health practitioner, I have to ask the question, what is? What is? What is a perfect test? What is a perfect measure? We interview persons routinely for employment. Every single senator would have conducted job interviews and screened persons, some more than others. Is that a perfect assay or measure? It certainly isn't. But does that mean we discard it? Does that mean we deny ourselves the application of such an approach in conjunction with other facilities? And the question is, we certainly would not deny ourselves. Which test is perfect? Pregnancy test. We have a distinguished OBGYN who taught me in medical school. Great teacher. Thank you for the compliment. A pregnancy test. Notorious for false positives, yes, and false negatives. Does that mean we deny ourselves? It's fundamental. The first thing you get when you walk through his office might be a pregnancy test in certain circumstances, notwithstanding the fact that it is not a perfect test. An HIV test, Senator Dillon-Remy would have conducted many of those in her practice. I, given my own background in public health, well, I did a lot of work in that field, and when someone tests positive, the first thing they come with is, I feel it's a false positive, and you have to counsel around that. So, by definition, these are not perfect measures or assays. Does that mean that they do not have value in the practice or in the field? I say not. A breathalyzer test, I'm not going to get into the law around that. Mr. President, even on your phone, you have a fingerprint to get into your phone now, those who are concerned about access to the phone. Sometimes you have to press and press again and press again because it is not, it is not perfect. It is not perfect, and sometimes it depends on the measurer. Sometimes it depends on the phone itself, the application you use. And sometimes you get locked out of your own phone. I heard it has happened from time to time. So if what we are pursuing, Senator Maharaj and others, is perfection before we can act, the truth is we will never act. We are called upon to act. We are called upon to act. We are called upon to act. Mr. President, none of those examples describe a perfect test. So if the message we are sending to other parliamentarians, and if the message we are sending to the population is that we will not apply this very useful facility to sensitive, particular areas defined in the bill that is before us very clearly, and let me give an example. Let me give an example in the bill. Section, let's go with 29A on page 9 of the bill that has been offered to this House. And this is replicated in many sections of the bill. In the exercise of the powers granted, the Commissioner of Prisons, so in this instance we're talking about the prison division, may order an officer to submit to any or all of the tests referred to in subsection 1, where the officer performs an intelligence or counterintelligence function. Mr. President, the stakes don't get any higher than that. The stakes for a country or a state don't get any higher than that. An officer is assigned to a section, unit, or department where top secret, confidential, or sensitive information is accessed, processed, and stored. The stakes don't get any higher than that. When you have a reality where even prisons officers, especially those who might be high in integrity, sometimes are threatened their very lives. The bar is very high, the stakes are very high here, Mr. President. And so those details and those parameters are pellucidly outlined in the legislation that is before us. This is not a Vicky-Vi approach. And those details and how the polygraph would be applied and in what circumstances are very clearly outlined. Mr. President, the whole point of the matter is that the society, as I said, is calling for answers. We have a very useful but imperfect measure. What do we do with it? I heard one senator say, it's urgent, but we need to wait until maybe October and bring it back with a full suite of the regulations, etc. I understand that sentiment very clearly. And that has been applied, that logic has been applied to many other pieces of legislation. So it's not new. That test is not new. But I would submit if something is urgent, and if we have the opportunity to examine clause by clause in a committee comprised of every single senator, that we not kick this tin down the road beyond the recess, etc., but we take action where action can be taken today. We put our minds together further in the parliamentary process. We take action where it can be taken today, and we treat with it further in the same stages that some may have been hesitant to do, Mr. President. Do we rule it out, or do we establish a framework for it? And I would say the urgency is certainly there. Mr. President, I'm not going to regale the Senate with the stories of my own as a citizen confrontation with official corruption. But I may give one example, and this is something that happened to me. As a young, I purchased my first car as a young man. It was a Nissan Sunny. And I remember driving on Ryson Road, not P10. I remember driving on Ryson Road late one evening. It may have been around 8 o'clock. And a vehicle slammed into my little Sunny, much to my distress. Damaged the vehicle severely. I went to then traffic branch opposite the Central Market to make a report. The other driver turned up. He was driving a brand new Audi vehicle. It turns out he was the son of a very prominent business family in this country. Other witnesses, having seen what happened, turned up at the police station to say that man in the Audi was drag racing for miles coming down that road. And it was in the drag race he hit your car. Extensive report was made. I made the report. Other witnesses made the report. When I went back to the police and I was having a further interface, I realized that the entire complexion of what transpired had changed. There was the issue of missing sections of the diary at that time. I don't know if this has happened to anyone else. And as a young man, Mr. President, I was confronted with a twilight zone. What has happened to me? I want to fast track many years later when I was a medical doctor practicing at our nation's STI clinic in Port of Spain. And at that clinic, we were performing screening tests such as HIV, syphilis, and others. And one of the fundamentals to get into drug rehab, some drug rehab programs, is you submit for a screening test for STIs, sexually transmitted infections. And I saw a gentleman come in. I mean, I'm busy seeing hundreds of patients come in and process for testing. And I said, "Sir, your face is familiar to me. Why are you doing these tests?" He said, "I know who you are. I know who you are." And he said his name, and we went a little further. Mr. President, to make a long story short, it turns out the patient submitting to me for a test, for screening, was the same police officer I had encountered years before. It turns out he was on an addictive substance for years. This is his confession to me in a medical office in our public health system. And he finally, it caught up to him in the end, and he had to go into rehabilitation. And he appeared before me for STI testing. And it turned out that he was manipulated based on his addictive circumstance back then to falsify the proceedings that had occurred to me. Mr. President, this is, I'm telling you, an experience that I had. And that is when I really realized there's a thin line out there, because these are the people we are depending on, and most of them serve with great courage and conviction. Our prisons officers, extreme courage. Our Coast Guard officers, those in our intelligence services, or fire officers with extreme distinction. But you see, when you have that crossing of the line, for whatever reason, we the citizens are so vulnerable. I have given that reality, one, because it's a very personal story, and two, because if there was a facility back then that could have prevented someone like that from entering the service, or allowed those in charge of that service to remove someone who would make our citizenry vulnerable in such a horrible manner, then that facility is something that we should not just dispel based on convenience or any other submission, but pay close attention to. And that, I believe, is part of the persuasion why the population is paying a lot of attention to this polygraph bill and some of the other anti-crime measures. That, I believe, may have contributed, along with other factors, to the unanimous support of politicians who normally disagree on everything in the other chamber. And it is my hope that those considerations would be deemed persuasive in our own contemplation of this bill before the Senate this evening. We have a long list of examples and concerns, but I just want to end where I began. There is a strong call for parliamentarians to take action on crime. That does not mean that parliamentarians must just close their eyes and rubber stamp any measure that the government says is useful. But given what has been put on the public record thus far, given the contributions I've heard to this debate, given the responses that have been generated, and I can say with great confidence that will be generated in the culmination of this conversation, this debate, I am quite confident that the Senate once again will distinguish itself and discharge its responsibility to the citizens of Trinidad and Tobago. Mr. President, we must respond in the pursuit of perfection, or in the pursuit of the perfect, or in the pursuit of a test that is 100% accurate on its own measure. Let us not lose the opportunity to avail or state or services in particular circumstances from a test that is applied routinely elsewhere and can be very useful to Trinidad and Tobago. Mr. President, I thank you.
Minister of National Security.
Thank you very, very much, Mr. President. Mr. President, Senator Richards identified corruption as the major issue facing Trinidad and Tobago. I agreed entirely with him, but I have three, which I rehearse and repeat as regularly as I can so do. First, productivity or the lack thereof. I don't think that this nation has been firing on all cylinders and doing as productively well as we could and should do. Right behind that, I have corruption. And then right after that, good old Trini Bacchanal, because you would not be surprised if I tell you, Mr. President, Bacchanal interferes with a lot of good things in Trinidad and Tobago. So I agree with the Senator. We are speaking for the last few hours, Mr. President, on the business of truth. And one of the means that we try to measure truth. So I feel too that I will continue to speak truthfully. In which regard, Mr. President, I would identify, following on my colleague, my friend, the leader of the government's business here, that there are three features about the debate that I participated in and experienced in this chamber here today that I should, for a long time, recall with great favor. We are discussing crime, and I think the context and the quality of the discussion and the range of the discussion demonstrates to anyone listening or looking that dealing with crime in Trinidad and Tobago is no light switch. It's crime we're talking about here, you know. But we got to Japan, to America, to Polygraphing Association, all psychology, sociology, demonstrating that this is a complex issue. So about crime, we went far today and wide. Constitutional issues, legal issues, tout bagay. Permit me a colloquialism. The other feature of this discussion today that will stand out for me is that it was not rancorous. I thought the discussion was soft and gentle and beautiful. Not that I'm accustomed to that, because in the other place, it gets a little hotter than that. But the discussion was very, very, very mellow. And I hope I mellowed into it. But the third feature is that the discussions, the contributions were all genuinely illuminating. I really, and to share my colleagues, the leader of government business, his sentiment, I think, I myself, I learned a lot today. And as well, it lifted my spirit. Every time I feel like losing faith in all of us, something happens. And you see the debate today, it really, really lifted my soul and my spirit. Very, very beautiful. Very beautiful. A friend of mine, an attorney at law, former Commissioner of Police, James Filbert, told me about a month ago. He ran into a potential investor in Trinidad and Tobago, a man who was considering doing some investment in the country. And the man told him he would not do it. And when he inquired of the man as to why, the man told him because from all that he has seen and all that he has heard, and by the way, he went and checked with the Department of Commerce in the country from where he came to get feedback on this jurisdiction. So everything that we say in the parliament, everything that is written, it's all recorded and sent to certain locations. And when investors are thinking about coming, they go there, they are obliged to go there and see where the country and where they want to invest, and they come to their opinions. The man tell him this place is very corrupt. And where there's a lot of corruption, there's a lot of crime. I can't argue with that. I find that compelling. So in that sense, I entirely agree with Senator Richards as well. Senator Richards in passing found it strange that only recently the Ministry of Finance would begin the procurement of some scanners and so on. I was on the Joint Select Committee with Senator Richards. I was one of the party that toured all of our legal ports of entry, and we issued a report to the Parliament. So I became familiar with some of those issues a long time before I became Minister of National Security. So by the time I went in as Minister of National Security, I must admit I went with a predisposition as to the border issues in this country. And with that, Senator Richards, I started to focus on the ports. Inspired by the work you and all of us did in that committee. And I focused on it for the last 3 years in a serious way, and came to discover that the transit sheds, as authorized by the Comptroller of Customs, whoever he or she may be over the years, was one of the spaces of the greatest vulnerability in terms of the importation of all kinds of things, not the least guns and ammunition. And in the focus on that, we found guns after guns, all kinds of things we found. Because now, as Minister of National Security, I was dealing with responding to it. And as a context, in the context of that, we recognized that they operated without scanners. It was a free-for-all for decades. And you would have seen reports of gun finds here and there in these transit sheds. Anyway, the upshot of that is that 2 have been shut down. And the fight continues. So, Senator Richards, in truth, light attracts light. In the spirit of truth, I must tell you, the procurement of the scanners had begun a long time before the last few weeks, and it's not really the coincidence that it appears to be. And Senator Richards and others asked, what does the word other mean in the context of lie detector tests, polygraph, and other? And I did get up, and I am thankful to Senator Richards. He allowed me an opportunity to bring some clarification while he was on his legs. And I also want to say, for us lawyers, we are familiar with the concept of what some call ejus dem generis, but I've heard it pronounced in the place where I studied as eius dem generis, Latin as it is. And it means when, and it is a tool of statutory interpretation, when you say polygraphing and that sort of thing, and you say other, as a tool of statutory interpretation by the judges, by the courts, the word other can only mean of similar ilk, of like that. So therefore, other can't mean you lie. It will mean eye scan, voice stress recording, and the other technologies along that line. So I just pass that as we go. Thank you very, very kindly. And I want to tell a quick story, because Senator Richards, I think it was, wondered, and Senator Vieira, what will happen to the future prospects of an officer who failed a lie detector test? Well, I have to tell you a quick story. That same Mr. Filbert, former commissioner, one day, and he would share this with me, he received a phone call from a criminal in Tobago. Prime Minister shared elements of the story, but he didn't tell you the half, if I may use a colloquialism again. He didn't tell you the half. One day a criminal called him and told him that if he was renting police gun in Tobago, and if he wanted to see the gun, he could come. The commissioner then passed it on to another police officer in Tobago. About 2 months later, the criminal called him again and said the police officer didn't do anything. Maybe a question of productivity, as I submitted a while ago, but nothing happened. Mr. Filbert decided to go in there with himself. He took an assistant commissioner at the time called Mr. Rez, and they went to Tobago. They went and meet the man, and the man showed them a gun. When they examined it, it's a police gun. And the man tell him, well, if you want to really see action, I could call for another one now, and it come in. And so it was. The man make a phone call, and shortly after, another police gun come. Of course, they lock up the policemen involved because the man point them out. They lock up the policemen involved, 2 of them. One is now dead. He committed suicide, I think it was. And the other one retired. And the case still pending. A real story to tell about every aspect of the criminal justice system and why what we're doing here today is so critical and important. But I'll tell you something to answer Senator Vieira's and Senator Richards' question about what happened to the policeman. Following this, the 2 police officers ended up as defendants in the court. And the magistrate, from the reports available to me, I wasn't present. I don't want to fall in trouble with nobody again. But postponing the matter, inexplicably postponing the matter, and things still going on today, you know. But, Mr. President, the 2 police officers in court, and I have to tell you, a police officer appeared as a lawyer for them, and a whole lot of stuff went on. No adverse consequences. Let me shorten this story. The police officer did not have the permission of the commissioner to practice, and that led to another issue in disciplinary proceedings. And that went on, found guilty in the disciplinary proceedings, paid the maximum sentences available in those disciplinary proceedings, 12 days pay, and so on and so on and so on. And that was the extent of it. I don't want to tell this story anymore. But Serious business. Senator Teemal, listen, the quality of the debate around here was very, very inspiring. Senator Teemal raised the question about it not being cheap and the investment, polygraphing, and so on, and we have to make sure we get value for money. That is essentially what he said, but Senator Ibrahim spoke and pointed out a number of very important things about polygraphing in the region, and I'm able to tell Senator Teemal, as I did indicate in my opening comments, that the technology exists, it is used. We have a cadre of trained police officers in Trinidad and Tobago. We have another cadre in the Strategic Services Agency, and they do the polygraphing on behalf of the state wherever it is required. They have the technology, it's in use, and this, as Senator Browne says, is really an extension of that. And I'll tell you, we promised that we will recruit about 1,000 police officers in short order in this country. Several young men and women applied. We came down now, the police service come down now to 1,500 of them, out of which they want to select 1,000. So they're all going to be polygraphed in accordance with existing police regulations. When I, as minister, inquired of the police and the SSA how many of those 1,000 you can reasonably polygraph, because it's a science, as Senator Browne said. And it takes time, and it's and it has some effects on the person administering it, and so on, and so on. They came up to about, I think, 700 in the time frame we're looking at. And as a result, we reached out to our colleagues in Jamaica who sent a team of Jamaican polygraphers here about a month ago. And they joined their counterparts in Trinidad, and they carried on doing some polygraphing for 3 weeks. And when they were professionally considered saturated, they left Trinidad, went back to Jamaica, and another team came to replace them. They are here now carrying on this very scientific and important work as we speak, in our collaboration with Jamaica. And they came out of the same institution, MOCA, the major organized crime and agency. And to them we are more than thankful. I only say all of that to let us know that this is an existing science, the technology is already in place, and Senator Teemal, we are getting value for money, and we'll continue to do that. It's a good way to go. Thank you very much for the observation. So we have several officers trained, equipment already in use, and they belong to professional organizations. Several speakers here today identified Senator Richards, Senator Ibrahim, and others. They are professional organizations of which they are part. And every year, police officers and the SSA personnel, they go on these annual conferences to keep updated and upgraded. It's a very scientific and well-organized situation around the world. They go to the US, some are trained in the US, some are trained in Canada, and so the story goes. Again, I want to emphasize the point that Minister Browne would have made, Senator Browne would have made. The measures in the bill speak not only about polygraphing, but as we established already, other. And in fact, I think it was, yes, Senator Teemal, I want to say the bill, it speaks to a combination of all of that. I responded to that earlier. And it will not be possible for one to selectively choose who to polygraph on the basis of malice or ill will or whim. And if you do it, you'll be exposing your court yourself to legal issues. Teemal, I'm so sorry about that. Thank you very much. Honorable Senator Teemal. I'm sorry. It will not be a question of whim, Mr. President, because as Minister Browne began to read, and I can read all of it, it's written in...
Minister of Foreign and CARICOM Affairs.
Yeah. Honorable Senator, it is all stipulated in there, the circumstances under which the head of the department can ask someone to be polygraphed. I don't think I need to detain us reading it. The Minister of Foreign and CARICOM Affairs, he did that. he would have read, well, let me, clause 3A, where we are adding a new 11A, and it speaks of, in sub 2, in the exercise of the power granted under subsection 1, the head of department, be it the chief fire officer, the comptroller of customs, the commissioner of police, and the rest, may order a law officer to submit to any or all of the tests or collection of information in subsection 1 where the law officer performs any intelligence or counterintelligence functions. The law officer is assigned to a section, unit, department, or division where the top secret information is used, where the law officer is part of or involved in an ongoing investigation involving economic laws such as theft, embezzlement, misappropriation, serious or complex fraud, or an act of sabotage or espionage or money laundering, where the law officer, I'm reading again, where the law officer has had access to property information or files that is the subject of an investigation, and where there is reasonable grounds to believe that the law officer was involved in a serious incident under investigation, where there is reasonable grounds to believe that the law officer is suspected of or involved in misconduct in relation to an ongoing investigation by law enforcement into the commission of a serious criminal offense, where the duties performed by the law officer in relation to his office, post, or activities involves having access to or dealing with top secret, confidential, sensitive information, and where the law officer is in proximity to someone charged for offenses under the Dangerous Drugs Act, the Proceeds of Crime Act, the Anti-Terrorism and the Trafficking in Persons Act, and the Anti-Gang Act. All of these are the ring fencing as to when the head is authorized lawfully, Mr. President, to ask someone to be subjected to testing. And if it is done whimsically and outside of this, the concept of judicial review would loom large. Any attorney at law, any aggrieved person will take this matter to the court and say, look here, the head of the department is acting ultra vires, outside of the law. And the head will be asked to show how did you fall inside, and if not, it will be struck out by the courts. Or if the head was acting in what we call Wednesbury principle on reasonableness, and all of the other grounds for judicial review that are now well known, well established to the court. So it cannot be that some head will just, because he doesn't like someone, or whimsically, as I said, Senator Teemal and honorable members, just send someone off to it. So that takes care of that valid consideration. I said to one of my colleagues earlier as we went through today's exercise, human beings are always assessing / judging each other. Parents are assessing their children, husbands, wives, husbands, business partners, co-workers. It's a very human thing. People are always assessing. I'm speaking here now. Members of this house must be assessing whether I'm speaking truthfully. And this is how this thing goes. So as was said several times in this debate, it's not going to be by whim. It can't be, I feel a lion. It can't be good enough to do that. So we are going to be using the best technology available to assist us in measuring that, one or all of them, or any combination. And that's all this is about, because seniors want to know that they're juniors, juniors want to know that they're seniors, co-workers want to know that the man watching your back, the man who is sharing this information, the man who is going to be allowed into the room to listen to sensitive information, to see sensitive documents, to know things you really want to know, it doesn't slip. That's how this thing works. And someone asks again, if a test fails, what happens? But I was about to give you the full detail of the story, but the bottom line is nothing. Fella still competed for the position of Commissioner of Police and was very high. So the plan here is not unlike Japan. Japan uses polygraph for criminal matters in the court. Japan does that. We don't. Among the gangs, they test each other with licks. A youngster who was in a gang told me the other day, they saw him speaking to somebody and they suspected that he was giving information and they beat him. War machines use torture. But when I opened this debate, we spoke about democracy and we spoke about whether it is reasonably justified in a society that has respect for the rights of the individual. And we saw where a judge of the Privy Council equated that concept with modern democratic way of life, civility, civil societies. We can't rely on beating and torture and those things. What civilized societies like the UK, Canada, Japan, Australia, New Zealand, Barbados, Jamaica do is use these methods in order to measure integrity. And that's what we are offering. It's being used now, but we want to put it on sounder, more institutionalized, regulated footing, circumscribed by the law.
1 second. Leader of Government Business.
Mr. President, in accordance with Standing Order 14.5, I beg to move that the Senate do continue to sit until the completion of the business at hand, or 12 a.m., whichever first occurs.
Honourable Senators, the question is that this Senate continue to sit until the completion of the business at hand, or 12 a.m., whichever occurs first. Those in favour say aye. Those against say no. I think the ayes have it. The Senate will continue to sit until the completion of the business at hand, or 12 a.m., whichever comes first. Minister.
Thank you very kindly, Mr. President. So the results and the outcome of this is not for court like Japan and perhaps other countries. This is about access. Restricted access to facilities and highly sensitive and secret information, and managing integrity among employees. In the US, as we would have heard earlier, all of the federal agencies make use of this. In Trinidad and Tobago, in some, it is restricted to evaluating integrity of certain officers, in particular like the police and the Trinidad and Tobago Defense Force. And the idea is to remove rogue officers, officers who will create problems from those environments, and to make our efforts at fighting crime more effective. That's essentially it. Just imagine for a moment, Mr. President, a shooting incident involving members of the Defense Force, or even a container of guns is distributed in a community somewhere along the line, and the fact pattern shows that it came in on the port and somehow or the other it came out unchecked, and an inquiry ensues. Members of this House and the public will want to know, how did that happen? Who did it? And it is in circumstances such as these where you are pursuing the truth, you use these tools to assist in measuring them. Now, of course, in the context of an investigation, in the context of the law, in the context of, say, a police officer, they have regulations, they have the laws, the Trinidad and Tobago, the Police Service Act, they have all the other laws. So investigators are pursuing it. This will not be used in criminal matters. But if, of course, evidence otherwise makes itself available, as happens every day, or if the police officer or the customs officer acts in breach of his regulations, and that is revealed, then disciplinary action will follow. But this will be aside and apart from that, just to put it flatly. So, Mr. President, I did indicate that this is widely used, and we heard so much about that today already. I don't want to belabor the point. I'm just trying to respond to the issues that were raised as we go along. Senator Lutchmedial raised the question of why, she asked, why should lawyers, she could understand everybody else, but why should lawyers be subjected to this? Lawyers who are contracted in or working in these departments that are the focus of this legislation. Minister Browne, Minister of Foreign and CARICOM Affairs, gave an example of a traffic matter, only to discover that the officer was compromised because of his condition, his addiction. And he was rueful at the fact that at that time, perhaps they didn't have these kinds of tools to have assessed that a lot earlier. I trained with a police officer in my batch. We passed out, and the next thing I heard, he was arrested for stealing police kit in the police station, uniform. And it doesn't stop there when you steal police uniform. It's not to give another police who have 10 uniform, you know. It's to give somebody else to look like police to do something more sinister. But when he was arrested and the inquiry went on, it was discovered that he was afflicted by cocaine. My batch. And therefore, Senator Lutchmedial, when persons are afflicted in those circumstances, they are vulnerable and therefore present a great risk to state security and intelligence and all of the portents of those. And lawyers are as human and as vulnerable as anyone, and I'm sure you will agree with me. Yes. So, as a matter of fact, just in passing, Mr. President, when I was a law student in England between the years 1987 and 1993, when I returned home, having done my degree, my master's degree, and was called to the bar in a temple, or middle temple, and of course, I returned home. But during my time there, they conducted a survey of students in London to determine who had the greatest proclivity to criminal conduct. Lawyers won hands down. That's true. Perhaps because they think they know the law and they could find their way through and they could beat the system. There was a survey done which shows that law students had the greatest potential for getting into them kind of trouble. The question of proximity, Senator Lutchmedial raised, and I did say in my opening comments, it has nothing to do with geography. It has nothing to do with familial relationships like mother and daughter, like father and son, like husband and wife. It had nothing to do with that. It has to do, and Senator Lutchmedial will identify with this, I'm sure, in the law of tort, one of the first things we would have learned is about the neighborhood principle, where the question is asked, did you give contemplation? When you were doing what you are about to do, or when you failed to do what you are about to do, how did this affect? How would the reasonable man see what you did or did not do as affecting someone else? And who is my neighbor? My neighbor is those who would have been affected by what I did. It's a civil law concept. Similarly, in the question of proximity here, which excludes familial or geography, doesn't mean because I'm close. No, it has to do with a course of conduct, discernible conduct. and my relationship with the person who is charged on the basis of what I did with him or did not do in relation to the crime for which he is charged. And that is a concept that any court could easily treat with. And I thought Senator Lutchmedial knew that. I think she was just testing. And it is decided by a judicial officer if it gets to that stage on a case-by-case basis, on the basis, of course, the facts as it presents itself, tied in with the context of reasonableness. And of course, Senator Lutchmedial raised the question of regulations, and so too Senator Maharaj. The Minister of Foreign and CARICOM Affairs addressed it. I don't think I have to belabor the point, suggesting that we need to get on now, but I did indicate that the act is going to be proclaimed in clause 2. It makes provision for proclamation, and therefore it will not be proclaimed unless or and until the administrative elements are put in place, and there we go. In addition to that, we have said that the regulations will be passed with an affirmative resolution, meaning it will have to be discussed among us to all of our satisfaction. In addition to that, it is well known that a policy which an administrator will glean from the legislation that he or she administers, or regulations on the basis of that legislation, must be consistent with the law. That's a basic principle. So you can't have regulations that are miles away from the law that it flows from. It must be consistent with the law. And in terms of consultation, I don't want to belabor the point, but it was asked. I took the trouble to get all of the heads and their teams together, and that happened in the month of March, as late as that. Gathered all from the Registrar General's Department, Commissioner of Police and her team, Defense Force and their team, Customs, everyone, tooth bagay, and caused the Law Commission's Senior Counsel, by way of an independent presentation, to present every single clause of this bill and its purport and how it would have impacted on each one of the organizations, the 7 of them. We spent almost the working day. They asked questions. I sat quietly, I listened as the lawyers from the Law Commission's office went through every detail and answered all of their questions to their satisfaction. So much so that every one of them put in writing their appreciation and satisfaction and support and endorsement of this law. And when I laid this bill in the other place, I highlighted that fact. Every one of them speaking on behalf of their organization, not just a section, the whole organization, endorsed the measures that we offer this House today in writing. And those copies can be made available anytime. So, Mr. President, since taking office in 2015, we have done a number of things. Most certainly.
Mr. President, I just want to ask the Honourable Minister whether he took the opportunity to meet with the associations representing the fire, the prisons, the police, and the civil servants. Could you clarify? And the law association.
I did say clearly that I went beyond the association. I dealt with the administration, speaking on behalf of the entire service. You could say that. You calling the police the government? You calling the fire service the government? Of course, they are arms of the executive, but are you saying that? Are you saying that the Board of Inland Revenue and its leadership and the... May I proceed? May I proceed? May I proceed? Thank you.
Proceed, Minister.
Thank you very, very much. You could call it that. I said I spoke to, had this shared with the leaders and their teams representing the entire organization. That's what I said. So I want to repeat, what will come of these tests will not be used in the context of Trinidad and Tobago for the court. Just wanted to repeat that. I was making the point, Mr. President, that we have done a number of things in advancing the frontiers of the state so that we could better protect ourselves against those who are trying to put pain and distress upon us. A number of things. One of the things was the very cataclysmic passage of what we call a JIPA, abolishing the preliminary inquiry, among many other fundamental changes, all with a view of quickening the criminal justice process. We removed cases, traffic matters, small narcotics matters, marijuana in particular, by the thousands from the list that were being clogged in the court. We established a system of penalty points to deal with traffic issues. Took that out of the lists. And all of the little small joint and little roach and little bit of marijuana that the police spend hours in dealing with. As a practicing attorney, every Monday morning, Senator Lutchmedial-Ramdial could bear testimony to this. The courthouse full, because for the weekend, the police were around the place, a joint, a 10-piece, a 20-piece, and all of that. We have said now, under 30 grams, there is no criminal sanction. And we have said up to 60 grams.
Minister, you have 5 more minutes.
It is ticketable. And those are some of the things we have done. We have ensured that there is an increase in the number of Court of Appeal judges, number of puisne judges. We have vacated, the civil courts have vacated the Hall of Justice. They are now comfortably ensconced in the waterfront, making 71 rooms available for criminal matters. We have introduced pre-sentence hearing. We have introduced the plea bargaining legislation. We did a host of things. Mr. President, today we do yet another. And given that the time allotted to me has now expired, I again commend the measures, simple, straightforward, easy to digest, and from the quality of the debate here today, I am satisfied in my intellect, satisfied in my very soul, that every member of this House properly understands the terms of what is before us. And on that basis, I retain my seat, confident that we will get the support of this House to advance the frontiers in our fight against crime, complex and troublesome as it is. Mr. President, with those few words, I beg to move.
Honourable Senators, the question is that a bill entitled An Act to Amend the Judicial and Legal Service Act, Chapter 601, the Prison Service Act, Chapter 1302, the Defence Act, Chapter 1401, the Police Service Act, Chapter 1501, the Civil Service Act, Chapter 2301, the Fire Service Act, Chapter 3550, and the Financial Intelligence Unit of Trinidad and Tobago Act, Chapter 7201, to provide a regulatory framework for polygraph and drug testing and biometric identification for members of the protective services and certain officers in the judicial and legal service and the civil service, and for other related matters be now read a second time. Those in favor say aye. Aye. Those against say no. I think the ayes have it.
A bill entitled An Act to Amend the Judicial and Legal Service Act, Chapter 601, the Prison Service Act, Chapter 1302, the Defense Act, Chapter 1401, the Police Service Act, Chapter 1501, the Civil Service Act, Chapter 2301, the Fire Service Act, Chapter 3550, and the Financial Intelligence Unit of Trinidad and Tobago Act, Chapter 7201, to provide a regulatory framework for polygraph and drug testing and biometric identification for members of the protective services and certain officers in the judicial and legal service and the civil service, and for other related matters.
Minister of National Security.
Thank you very much, Mr. President. Mr. President, in accordance with Standing Order 66-1, I beg to move that the Miscellaneous Provisions Testing and Identification Bill 2022 be committed to a committee of the whole Senate forthwith to be considered clause by clause.
Honourable Senators, the question is that the Miscellaneous Provisions Testing and Identification Bill 2022 be committed to a committee of the whole Senate forthwith to be considered clause by clause. Those in favour say aye. Aye. Those against say no. I think the ayes have it. The Senate shall now go into committee of the whole to consider the bill clause by clause. Okay, Honourable Senators, I have not seen any circulated amendments prior to the commencement of this committee stage, so we will move accordingly. Clerk.
Clauses 1 to 10.
Honourable Senators, the question is that clauses 1 to 10 stand part of the bill. Honourable Senators, the question is that clauses 1 to 10 now stand part of the bill. Those in favour say aye. Aye. Those against say no. I think the ayes have it. Clauses 1 to 10 now stands part of the bill.
The preamble.
Honourable Senators, the question is that the preamble to the bill be approved. Those in favour say aye. Aye. Those against say no. I think the ayes have it. The preamble to the bill is approved. Honourable Senators, the question is that the bill be now reported to the Senate. Those in favour say aye. Aye. Those against say no. I think the ayes have it. The bill will now be reported to the Senate. Minister of National Security.
Thank you very much, Mr. President. Mr. President, I wish to report that the Miscellaneous Provisions Testing and Identification Bill 2022 was considered in Committee of the Whole and approved without amendments. I now beg to move that the Senate agree with the committee's report.
Honourable Senators, the question is that the Senate agree with the committee's report on the Miscellaneous Provisions, Testing and Identification Bill 2022. Those in favour say aye. Aye. Those against say no. I think the ayes have it. Minister of National Security.
Thank you yet again, Mr. President. I beg to move that a bill entitled An Act to Amend the Judicial and Legal Service Act, Chapter 601, the Prison Service Act, Chapter 1302, the Defense Act, Chapter 1401, the Police Service Act, Chapter 1501, the Civil Service Act, Chapter 2301, the Fire Service Act, Chapter 3550, and the Financial Intelligence Unit of Trinidad and Tobago Act, Chapter 7201, to provide a regulatory framework for polygraph and drug testing and biometric identification for members of the protective services and certain offices in the judicial and legal service and the civil service, and for other related matters, be now read a third time and passed.
Honourable Senators, the question is that a bill entitled An Act to Amend the Judicial and Legal Service Act, Chapter 601, the Prison Service Act, Chapter 1302, the Defence Act, Chapter 1401, the Police Service Act, Chapter 1501, the Civil Service Act, Chapter 2301, the Fire Service Act, Chapter 3550, and the Financial Intelligence Unit of Trinidad and Tobago Act, Chapter 7201, to provide a regulatory framework for polygraph and drug testing and biometric identification for members of the protective services and certain offices in the judicial and legal service and the civil service, and for other related matters, be now read a third time and passed. Honourable Senators, this bill requires a special majority. The clerk will now conduct a division.
Dr. Browne?
Yes.
Mr. Armour SC?
Yes.
Ms. Gopeesingh? Yes. Mr. Sinanan? Yes. Mr. Hussain?
Yes.
Ms. West?
Yes.
Mr. Mitchell?
Yes.
Ms. Cox?
Yes.
Mr. Bacchus?
Yes.
Dr. Ibrahim?
Yes.
Mrs. Bisramsingh Suklal?
Yes.
Mr. Sakai?
Yes.
Mrs. Lazama Lise?
Yes.
Mr. Hislop?
Yes.
Ms. London?
Yes.
Mr. Mark?
Instruction?
Ms. John?
Yes.
Mrs. Lutchmedial-Ramdial?
Yes.
Mr. Roberts?
Yes.
Dr. Gopeesingh?
Yes.
Ms. Bisramsingh? Dr. Richards?
Yes.
Mr. Vieira SE?
Yes.
Mr. Teemal?
Yes.
Mrs. Thompson-Ahye?
Yes.
Dr. Dillon-Remy?
Yes.
Professor Hutchinson?
Yes.
Dr. Patasar?
Yes.
Ms. Maharaj?
Yes.
Mr. Francis?
Yes.
Mr. President, the results of the division are 13 senators voting for, 0 senators voting against,
Honourable Senators, the results of the division is as follows. 30 senators voted for, there were 0 votes against and 0 abstentions. As such, the bill has been read a third time. Passed.
A bill entitled An Act to Amend the Judicial and Legal Service Act, Chapter 601, the Prison Service Act, Chapter 1302, the Defense Act, Chapter 1401, the Police Service Act, Chapter 1501, the Civil Service Act, Chapter 2301, the Fire Service Act, Chapter 3550, and the Financial Intelligence Unit of Trinidad and Tobago Act, Chapter 7201, to provide a regulatory framework for polygraph and drug testing and biometric identification for members of the protective services and certain officers in the judicial and legal service and the civil service, and for other related matters.
Attorney General.
Thank you, Mr. President. Mr. President, I beg to move that a bill entitled An Act to Combat Corruption and Other Wrongdoings by Encouraging and Facilitating Disclosures of Improper Conduct in the Public and Private Sector, to protect persons making those disclosures from detrimental action, to regulate the receiving, investigating, or otherwise dealing with disclosures of improper conduct, and to provide for other matters connected therewith, be now read a second time. Mr. President, the bill before us today forms part of an essential mechanism to be utilized to promote transparency, accountability, and integrity to prevent organizational corruption within both the public and private sectors. Following immediately, as I do, on the debate and passage of the bill that we have just debated in this Honorable Senate, it is very significant that I rise to address another very important part of the government's drive to combat corruption in our society, and to borrow from the government leader, the people of Trinidad and Tobago have hope. The need, Mr. President, for legislation such as is proposed by this bill to protect whistleblowers is part of a wider initiative on the international front to combat corruption. This anti-corruption initiative is enshrined in various international legal instruments to which Trinidad and Tobago is a party. This country has signed and ratified two main international conventions on anti-corruption, namely the Organization of American States Inter-American Convention Against Corruption, the OAS Convention, and secondly, the United Nations Convention Against Corruption, the UN Convention. Both conventions, Mr. President, underscore that whistleblowing has been acknowledged on an international level as an anti-corruption tool and is adopted and accepted by this country. And in this regard, Trinidad and Tobago has already implemented various pieces of legislation under both of those conventions, which include the Integrity in Public Life Act, Chapter 22, Number 1, in particular, Section 42A, the Data Protection Act, Chapter 2204, in particular, Section 99, and the Public Procurement and Disposal of Property Act, Number 1 of 2015, in particular, Section 40. Legislation, Mr. President, for overall protection of whistleblowers in both the public and private sectors is, however, necessary, as the current sectoral protection has limitations. For example, whistleblower protection only often applies to certain employees and to the disclosure of only certain types of wrongdoing. We need, Mr. President, a robust regulatory legislated mechanism that can facilitate the reporting of misconduct, fraud, and corruption. Without such legislation to protect persons who report wrongdoing, they are prey to fears and actual acts of retaliation, particularly in a society as small as ours. This erodes the overall anti-corruption machinery which we aim to build. And the risk of corruption, therefore, increases exponentially where reporting is not facilitated or production. The absence of legislative safeguards in that regard can dissuade witnesses to corruption from stepping forward. Briefly, the history of this legislation, Mr. President. In 2015, the Whistleblower Protection Bill 2015 was first introduced at the House of Representatives on November 13, 2015. It was then referred to a joint select committee for evaluation and report. 5 interim reports were produced following stakeholder consultations. Thereafter, the Whistleblower Protection Bill 2018 was introduced on April 9, 2018 at the House of Representatives with the requirement that it be passed then with a special majority. The 2018 bill was defeated on May 6, 2019, introduced again in 2019, this time as a Senate bill. However, that bill lapsed. The Whistleblower Protection Bill 2022 was subsequently introduced in the House of Representatives on January 14, 2022, and that is the bill now before this House. Mr. President, a disservice was done in the other place to our Chief Parliamentary Counsel, Mr. Ian McIntyre, Senior Counsel, which I wish to address and correct for the record. In the course of the earliest iteration, 2015, of this bill, on the 16th of January, an opinion was requested by the Joint Select Committee on that 2015 Whistleblower Protection Bill, which opinion was given by the Chief Parliamentary Counsel. That 2016 opinion of our distinguished Chief Parliamentary Counsel was read out in the other place by a member of the other side, and much was made of the Chief Parliamentary Counsel's advice then in 2016, in effect, to the effect that certain aspects of the 2015 Whistleblower Protection Bill infringe certain fundamental rights, and the bill may not be reasonably justifiable in a democratic society. Mr. President, the decision of the Privy Council in Dominic Suraj and others against the Attorney General, 8 years after the Chief Parliamentary Counsel's opinion, was delivered on the 20th of June 2022. That decision has altered fundamentally the landscape of our constitutional interpretation with respect to, among other things, our constitutional interpretation of the use of a simple or supermajority in legislation passed by our Parliament, as that legislation impacts our guaranteed fundamental rights and freedoms. The long title of the bill, Mr. President, reads very clearly that it is an act to combat corruption and other wrongdoings by encouraging and facilitating disclosures of improper conduct in the public sector and private sector to protect persons making those disclosures from detrimental action, to regulate the receiving, investigating, or otherwise dealing with disclosures of improper conduct, and to provide for other matters connected therewith. The legislative aim, the public interest of this bill before this House today, therefore, to regulate the receiving, investigating, or otherwise dealing with disclosure of improper conduct is consistent with the new interpretation provided by Suraj of the approach to constitutional law, and in particular, the approach to how we deal with simple as opposed to supermajorities. And the opinion of the Chief Parliamentary Counsel given in January of 2016 was premised on a law that was 8 years before Suraj and therefore was correct at the time. Since the delivery of Suraj, I commissioned an opinion from external senior counsel who advised that the 2022 bill, which is before this House, was constitutionally compliant, consistent with the principles developed and settled by Suraj, save only for one vulnerability, which was that in order to meet the Suraj proportionality test, there should be provision in this bill for the establishment of guidelines or procedures on the processing and retention of collected information. I shared that external opinion with Chief Parliamentary Counsel, Mr. McIntyre, Senior Counsel, who then advised, in agreement with the developed 2022 position of Suraj and the opinion of external senior counsel, Mr. McIntyre then advised an amendment to Clause 28 of the bill now before this House, under which the minister may make regulations to ensure that this bill was constitutionally compliant. Accordingly, on the 21st of June 2024, in the other place, we removed the preamble, we removed Clause 3 of the bill and amended Clause 28 to render the bill consistent with and compliant constitutionally in accordance with the decision of Suraj. Mr. President, I turn to the contents of the bill. Clause 3, the interpretation section, the definition and scope of employee. One of the shortcomings of electing to continue with sectoral whistleblowing protection is that it limits the type of person that can be covered by the prescribed protection. In some instances, only state employees are given the protection of that protection is only afforded to persons making certain types of disclosure in respect of specified bodies. In this bill,
This bill seeks to address that by providing a wide definition of employee, a definition which includes persons who are volunteers and independent contractors. The scope of disclosure and improper conduct. Disclosure is defined in the bill as disclosure of information by a person which shows or potentially shows that improper conduct has occurred or is occurring or is likely to occur. Unlike our existing and very limited legislative framework for whistleblowing, the bill does not narrowly define or itemize the types of conduct. Instead, it utilizes the term improper conduct, which is defined in the interpretation section, so that in the interpretation section of this bill, improper conduct means A, criminal offense, B, failure to carry out a legal obligation, C, conduct that is likely to result in a miscarriage of justice, D, conduct that is likely to threaten the health or safety of a person, E, conduct that is likely to threaten or damage the environment, F, conduct that shows gross mismanagement, impropriety, or misconduct in the carrying out of any activity that involves the use of public funds, G, an act of reprisal against or victimization of a whistleblower or person related to or associated with a whistleblower, H, conduct that tends to show unfair discrimination on the basis of gender, race, place of origin, social class, color, religion, or political opinion, or I, willful concealment of any act described in paragraphs A to H foregoing. Clause 6 of the bill, Mr. President, under Part 2, enables an employee or an organization to make a disclosure of improper conduct to a whistleblowing reporting officer or a whistleblowing reports unit. The disclosure must be based on an employee having reasonable grounds to believe that improper conduct has occurred, is occurring, or is likely to occur. Subclause 3 provides that a disclosure may be made either orally or in writing, and subclause 4 provides that oral disclosures must be reduced into writing immediately in the presence of the person making the disclosure and read the written disclosure to the person who made it. Importantly, Mr. President, because there are no sacred cows, Clause 6, subclause 6 says, a disclosure made in relation to a member of Parliament shall not amount to a breach of privilege. Very importantly, under this whistleblowing legislation, there shall be no sacred cows. Clause 7 of the bill specifies the 6 conditions that must be complied with for any disclosure to be protected. These disclosures include A, it is made in accordance with Clause 6, B, it is made in good faith, C, at the time of making the disclosure, the whistleblower reasonably believes the information that he has at the time is substantially true and shows his employer or person working for his employer's behalf engaging in or preparing to engage in improper conduct. Mr. Vice President, a principal requirement in most whistleblower protection legislation is that a disclosure must be made in good faith. The reporting in good faith requirement is intended to prevent the airing of vexatious or harassing disclosures. Clause 8 provides that information disclosed in the course of obtaining legal advice and found to be protected by legal professional privilege is not a protected disclosure. Clause 9. The bill also addresses Clause 9 addresses anonymous disclosures under Clause 9. An anonymous disclosure will not be a protected disclosure. However, if the identity of a person making an anonymous disclosure becomes known, the disclosure shall be deemed to be a protected disclosure as if it had not been made anonymously. In relation to an anonymous disclosure, a whistleblowing reporting officer or whistleblowing reports unit can receive, process, and review an anonymous disclosure to determine whether improper conduct has occurred. However, if after consideration of all relevant circumstances, the information is determined to be defamatory or libelous, then such information shall be rejected and a record kept in the event that the person who disclosed the information becomes known and is liable to criminal or civil proceedings. The proportionality of the Suraj principle, Mr. Vice President, is understood when one looks, and I will come to them in detail, but when one looks at sections 10 to 12, which deals with internal disclosure, and sections 13 to 16, which deal with external disclosure. Because what the bill provides for is a responsible internal mechanism within companies, state organizations, and all of those bodies caught within the schedule, the designated authorities, so that they must establish a controlling, overriding facility by which employees and or other persons as whistleblowers may make reports to reporting units and authorities, and it must be managed properly, so that it must be published. Those internal disclosures must be published so that everybody is aware of it. That goes to the proportionality of this bill, which is ensuring that there is a fair process by which persons can operate and be seen to be operating. So that Clause 10 provides for employers to appoint whistleblowing reporting officers to receive and process internal disclosures of improper conduct within a company or organization. Whistleblowing reporting officers would also determine whether an internal disclosure should be referred to a designated authority or through its whistleblowing reports unit for further investigation. Clause 11 requires an employer to establish and publish operational internal procedures for dealing with disclosure. These internal procedures must identify the whistleblowing reporting officer. This provision to enable that employers publish and republish widely at necessary regular internals is necessary to give effect to this legislation in proportionate terms. Clause 12 provides for a whistleblowing reporting officer within 30 days after receiving an internal disclosure to notify the whistleblower of the status of the disclosure. Clause 13 provides for the setting up of whistleblowing reports unit in all of the designated authorities which are set out in the schedule. Clause 14 provides for an external disclosure to be made to a whistleblowing reports unit in a designated authority, and each designated authority under the relevant part applying to external authorities has to employ a particular procedure. Clause 15 provides that where a whistleblowing reports unit to whom a protected disclosure is made considers that the disclosure can be better processed by another whistleblowing reports unit, that disclosure can be referred. And Clause 16 means that the director of the whistleblowing reports unit shall submit a report to the minister on the activity of the whistleblowing reports unit during the preceding year, and the minister is to lay such reports submitted in the Senate and in the House of Representatives, so that there is an overriding oversight of the operation of this bill. Clauses 17 and 18 provide for the protection of whistleblowers, Mr. Vice President. Clause 17 of the bill safeguards a whistleblower from any detrimental action after making a protected disclosure, despite the existence of any prohibition or restriction on the disclosure of information under any written or rule of law, contract, oath, or practice. Flowing from Clause 17, Clause 18 grants a whistleblower who has made a protected disclosure immunity from all criminal, civil, and disciplinary proceedings. But that immunity shall not be prejudiced where in good faith the whistleblower was mistaken about the importance of the disclosure, the perceived threat to the public interest, and has not materialized, or the whistleblower has not respected the procedural requirements of the Act or its regulations. It must be highlighted, Mr. Vice President, that whilst immunity is provided for in Clause 18, by Clause 19, a whistleblower who is herself or himself a perpetrator or accomplice to the improper conduct which is being disclosed, that person may have initial criminal proceedings initiated against him for that conduct. And the court, in considering mitigating factors, shall consider the disclosure and its value to the investigation. Mr. Vice President, the whistleblower can be subject to civil or disciplinary proceedings for conduct not related to the protected disclosure. In civil proceedings, the whistleblower who has acted as a perpetrator or an accomplice to improper conduct and found liable for this conduct shall pay only part of the damage caused by him. A whistleblower who is a perpetrator or accomplice and is employed by a public body shall not be dismissed and should have his punishment mitigated following disciplinary proceedings. Clause 20, Mr. Vice President. Information which identifies or may lead to the identification of the whistleblower without their consent is prohibited. This is provided for in Clause 20. Part 4 of the Act, I beg your pardon, prescribes for offences. Under Clause 22, there are listed 5 offences: knowingly preventing, restraining or restricting any person from making an internal or external disclosure, knowingly intimidating any person who intends to make an internal or external disclosure or who has made a protected disclosure, and knowingly inducing any person by threats, promises, or otherwise to contravene the Act. These offences carry a penalty on summary conviction, a fine of $15,000 and imprisonment for 2 years, or on conviction on indictment, a fine of $50,000 and imprisonment for 10 years. Under Clause 23, Mr. Vice President, the offence of disclosing the identity and statement or information of a whistleblower by a whistleblower officer or unit carries a penalty on summary conviction of a fine of $600,000 and imprisonment for 2 years. So the units or officers to which the disclosures are made are under penalty of serious fine and imprisonment, sworn to keep that information protected. Under Clause 24, the offence of obstructing a whistleblower reporting officer or director or other officer of whistleblowing reports units in the performance of their duties also carries a penalty on summary conviction to a fine of $15,000 and imprisonment for 2 years. Clause 25 provides for the penalty of destroying, falsifying, or concealing documents relevant to a disclosure, and Clause 26 provides for the effect of conflict between a contract of service and the provisions of the Act. Mr. Vice President, Clause 27 provides that the Minister may amend the schedule subject to affirmative resolution of Parliament. And this takes us to Clause 28, the product of the joint consultation and advice of External Silk and Mr. McIntyre, Chief Parliamentary Counsel, an amendment that was approved in the other place to add Clause 28. And Clause 28 reads, the Minister may make such regulations, A, for the processing of disclosures and other information collected under this Act, B, for the retention of disclosures and other information collected under this Act, C, for ensuring that only information that is relevant and necessary for the purposes of this Act is retained by the Whistleblowing Reports Unit, D, prescribing the length of time during which disclosures and other information collected under this Act may be retained by whistleblowing reporting officers and whistleblowing reports units, E, for the destruction by whistleblowing reporting officers and whistleblowing reports units of information in their possession which is no longer necessary for the purposes of this Act, F, for the conduct of independent reviews of information retained by whistleblowing reporting officers and whistleblowing reports units to ensure compliance with this Act and its regulations, and G, generally for carrying into effect the provisions of this Act. That was the amendment introduced in the other place, which is now part of the bill before this August Senate for approval and passage into law. And may I add, Mr. Vice President, and I have no doubt that this will find favor with Senator Wade Mark on the other side, that Clause 28, Subclause 2, before any amendment was made, provides regulations made under subsection 1 shall be subject to affirmative resolution of Parliament. So that such regulations as are made by the Minister after this bill becomes law will have to be brought to this House, to the other place, and to this chamber for active deliberation and debate. And therefore, the proportionality, and this is the point, the proportionality of this bill in ensuring controls and measures in pursuit of the legitimate aim being the public interest of regulating corrupt activity in this country by giving protection to whistleblowers. The proportionality of this bill is self-evident from the language of the bill even before the advice was received from External Senior Counsel and Mr. McIntyre to introduce the new Clause 28. As I noted in the other place, Mr. Vice President, the collection and storage of information pursuant to this bill must be properly regulated by a fair procedure to prevent disproportionate limitations of rights. And that clause addresses that. So we have, as a result of this legislation, this bill, when it becomes legislation, we will have regard to the statistics of whistleblower disclosures, which have been credited for saving millions in public funds and safeguarding the public good by exposing mismanagement, corruption, illegality, wasteful spending, and violations of civil, human, and constitutional rights. By way of jurisdictional comparison, again, to show the proportionality of this bill, which is before this August Senate, there are numerous Commonwealth countries who have seen it fit to implement whistleblower protection. Whistleblower protection from some of those from other jurisdictions, some of which informed the Law Reform Commission's research and policy advice on this bill, can be found in the United Kingdom, Canada, New Zealand, Malta, Jamaica, Malaysia, Barbados, the Cayman Islands, and Ghana. We have drawn from all of that legislation in the crafting of the bill, which is before this Senate this afternoon. It is hoped that this bill, together with the passage of the Public Procurement and Disposal of Property Act, which was fully proclaimed on April 26, 2023, and aims to reform the procurement laws of Trinidad and Tobago in keeping with the principles of good governance, such as accountability, transparency, integrity, and value for money, can positively affect this country's score on Transparency International's Corruption Perception Index, which is the leading global indicator of public sector corruption, which scores 180 countries. I remind our naysayers, Mr. Vice President, that in its 2023 report, the Corruption Perceptions Index of Transparency International noted that Trinidad and Tobago's score was 42, which means that we ranked 76 out of 180 countries. The level and frequency of corruption in Trinidad and Tobago, as we have spent the entire day today discussing on the other bill, has serious costs and consequences, and it has the ability to poison all spheres of our society in profound ways. Mr. Vice President, this government is committed to fighting against corruption, and our legislative agenda has been hard at work on that. For example, through the numerous pieces of legislation that exist, such as the Miscellaneous Provisions, Trustee Exchequer and Audit Act, the Minister of Finance Incorporation Act, the Proceeds of Crime Act, Income Tax Act, Companies, Partnerships, Securities, Tax Information Agreements, the Non-Profit Organizations, and Mutual Administrative Assistance in Tax Matters Act 2024, which amends several pieces of legislation to create a comprehensive regulatory framework that aims to prevent money laundering by enhancing transparency and accountability, and to facilitate the tracing and verification of beneficial ownership of financial entities. So that this bill will now complement that suite of legislation that already exists, which has been driven by this government in order to ensure that we are working towards a country in which we have corruption under control, and those persons who, on the basis and the platform which this bill will give, are able to report on corruption, likely corruption, in good faith, will have the confidence to be able to make those reports, knowing that their reports will be kept confidential, knowing that their reports will be processed responsibly. There are whistleblowing reports units, whistleblowing reporting officers, and designated authorities who will assist them to process that information, and knowing, most importantly, that the regulatory framework which this legislation, this bill, once it becomes legislation, will put in place, will protect them from victimization and indeed keep them anonymous until such time as they are called on to stand up. The passing of this bill, Mr. Vice President, can only stand to benefit the people of Trinidad and Tobago. It is a key element in the government's anti-corruption drive, and indeed it will place us among the list of countries who have determined that it is necessary at this time to implement whistleblower legislation. And Mr. President, with those few words, I commend this bill and I beg to move. Thank you.
Honourable Senators, I shall now propose the question for debate. The question is that a bill entitled An Act to Combine Corruption and Other Wrongdoings by Encouraging and Facilitating Disclosures of Improper Conduct in the Public and Private Sector to protect persons making those disclosures from detrimental action, to regulate the receiving, investigating, or otherwise dealing with disclosures of improper conduct, and to provide for other matters connected therewith, be now read a second time. Senator Mark.
Thank you, Mr. Vice President. Mr. Vice President, I've listened very carefully to the contribution of the Attorney General as it relates to the bill entitled An Act to Combat Corruption and Other Wrongdoings by encouraging and facilitating disclosures of improper conduct in the public and private sector, and to also protect persons making those disclosures from detrimental action, I beg your pardon, to regulate the receiving, investigating, or otherwise dealing with disclosures of improper conduct, and to provide for other matters connected herewith. Now, Mr. President, Mr. Vice President, I want to say that, like the Attorney General, this bill has gone through several iterations over the last few years, from 2015, 2016 to the present time. But what is extremely noteworthy is that the only two fundamental changes that we have seen to this bill introduced by the Attorney General are the following. One, the Attorney General and his authoritarian regime has scandalously removed the certificate governing the special majority on the basis of the Attorney General indicating he got some so-called senior counsel opinion. He has not provided the Senate. He has not provided this Parliament. He has not provided the country with a copy so disrespectful and contemptuous. Is this Attorney General?
Who is it?
That the Attorney General that is, did not find it necessary to name the senior counsel or even to provide us with a copy of the senior counsel's opinion and advice. Suffice it to say, he simply regurgitated Dominic Suraj, Privy Council, mantra and use proportionality and legitimate aim and public interest to simply throw into the dustbin the people's fundamental rights and freedoms. That is what we have here as a presentation, Mr. President. Mr. President.
A point of order, Standing Order 46-6. I just heard an imputation of a very improper motive against the Attorney General.
Senator Mark, 46-6 upheld. Kindly refrain from such comment.
Mr. President, what we are arguing on this side is the Attorney General of this country has not provided, this Senate with any persuasive or convincing arguments, either from a legal or constitutional perspectives, to convince us that there is no need for a special super majority for this piece of legislation. That is what we are arguing. And I want to say from the very outset that under Section 2 of the supreme law of the land, which is a constitution, it states, and I quote, "The Constitution is the supreme law of Trinidad and Tobago, and any other law that is inconsistent with this Constitution is void to the extent of the inconsistency." Mr. President, the Attorney General went further and utilized the name of the Chief Parliamentary Counsel and indicated that the Chief Parliamentary Counsel, who submitted a legal opinion in January of 2016, has now changed his mind. But we have seen no evidence from Mr. Ian McIntyre to that effect. We have seen no opinion being circulated by the Attorney General in order to justify his statement. So what are we to do? Summon Ian McIntyre to this House and question him? We can't do that. He's a senior public officer. And we respect him. And I want to tell this Honorable Senate that, Mr. President, there are 28 clauses in this bill. And there are some 5 parts, I believe, if I'm not mistaken. And Mr. President, every clause that I saw in 2015 in the whistleblowing protection bill are now contained in the 2022, which is now being debated in 2024 legislation. There has been almost insignificant amendments to regulations. To whom? Who is going to determine in clause 28 under those regulations, those new provisions? The minister The minister who's a member of parliament, and as the Attorney General said, the Honorable Attorney General said, there's no sacred cow. So the minister is not protected by the legislation, yet still the minister has taken the power to determine regulations. So is this a PNM inspired, politically inspired piece of legislation to embark on a political witch hunt against its political opponents? Is that the purpose of the legislation? What's the purpose of this legislation? Mr. President, we on this side dismiss out of hand, we reject completely this so-called proportionality argument that is being spun, that is being spun by the Honorable Attorney General, right? We are very clear in our analysis of this bill that, and we will demonstrate, several clauses of the bill, Mr. President, are completely disproportional. Do not live up to this so-called legitimate aim in terms of the public interest. What we would like to show very early, Mr. President, is that when we look at several clauses in this legislation, and I want to say, Mr. President, we see no reason to deviate from the very solid legal opinion proffered by the distinguished Chief Parliamentary Counsel back in 2016. The same provisions, the same clauses, Mr. President, in the 2015 bill that came without a certificate, that came with a certificate in 2018, 2019, are the same clauses in the 2024 piece of legislation. So, Mr. President, let's look at what is before this Honorable House and Senate. Mr. President, there are several clauses in this bill that we have to look at conjointly to fully appreciate the importance of these provisions, these clauses, as it concerns citizens' fundamental rights and freedoms. Mr. President, I just want you to look at one important clause that I'd like to refer to so you can follow the concerns of the opposition. And I want to tell the Attorney General, as soon as you sign this bill, as soon as the President of the Republic signs this bill, you will meet us in a place that you are familiar with. You will meet us in a place that you are familiar with. that is where you will meet us. Right? So, Mr. President, let's go to clause 18, right, before I deal with other clauses of the bill. Mr. President, go to clause 18 of this bill. What does clause 18.1 says? This government is so intoxicated, inebriated, Mr. President, with this bill, and almost, Mr. President, without flinching, without batting an eyelid, their objective is to give cover and coverage to anyone, including someone who is anonymous. You don't know that person. It could be a PNM agent. You don't know. And Mr. President, that person anonymously can make a disclosure on you, on me, on any citizen, because this bill covers both private and public sector. So whether they work in Ansabakal, in Massey, or in any bank, whether you work, Mr. President, in the public sector, or in a statutory authority or state enterprise, you are covered by this legislation. This legislation reaches 1.4 million people. And those persons who are 18 years and over and working in particular are going to be covered by this legislation because it covers everyone. We must never forget email gate. We must never forget email gate that turned out to be a hoax. And somebody should be serving a jail sentence in this country for impugning the good name of journalists and politicians. But they got away scotch-free. And they have now turned email gate into whistlegate. This is the whistleblowing legislation, Mr. President, that they have brought here today. But let's go to clause 18.1 to understand the gravity of what we are dealing with here. Anyone, Mr. President, according to 18.1, hear what it says. Notwithstanding any other law, but subject to section 19.1, a whistleblower who makes a protected disclosure is not liable to any criminal, civil, or disciplinary proceedings for having made such a disclosure. So, Mr. President, anyone under section 18.1 can make a protected disclosure under the definition improper conduct of anyone in Trinidad and Tobago, including any member of parliament. And that person cannot be challenged in a civil court, cannot be challenged in a court for criminal misconduct. And worse, if he works for an employer and he violates the contractual obligations to which he is obligated to, the employer cannot take disciplinary action against that employee. Because this law gives protection to that whistleblower, Mr. President. Now, the last time I checked, we live in a democracy. The last time I checked, we have a right to go before a court if somebody is trying to impugn my good name. The last time I checked, the highest court is the Privy Council. So how can we put into legislation, Mr. President, that you cannot challenge someone who wrongfully, falsely accuses you or me or anybody of wrongdoing, of corruption, and that person is protected by this piece of legislation? You can't take civil, you can't take criminal, you can't take disciplinary action against that individual. This bill requires almost 2/3 majority, you know. This bill requires almost a 2/3 majority. If you are denying the citizen the right to go to court to defend his or her good name, you should have a 2/3 majority in this legislation.
It should never happen.
No, I'm saying if you want to go that route, you need to have a 2/3 majority. You remove the 3/5. You're now telling Mr. President, others, no right to defend your good name against a whistleblower, a PNM whistleblower, who is set up by the PNM to set you up, and then your name jumping up in a ban. And they're telling you, the PNM is telling you, using the parliament to weaponize legislation, to tell you and me and the citizens of this country, you cannot take the PNM whistleblower to court. You can't mash them up. They can mash you up, but you can't mash them up.
46-6.
Senator Mark, I believe you're stretching it a little too far. You could refer to them as government.
Government. So, Mr. President, the first point I bring to your attention. This bill in its current form is illegal, is unlawful, is unconstitutional, and it will be challenged in the courts of Trinidad and Tobago. I give it that undertaking. So as the first area, Mr. President, I wish to draw to your attention. Mr. President, you go to several clauses of this piece of legislation, and I see no reason to deviate from these clauses in the legislation, and to show Mr. President, Mr. Vice President, the connectivity, right, as it relates to the importance of those clauses and its impact on people's fundamental rights and freedoms. So, Mr. President, I invite you to go to clause 6.1. I want you to go to clause 6.2. I would like you to go to clause 9, subsection 2. Clause 10, subsection 2. Clause 12, subsection 3. Clause 13, subsection 2. Clause 15.1. And Mr. President, when we were examining this bill back in 2015, 2016, we discovered what the very CPC discovered. We discovered, Mr. President, that in these clauses that I've just called out for your attention, look, let's go to 6.1, Mr. President, so at least you will follow the trend very closely. I want you to note that this government, even though the Minister of Digital Transformation gave an undertaking today that he will bring the Data Protection Act and proclaim it fully, shortly. But as promised, the reality is, Mr. Minister, through the Honorable Vice President, while the grass growing, the cow, the horse, starving. So what do we have in clause 6, Mr. President? I want to read it for you so you'll understand the importance of what we are talking about here. Mr. President, it says, and I quote, an employee of an organization may make a disclosure of improper conduct. And I want to go to these definitions. What is a disclosure? What is improper conduct? So we and the nation would be able to understand improper conduct to a whistleblowing reporting officer or a whistleblowing reports unit where he has reasonable grounds to believe that improper conduct has occurred, is occurring, or is likely to occur within the organization. And it says, Mr. President, in 2, a disclosure under this subsection may be made although the employee is not able to identify a particular person to whom the disclosure relates. So you don't even have to identify the person to whom the disclosure is being made against. You just have reasonable grounds to believe, Mr. President, that something has happened, and they say, you go on and whistle like a bird. You sing like a bird. So what are we talking about, Mr. President? Mr. President, when we talk, you go to the definition section, Mr. President, and you see when they talk, the government in this document that we are talking about, that we are referring to, when you talk about improper conduct, Mr. President, what are we talking about? Mr. President, when we talk about improper conduct, according to the definition, it means a criminal offense. It means failure to carry out a legal obligation. It goes on to talk about conduct that is likely to result in a miscarriage of justice. It talks about conduct that is likely to threaten the health and safety of a person. And it goes on, Mr. President, to talk about likely to threaten or damage to the environment, among other things, as you go to the other areas of this piece of legislation. But what is significant about this, Mr. President, is that the employee under 6.1 can make these protective disclosure. And when we talk about protected disclosure, Mr. President, what we are talking about essentially is that under this improper conduct concept, you are providing information, you are providing data, you are making allegations against an individual. And Mr. President, you know what is even, Mr. Vice President, what is even more egregious? Somebody is making allegations, providing information on you to a whistleblowing officer, to somebody who is in charge of an internal unit, whistleblowing unit. And Mr. President, Mr. Vice President, you have not a clue of what is happening behind your back. Somebody is reporting you to a whistleblowing officer without your knowledge and without your consent. And there is nothing to protect you. There is no data information commissioner that can be around that they have to go to, Mr. President. So the various clauses that I mentioned earlier, Mr. President, all are interconnected. And why are they interconnected, Mr. President? Because they allow the so-called whistleblower to provide information of a personal, private, and confidential nature to a whistleblowing officer. And that person who is making those allegations against the individual, that individual is protected under the legislation. You, on the other hand, constitute the victim. You have offered no consent. You have no knowledge that this is being done, Mr. President. And therefore, what happens in those circumstances, Mr. President? Mr. President, the Data Protection Act of Trinidad and Tobago, had it been fully proclaimed, the citizens of the country would have had some degree of protection against anyone conveying information of a private nature, of a personal nature, of a confidential nature, without your knowledge and your consent. So here it is. You are working according to this piece of legislation in a company. And Mr. President?
Senator, you have 5 more minutes.
Yeah, Mr. President, you are working in a company. And in that company, Mr. Vice President, you are working in a company and you have a contractual obligation not to reveal secrets within the company for whatever reason, because that is a commercial contract. This legislation has voided it, has made it unenforceable, that contract. So you are now able to make that information available to a whistleblower or a whistleblowing officer. That is what you are able to do. And Mr. President, what is even more serious about this particular matter is that this whistleblower can hack your computer. They can hack your data. And they can make that data available, Mr. President, without your knowledge, without any protection, and make it available to the whistleblowing officer. Mr. President, I want to tell you.
Members. Senator Roberts. Can you allow the Senator? Senator Mark, you're going a bit further off the bill.
No, in the bill talks about how they can.
Proceed.
Yeah. Mr. President, what I'm saying is that the United National Congress has looked at this piece of legislation very closely. We find it very inimical to the national interest because we are in favor of good law. Let me make that very clear. We are in favor of good law. We are in favor of whistleblowing legislation. But we are not in favor of the provisions as they stand in the legislation, in the bill before us, that gives almost carte blanche authority and cover to the whistleblower at the expense of those persons who this person is anonymously reporting on. We are saying that the citizen who is a victim of that attack, Mr. President, must have the right, if he is maligned, if his good name is impugned, to take that individual to the court, to take legal action against that individual, Mr. President. And that is not contained in the legislation. And we find that extremely offensive. And there can be no proportionality in this particular context. We are all in favor, as I said, Mr. President, of fighting corruption. The government talks about public procurement. The government took 9 years almost to proclaim the public procurement law. And when they did it, it was all water. It was all water. They chopped it, they cannibalized it, and they made it weak. So that cannot fight any serious corruption. The government has corrupted the Public Procurement Act, and therefore that act is a waste of time. And therefore they have come now with a very malicious piece of legislation that we believe, Mr. President, is designed and organized in a way to target certain persons, certain organizations, certain individuals in Trinidad and Tobago. And we are saying, Mr. President, that is wrong. We are for good law. We are for good law, not for bad law, Mr. President. And therefore, when we look at these provisions in the legislation before us, we see, Mr. President, where this Parliament is
Senator, your time has lapsed.
Okay, thank you, Mr. President.
Senator Anthony Vieira, SC.
Thank you, Mr. Vice President. Well, initially I was surprised to learn that the earlier versions of this bill, put out in 2019 and 2022, both required a special majority, while this one didn't. So that raised a red flag, requiring me to conduct a clause-by-clause comparison to see where and how this version differed. Before getting to the results of my comparative analysis and my view on whether this bill requires a special majority, I think I should just like to say something about whistleblower protection legislation in general, to put things in context. As of recent counts, more than 60 countries have enacted some form of whistleblower protection laws. And those laws vary in terms of scope, enforcement mechanisms, and protections offered. But they all have one thing in common. They aim to protect individuals who report misconduct, corruption, or other illegal activities from retaliation. The purpose of this legislation as set out in the preamble and the title. Now, what makes whistleblower protection so important that over 60 countries would have it on their law books? Well, maybe for some of the following reasons. First, whistleblower protection encourages ethical behavior by promoting a culture of transparency and integrity within both the public and the private sectors, as employees are encouraged to report unethical or illegal activities without fear of retaliation or victimization. Speaking out is never easy. Besides going against the grain of how many have been brought up, the harsh reality is that when insiders blow the whistle on those who have power over them, they do so at great personal risk. Now, blowback can take the form of a job loss, harassment, and legal consequences. And so that's why Part 3 of the bill is so important, because it prohibits detrimental action against whistleblowers on account of their having made a protected disclosure. Further, by providing mechanisms for exposing improper conduct, now whether it relates to bribes for benefits, sexual abuse, fraudulent payments for non-existent work, or damage to the environment, this legislation can help hold individuals and organizations accountable for their actions, thereby promoting trust in our institutions and governance. So as such, the bill enhances accountability. Another benefit that the legislation offers is the opportunity to prevent harm. If Karen Silkwood hadn't reported on safety issues at the Kerr-McGee nuclear plant in Oklahoma in the 1970s, leading to closure of that plant, there was a very real and present danger of plutonium contamination. But because of her bravery, serious harm was avoided. Conversely, had a whistleblower warned us about some mystery barge recklessly and unlawfully transporting oil-like substances through our waters, the environmental disaster inflicted upon Tobago might have been averted. The salient point is that by bringing issues to light before they escalate, whistleblowing can prevent or mitigate harm to the public. Whistleblower protection laws also promote compliance by encouraging organizations to comply with legal and regulatory standards, knowing that internal or external scrutiny is possible. So when employees in an organization are encouraged to report unsafe practices and to speak up against OSHA violations without fear of recrimination, the protection offered by this legislation can contribute to safer working conditions. Finally, by ensuring that public and private sector entities operate transparently and are held accountable for their actions, whistleblower laws strengthen democracy and governance. So if we can empower citizens to come forward confident in the belief that they will be heard and they will be safe from retaliation, it will help hold power to account for the common good. In turn, that can help prevent injustice, corruption, and human rights abuses. So that is why in so many jurisdictions across the globe, especially in the developed countries, whistleblower protection is seen as critical for maintaining ethical standards, protecting individuals, and ensuring the proper functioning of organizations and governments. Now, it remains to be seen whether this legislation will translate into actual practice or merely be ink on paper. It remains to be seen whether we are engaging in a pantomime destined for the courts, given concerns that the bill is being pursued with a simple rather than a special majority. And even if the constitutionality of this legislation is upheld by the courts, it remains to be seen if the statute is sufficiently comprehensive and robust, or whether it has been watered down to the point of being ineffective. Assuming whistleblowers have a key role to play, and they must be protected, not persecuted, when they speak up, what are the necessary elements that would allow individuals to feel confident, to raise concerns in the knowledge that the law is there to protect them? Now, these are some of the aspects that I would like to touch on in my contribution. First and foremost, for this law to be effective, there must be a clear legal framework. The legislation must be well defined. It should specify the types of wrongdoing that can be reported, the procedure for reporting, and the protections offered to whistleblowers. Secondly, the legislation must include robust protection against retaliation, such as job loss and harassment. And such protections should extend to both employers, to employees, and external parties who report misconduct. Thirdly, the legislation should provide secure and anonymous reporting mechanisms that would encourage individuals to come forward without fear of identification and reprisal. But contrary to what Senator Mark said, given that Clause 10 precludes anonymously made disclosures from protection, it's questionable whether the bill falls short there. Fourthly, there should be an independent oversight body. So, for example, in several jurisdictions, independent agencies or ombudsmen have been established to oversee the handling of whistleblower reports, ensuring impartiality and thorough investigation of complaints. Now, while an independent oversight body is not being established under this legislation, the bill fills a gap where an organization has no internal procedures for receiving and dealing with disclosures, and where there may be a suspicion that the whistleblowing reporting officer is actually involved in the alleged improper conduct. So the bill allows whistleblowers to make their disclosures externally to whistleblowing report units at multiple designated authorities as listed in the schedule. And it's interesting to go through that schedule because these designated authorities include constitutionally protected officers under the Constitution, such as the Auditor General's Department, the Director of Public Prosecutions, and the Ombudsman, as well as highly respected institutions such as the Central Bank, the Children's Authority, and the Office of Procurement Regulation. But as they say, it's hard to form roots in barren soil. Even if this legislation withstands judicial scrutiny in terms of constitutionality, and its provisions are sufficiently comprehensive and robust, more, I submit, more is required for the seeds we are sowing today to take root and to flower. If we hope to see a whistleblowing culture take root and flower, we need to cultivate. And we cultivate by crafting and publishing whistleblower policy templates that organizations can use, instead of each entity having to reinvent the wheel. Exactly. So this would promote also a level of consistency. We cultivate through regular training and awareness campaigns to educate employers and employees about whistleblowing laws, their rights, and the procedures for reporting wrongdoing. We cultivate by ensuring that disclosures do not fall on deaf ears. When whistleblower complaints are dealt with swiftly and transparently, it helps build trust in the system. But the opposite is also true. We cultivate by fostering an organizational culture that values transparency and ethical behavior. Now, that requires our leaders in both the public and private sectors to set a positive tone, among other things, by actively promoting a safe environment for reporting and demonstrating a commitment to addressing misconduct. Most importantly, we cultivate by shifting the cultural perceptions and attitudes where whistleblowers are regarded as traitors or snitches. Getting past such cultural perceptions and attitudes will not be easy, but it has to be done because the current norm encourages people to stay silent in the face of corruption and wrongdoing. These perceptions and attitudes are based on a mistaken sense of loyalty. Loyalty to the wrongdoer instead of to the organization, instead of loyalty to one's co-workers, to the public, and to the state. We cultivate by reframing and redirecting misplaced loyalties to what is right and just, towards a new ethos, where if you see something, you say something. An ethos based on Gandhi's observation that, and as I quote, silence becomes cowardice when occasion demands speaking out the whole truth and acting accordingly, end of quote. We cultivate by highlighting stories where whistleblowing led to positive and significant changes. The internet is replete with stories about inspiring individuals who safeguarded public interest by exposing misconduct, including our own Jean Miles, who testified against the corruption surrounding the granting of gas station licenses. Publicly rewarding and recognizing whistleblowers for their courage and contribution within organizations will also assist in reframing the narrative. Now, at the end of the day, if this legislation is to flower, potential and actual whistleblowers must be assured that they're protected by law and that any form of retaliation will be taken seriously. Cultivation means creating an environment where whistleblowing is encouraged, protected, and effective in promoting ethical behavior and accountability. Now, turning now to the vexing question of whether this bill requires a simple or special majority. It bears noting, and I agree with Senator Mark on this, that what has been left out in this version are parts of the 2019 and 2022 preamble, the provision at clause 3, which declares that the act shall have effect even though inconsistent with sections 4 and 5 of the Constitution, and parts of clause 29. Clause 28 in the current version before us. That's it. Nothing else. Apart from those changes, those deletions, the three versions are essentially the same in terms of wording, order, and scope. Now, removing parts of the preamble is no big deal because a preamble is just a recital. It provides context and rationale for the law that follows. And while the preamble outlines the objectives, guiding principles, and motivations behind the legislation, helping clarify the intent of the lawmakers and useful for interpreting the law's provisions and understanding its broader goals, it's important to understand that the preamble itself is not legally binding. But that begs the question. If the substantive provisions in all three versions are essentially the same, then why was it considered necessary to provide for a special majority in the earlier versions and not now? Well, I think the Attorney General answered that question for us when he confirmed that the earlier versions preceded the Privy Council's judgment in Suraj. No, in Suraj, yeah. I have the case here. In Suraj, which was given on the 20th of June, 2022. Certainly, where it is clear that the legislation amends the Constitution or affects one of the enshrined fundamental rights, the bill should require a higher threshold of approval. Again, where legislation has the potential for substantial social, economic, or political impact, as hoped for with this bill, it's always better to get broad consensus to ensure stability and acceptance. Certainly, laws having a special majority enhance legitimacy and public trust in the law. A burning issue that I was hearing about related to the matter of privacy. So let's have a brief look at that. First, it bears emphasizing that unlike jurisdictions in Europe and South America, we haven't enacted a privacy law in this jurisdiction. Where privacy rights are concerned, ours is a miscellany. We don't have a privacy law, but an amalgam of principles embodied in different pieces of legislation, like the Data Protection Act and case law. Interests in privacy can receive some protection, but only in an indirect way. For example, under the Data Protection Act, actions for breach of confidence, trespass to property, defamation, so on. While the constitutional provision regarding the right of the individual to respect for his private life offers some protection from unwarranted interference from the state, there is little or no protection where the infringer is a private individual. But what about the common law, you might ask? Well, the decision of the House of Lords in Wainwright and Home Office, which involved the strip search of visitors to a prison, conclusively reaffirmed that there is no thought of invasion of privacy and no right of privacy under the common law. I should say, too, in the Surat case, the Privy Council reaffirmed the position that they are taking in Surat. That is to say that ordinary or subsidiary legislation can impinge upon the fundamental rights and freedoms set out in Section 4 of the Constitution, as long as it pursues a legitimate aim and is proportionate to it. And I'm quoting from the Suraj case, the nature of the rights and freedoms in Section 4 must be read as subject to a qualification that there may be interference with them, where that is to promote a legitimate aim in the public interest and the interference is proportionate to that aim. In other words, the rights protected by Section 4 are not absolute, and it is for Parliament, in the first instance, to strike the balance between individual rights and the general interest. Secondly, even if it is felt that the legislation does impact privacy rights in specific contexts, well, given the Privy Council's holding in Suraj, we must accept that privacy is not an absolute right. And if we were to treat it as an absolute, the lawmaking power which Parliament enjoys under Section 53 to take measures in the public interest would be severely and unjustifiably undermined. That's what the law lords in the Privy Council that we love so much have said. So we can pass this law. We can pass this law provided that the right balance is struck between individual rights and the general interest. Now, this means, as a Parliament, satisfying ourselves that the legislation serves the public good. It aligns with its intended purpose, and that the mechanisms provided for implementation, enforcement, impact, and compliance are capable of producing the desired results. And we need to assess whether the legislation is necessary and appropriate to achieve a legitimate aim. Now, this involves evaluating whether the objectives pursued is legitimate. Well, if the primary goal is to combat corruption and other wrongdoing by protecting individuals who report improper conduct from retaliation, that strikes me as a legitimate aim. And finally, whether the benefits of the proposed legislation outweigh the risk and potential harm caused to individual rights where privacy is concerned. Well, as said in earlier debates, the law is always a balance between competing and sometimes incompatible ends. Now, looking at the legislation, it's clear that it seeks to balance the competing ends of, on the one hand, the need to investigate allegations of improper conduct against, on the other hand, the protection of personal privacy. For example, at clauses 21 and 24, the bill makes express provision to maintain the confidentiality of the whistleblower's identity to protect them from retaliation. Again, Part 2 of the bill outlines how information provided by whistleblowers should be handled, stored, and disclosed to ensure that protected disclosures can only be used for legitimate investigative purposes, and that privacy is safeguarded as much as possible. Another area where the legislation seeks to balance protection of the individual's privacy rights against the need for transparency and accountability relates to the restrictions or limits on what information can be disclosed and to whom. Most importantly, the legislation provides legal protection and remedies for whistleblowers who believe that detrimental action has been or is likely to be taken against them. Now, Senator Mark raised concerns about Clause 18.1, that those who make protected disclosures are not liable because they are immune from criminal, civil, and disciplinary proceedings for having made such a disclosure. But the operative word here is protected disclosures. The immunity only covers protected disclosures, defined at Clause 7. So if a disclosure is false, it's not protected. And if it's not protected, then proceedings can be brought against the person who made the false disclosure. So, who determined the perjury was false? All right? So now, I mean, we talked about it in the earlier debate. While the provisions protecting personal privacy cannot be guaranteed as fail-safe, it's apparent on the face of the legislation that good faith attempts have been made to balance the need to investigate allegations against the need for protection of personal privacy and other rights. I am satisfied that the risks to privacy are justified and they are not excessive. I don't see an intolerable and unjustifiable invasion of privacy. I am satisfied that even where there may be some impact on privacy, the risks are justified and proportionate to the public interest served by whistleblowing. I am satisfied that this legislation is not out of line with the fundamental goals and values set out in the Constitution. And as such, I am satisfied a special majority is not required. As indicated earlier, my concerns about this legislation relate to softer issues on the penumbra of the legislation. Because even with the best laws on paper, unless we cultivate the right environment, changing the perception from where whistleblowers are seen as snitches to being recognized as valuable contributors to organizational integrity and public trust, the seed sown today will not yield a full harvest. Ella Wilcox is reputed to have said, "To sin by silence when they should protest makes cowards of men." With the passing of this legislation, once we can cultivate the right supporting environment, I am hopeful that even cowards will speak up because they will feel safe in the knowledge that they're protected from detrimental action and victimization. And that, Mr. President, is a worthy goal deserving of support. I thank you.
Minister of Social Development and Family Services.
Thank you very much, Mr. President. Yes, Mr. President, I am honored to have been given the opportunity to join the debate on what is essentially government's third attempt to introduce whistleblower legislation into the compilation of national laws, and in so doing, buttress other pieces of legislation aimed at crippling criminal enterprise. Mr. President, all of us who live in this country are aware, more often than not, painfully so, of the numerous instances where allegations of impropriety fail to move from the stage of more hearsay to that of evidential robustness because of the absence of witnesses and/or documentation. And in such cases, some corruption matters may fall by the wayside. This bill, Mr. President, seeks to put a tool in the hands of employees and the wider citizenry, a mechanism through which they can be the eyes and ears, and in many cases, the conscience of the nation, doing their civil duty to identify those with prosecutorial powers, those instances where persons have been less than honest in their dealings. Mr. President, this legislation is not novel. This is not an approach that has not been taken before. Indeed, the concept of whistleblowing is as old as society itself. The ancient Greeks had a term for it, parrhesia, or fearless speech. Antecedents to modern whistleblowing laws can be found in feudal England. Hundreds of years later, the act of whistleblowing has lost none of its importance. To encourage persons to speak up and prevent whistleblowers from facing retaliation for their courage, in recent decades, many governments have enacted standalone whistleblower protection laws. What began as a trickle in the late 1970s in the United States became a global flood in the mid-2010s. In 2019, the European Union passed a landmark whistleblower protection directive, requiring all member states to introduce best practice laws in the coming years. And today, a quarter of the globe have dedicated whistleblower statutes. And I make reference to this information simply to make the point that this legislation, which we are attempting to pass through this Honorable House, is part of a growing worldwide trend aimed at closing the loopholes through which ingenious and some wealthy persons are often able to wriggle free. But however, as we all know, laws do not operate in a vacuum. So setting high protection standards and laying down strong rights in the law is not the end of the story. Rather, it is only the first step of a long journey. Even the most sophisticated protection regime can only be fully effective if the judicial and enforcement institutions support such effectiveness. And, Mr. President, that is the support that we seek today. Irrespective of which side of the aisle you are, everyone, every citizen, is subject to the same legislation. So as I heard Senator Mark brought politics into this, the whistleblower legislation is not for the benefit of this administration. It is for each and every citizen, and of course to protect the public purse. I can say without fear of contradiction that some of the fraud that we have discovered in the Ministry of Social Development and Family Services is owed in no small way to civic-minded citizens who understand that the person who has 2 food cards is depriving a needy person of one. Yes. And the person who is living in the United States and collecting pension is also depriving another eligible citizen from receiving the benefit. And note that is also taxpayers' money paying for that. The fraud that has been detected in the disbursement of flood relief grants or COVID-19 support checks is as a result of whistleblowers accepting their duty as patriotic citizens to weed out corruption in all levels of our society. Very good. The anonymity that this legislation affords potential whistleblowers is no different from the protection offered to persons using our Crime Stoppers hotline, E999, and various other hotlines similar. Mr. President, the evidence from these organizations suggests that persons have successfully utilized the systems without either placing themselves in harm's way or endangering the lives of loved ones. Indeed, more often than not, their courageous actions have resulted in someone or an entire community being able to have an enhanced quality of life. And I am certain that there are members on this side who can speak of corruption that has been brought to their attention in their ministries.
Correct.
But some of these will go unresolved, without resolution, because witnesses are either unwilling or afraid to come forward because, of course, they want some form of protection. And think of where the great United States of America would have been if the whistleblowers in the infamous Watergate scandal were publicly named from the get-go. Think of the WikiLeaks revelation and Panama Papers that journalists collaborating with whistleblowers were able to use to expose corruption at the highest levels of government around the world. Mr. President, I want to say something here with regards to, sometimes there's refusal to support certain legislation. So, for example, the refusal to support the Revenue Authority was premised on the so-called inappropriate intention to share information and the data between the Board of Inland Revenue, Customs, and the Ministry of Finance. But I always remember that Al Capone, who was alleged to have been the mastermind behind countless murders in the United States, was never convicted for one of those murders, but rather for tax evasion. So when we refuse to support certain bills, there's always a relation somewhere that can help.
Yes.
Mr. President, Clause 15 of this bill provides for the referral of protected disclosures by a whistleblowing reports unit to another whistleblowing reports unit within 30 days with the consent of the whistleblower. And if it is determined that such disclosure can be better processed by the other whistleblowing unit. And this presents the whistleblowing reports unit with the opportunity to make connection between units in different agencies and ministries, and thus via a whole of government approach. Reporting infrastructure potentially bringing to justice those who seek to benefit from their nefarious ways. The Whistleblower Protection Bill is designed to create a robust legal framework that encourages and protects individuals who report improper conduct within organizations. By clearly defining terms such as improper conduct and whistleblower, the bill ensures that there is no ambiguity in its application. So I didn't understand how Senator Mark didn't understand what improper conduct meant, and it was there in the definition. Notably, this legislation applies retroactively to past misconduct, ensuring that all instances of fraud and corruption are addressed, regardless of when they occurred. And that is important to note. So the benefits of this bill are substantial for the Ministry of Social Development and Family Services. It will encourage employees and stakeholders to report errors, fraud, and corruption without fear of retaliation, and will foster an environment of transparency and accountability. The transparency is essential for ensuring that the funds and resources allocated to our social safety nets reach their intended recipients efficiently and effectively. The bill also establishes a structured framework for disclosing improper conduct, which is critical for detecting and preventing fraudulent activities. This framework ensures that reports are handled systematically and professionally, enabling us to uncover and address wrongdoing promptly. Additionally, the legal provisions within the bill necessitate the establishment of strong internal reporting channels and safeguards. And this will lead to more rigorous internal controls and audits within the ministry, significantly enhancing our governance and our operational strategy. By mandating these practices, the bill ensures that our ministry would operate with the high standards of accountability and oversight. Public trust in the ministry can be bolstered by our commitment to ethical conduct and the protection of whistleblowers. Beneficiaries and the general public will acknowledge that we are dedicated to addressing and eliminating misconduct. And this trust is fundamental to the success of our programs, as it ensures our continued support and cooperation from the public and other stakeholders. By proactively identifying and rectifying instances of fraud and corruption, we can reduce our exposure to legal and financial risks. This proactive approach will mitigate the consequences of potential scandals or mismanagement, protecting the ministry's reputation and resources. In a broader sense, it will contribute to a culture of integrity and accountability across the public service, setting a precedent for other ministries and departments to follow. So, Mr. President, even though the bill excludes anonymous disclosures, which is Clause 9, we must ensure that legitimate concerns are not overlooked by creating secure and trusted channels that encourage name disclosures while protecting the whistleblowers. And I know that Senator Mark and Senator Vieira refer to this, but it is vital that those who come forward feel fully protected against any form of retaliation. And the Attorney General refers to Clause 9, Subclause 4, where the person who makes an anonymous disclosure, if the identity becomes known, they will be protected, and that is important. Despite the legal protection framework, some whistleblowers may still face some form of retaliation. So it is imperative that we develop robust mechanisms to monitor and address any such issues promptly to maintain the credibility of the whistleblower protection framework. And I refer to Senator Vieira saying this, but different words. And these mechanisms should include clear reporting processes, strong anti-retaliation policies, and ongoing support for whistleblowers throughout the investigation process. And I must note that the Trinidad and Tobago Transparency Institute endorsed the whistleblower legislation. In the Sunday Guardian, dated June 23rd, the Sunday Express, dated June the 23rd, they identified the whistleblower legislation as one of the key tools in the fight against corruption. They therefore called for the swift, uninterrupted, and supported passage of this bill through the upper house. Mr. President, also, the head of the Tobago Business Chamber, Attorney at Law Martin George, sees the whistleblower legislation as tremendously important in both the public and private sector, and he is quoted in Sunday Guardian, January 14, 2024. This bill, therefore, as I mentioned before, presents significant benefit for the Ministry of Social Development and Family Services because it promises to enhance transparency, accountability, and the prevention of fraud, leading to a more ethical, efficient, and trusted system for distributing grants and providing services to our vulnerable population in Trinidad and Tobago. And some examples of the areas that now require whistleblowers to come forward within the ministry are as follows. Cases of fraudulent applications. Even employees may know of clients who submitted false information or documentation to obtain grants. A good example are cases where we have seen cases with persons with the same birth certificate applying for grants. From the same district, they submit grant application using the same information. And this also clearly extends beyond the Ministry of Social Development and Family Services because so how did these people obtain these original birth certificates in the first place? Another area is where people earning income through rental arrangements of their large properties still apply and obtain grants after transferring these properties to family members. It is through whistleblowing we are able to know of these cases and have them removed from the system. Another area with regards to the ministry, misallocation of funds. We know of cases at particular local boards where grant money has been diverted for personal use or unauthorized persons cash or redeemed at particular groceries. Since these are not isolated to one individual, whistleblowers need to come forward to let us know who is running these schemes. Conflict of interest. Undisclosed relationships or interests that influence the awarding of grants. And we have found that there are areas where there's conflict of interest in the awarding of grants from across the ministry. But we must protect whistleblowers to get the information required to build and close these cases. Corruption and bribery. Offering or accepting bribes to influence grant decisions. Investigators have been informed of situations where people are rewarded, bribed, even for approving grant application. This is, of course, unacceptable, but can only be proven if a whistleblower comes forward or if the client comes forward. Financial mismanagement. We have inappropriate or inefficient use of grant funds. Example, the food support grant. We still have supermarkets, we still have persons using the food card and receiving cigarettes and alcohol, which you're not supposed to receive. Employees have to come forward and speak about it. Because when we talk about food support, the monthly food support that you receive, one of the areas that they are not to buy alcohol and cigarettes, but supermarkets still give it to them. Nepotism, favoring relatives or friends in the distribution of grants. Violation of grant terms, non-compliance with the conditions set forth in the grant agreements. And some of this, we may not be there to see it, but whistleblowers are the ones going to tell us about it. Data manipulation and willful deception. This was discovered in the Senior Citizens Pension Grant Total, which was submitted in 2021. Clients who were supposed to be taken off the system, either because of death or ineligibility, were left on the system. While our investigation and compliance unit was able to identify the fraud and even the employee who submitted the information, they could not determine who was responsible for the original falsification because, of course, people did not speak up. We have a situation where sometimes files disappear when there is suspicious activity. We need whistleblowers because files don't work on its own. Discrimination, biased decision-making based on race, gender, and other discriminatory factors. We have found that particular grants are more easily distributed in some areas than others. We ask ourselves, why? We have had instances of retaliation against whistleblowers, threats of non-renewal of contracts. While the executive of the Ministry of Social Development and Family Service takes a non-retaliation stance against whistleblowers, the whistleblower legislation will strengthen the protection of whistleblowers from these instances of abuse. So we have had people report that they were told to shut up by supervisors, or else their contract will not be renewed, whether they be on short-term or long-term. They are threatened. So these investigations remain ongoing, both for the investigation and compliance unit of the Ministry of Social Development and Family Services, and also for the Trinidad and Tobago Police Service, because as a country, we lack the comprehensive whistleblower protections needed to gather crucial information and protect those who come forward.
True.
Without proper whistleblowing legislation, individuals who possess critical knowledge are often too fearful to report misconduct, knowing they might face retaliation or, of course, adverse consequences. With robust whistleblower legislation, our ministry would be able to, and I summarize, encourage reporting. By providing strong legal protections, we can assure potential whistleblowers that they can report wrongdoing without fear of retaliation. We can gather comprehensive evidence. Protective whistleblowers are more likely to come forward with detailed and critical information, enabling us to close investigations more effectively. Can protect whistleblowers. Effective legislation ensures that those who expose misconduct are shielded from any form of retaliation, fostering a culture of transparency and accountability. So, Mr. President, in the past, some whistleblowers have faced severe retaliation for their courage in reporting misconduct. And this has not only silenced important voices, but has also allowed unethical behavior to persist. The introduction of robust whistleblower legislation changes this dynamic. It empowers individuals to act in the public interest, knowing that the law will protect them. To illustrate, consider the unresolved cases of fraudulent applications. Proper legislation would enable more individuals to report fraudulent applications without fear, leading to a cleaner and more efficient grant distribution process. More whistleblowers will feel secure in reporting the misuse of funds, ensuring that resources reach their intended recipients. Comprehensive protections would allow to uncover hidden relationships and corruption, restoring fairness and integrity in our operations. With better protection, we would receive more reports about mismanagement and favoritism, allowing us to take corrective action. Data manipulation and discrimination. Accurate reporting from protected whistleblowers would help us address data falsification and ensure decisions are made fairly. Strong legislative safeguards would prevent past instances of retaliation, ensuring that those who come forward are supported and not punished. Mr. President, let me emphasize that the integrity and effectiveness of the Ministry of Social Development and Family Services depends on the trust and cooperation of the public we serve. By implementing and upholding strong whistleblower legislation, we affirm our commitment to transparency, accountability, and justice. And we must empower those who witness wrongdoing to speak out. And we must demonstrate that our ministry is dedicated to rooting out corruption and inefficiency at every level. Yes. And that is why I support and I salute the Member of Parliament for Kamuta-Mantinilla for his stance on supporting this bill.
What a man.
Permit me to quote Newsday, article dated June the 26th, 2024, where Mr. Rugby was quoted as follows, and I quote, "I wish to remind my party, as well as the nation, that the primary reason I voted in favor of this bill is the numerous concerns expressed by individuals regarding certain actions within the Sandy Grande Regional Corporation." He said in a statement on June 25th, "Many people," end of quote, "many people were afraid to report these matters to the police," and I quote, "I have no doubt that this legislation will benefit the people of Kamuta-Mantinilla and the entire country." End of quote. Rugby reiterated that he stands by his vote, adding that he would always prioritize the best interests of those who elected him over those who thought only of themselves. So this bill is not just about improving processes and frameworks. Mr. President, I'm being disturbed.
It's quite late at night, and could we just temper the level of noise in the chamber to allow the minister to continue her contribution? Continue.
Thank you very much. Rugby reiterated that he stands by his vote, adding that he will always prioritize the best interests of those who elected him over those who only thought of themselves. So this bill is not just about improving processes and frameworks. It is about ensuring that the most vulnerable in our society receive the support they need and deserve. It is about fostering a culture where honesty and integrity.
Hearing you quite loudly. Minister, continue.
This bill is not just about improving processes and frameworks. It is about ensuring that the most vulnerable in our society receive the support that they need and deserve. It is about fostering a culture where honesty and integrity are valued and protected. It is about making a clear statement that corruption and fraud have no place in our country. Yes. So I urge my fellow senators to support this bill. Let us demonstrate our commitment to transparency, accountability, and justice. Yes. And Mr. President, the Parliament is a place for debate, vigorous and at times vociferous. What it is not is a place where the needs of the country become subservient to anyone, to any political party.
Well said. Well put.
By passing the Whistleblower Protection Bill, we can take a significant step forward in safeguarding the integrity of our nation's public sector and the well-being of our citizens. So I respectfully submit to this House. I support this bill wholeheartedly.
Excellent. Excellent. Excellent.
Senator Gopeesingh.
Mr. President, for the opportunity to contribute on this important piece of legislation which the government is contemplating to be passed in this House. Let me thank the honorable political leader of the United National Congress for giving me this opportunity to speak on this here this evening. And let me congratulate also the leader of opposition in the Senate, Senator Wade Mark, on his brilliant contribution. Yes. Mr. Brilliant. Mr. President, let us look at the history of this bill.
Exams coming up.
When you look at the history of this bill, you must ask, what is the intent of this government here today? They brought this bill in 2015, 9 years ago. They truncated it with a JSC, a Joint Select Committee. No report was made in it. After we voted down the bill in May 29, in 2019, they tabled it in the Senate in November 2019, yet failed to debate it for 3 years. That's this government. With all these new global benchmarks for whistleblowing emerging, such as the EU blowing directive, why have they suddenly begun to rush this? The same bill 9 years ago without any changes.
Lazy.
Is it just a bus mark and change in the national conversation because zero work has gone into this in the last number of years? Mr. President, this legislation is based on inadequate and insufficient global laws. The legislation is based on drafted in accordance with the whistleblowing laws of New Zealand, as mentioned by the Attorney General, Canada, Alberta, Malaysia, the UK, and Jamaica. 4 of these 5 jurisdictions have now highlighted massive shortcomings with their whistleblowing laws and are making changes. But we are stuck with the original ones that they have. This is where we are years behind. And they're feeling proud about it. Yeah. New Zealand found shortcomings in their laws and presently has a new whistleblowing bill being debated at the committee stage of their parliament. They're changing it. Alberta is undertaking a review of its whistleblowing law due to shortcomings and is before the Legislative Assembly for amendments. Malaysia blamed its fall in their corruption perception index last month due to the lack of amendments to their whistleblowing law. In November 2021, MPs in the United Kingdom Parliament called for a review of the whistleblowing laws due to shortcomings, and the Prime Minister agreed. And this government is pushing through legislation now that has been globally proven to be faulty. If all these 5 countries, which we are basing all our legislation on, have gone about to find that their laws are archaic and making new laws now. And so this government will want to blame the opposition all the time for delaying or stalling whistleblowing legislation. Time and time again, this government tries to rush faulty legislation and then blame the opposition into not supporting it. We want good law, and this is not good law. But we have always said that we support good law in the national interest, as we did with FATCA, Global Forum, Follow the Money, the anti-gang bill, etc. They took 9 years to bring this bill to us the same way. They did nothing. They could have convened a Joint Select Committee to get comments a few years ago and then make some changes. Yet, now we have the same. And this piece of legislation is faulty, Mr. President. Our definition of protected disclosure is too arbitrary. In the Whistleblower Bill 2022, disclosure means disclosure of information by a person which shows or potentially shows the improper conduct has occurred, is occurring, or is likely to occur. Note, the person is reporting improper conduct. But what is improper conduct? Is improper conduct coming to work late, wearing improper clothes, civil violations, or criminal violations? Which one is it? According to the OECD Whistleblower Protection Legislative Proposal to Greece, on page 16, it is recommended the precise definition of what constitutes a protective disclosure is vital They don't have anything about that definition, not only for reasons of legal certainty, but also for public confidence in the process. When you look at the UK and New Zealand laws, which our legislation is based on, they are very specific. The UK Public Interest Disclosure Act 1998 defines protected disclosure in Article 443B information, which tend to show that a criminal offense has been committed, is being committed, or is likely to be committed. B, that a person has failed, is failing, or is likely to fail to comply with any legal obligation to which he is subject. C, that a miscarriage of justice has occurred, is occurring. So it is spelled out. D, that the health or safety of any individual has been, is likely to be endangered. E, that the environment is being, or is likely to be damaged. So this, what defines protected disclosure, they define exactly what they want to have in the legislation, but this is ambiguous, airy-fairy, nothing. New Zealand Protected Disclosure Act
Would you remember give
of
way?
2000, New Zealand.
Would you give way?
No. Let me get on. I will give way a little bit later. New Zealand Protected Disclosure Act, PDA 33, defines serious wrongdoing in Section 3 as unlawful, corrupt, or irregular use of funds or resources of a public sector organization, or B, an act, omission, or course of conduct that constitutes a serious risk to public health or public safety or the environment, or C, an act, omission, or course of conduct that constitutes a serious risk to the maintenance of law, etc. The point here is that these laws in the United Kingdom and in New Zealand have and the OECD, they have already found, even though they're specific in what they require to be looked at, they're now finding them archaic and irrelevant. So they are trying to make changes. But we are hooked in the whole thing. I wonder, the Attorney General, I would wonder, you're a senior person in the legal profession, how could you sit down and accept that what is given to you and you don't make any changes to that, and because you're Attorney General, you bring it to the Parliament? But you can use your wisdom and tell your government that this is unacceptable and don't bring what you brought here today. It reflects on your incompetence, Attorney General. It reflects on you. And if you could sit down there and allow yourself to be used like that, I feel sorry. Look at disclosures. Will disclosures be protected from the Freedom of Information Act? The OECD Whistleblower Protection Legislative Proposal to Greece recommends, page 28, that confidentiality can be guaranteed by ensuring that whistleblower reports are exempt from Freedom of Information legislation. The New Zealand legislation provides that a request under the Official Information Act may be refused if it might identify a person who has made a protective disclosure. So will disclosures under this law will be protected from the FOIA to ensure the safety of whistleblowers? Nothing has been mentioned about that. Nothing about the FOIA. Mr. President, there are serious drawbacks in this bill in terms of data protection and data security. One of the major shortcomings of this bill is data protection and data security. Ethic Control, which is a platform that analyzes whistleblowing legislation across the globe, has highlighted the issue of data protection and data security in their 2018 bill. On their website, they analyzed our 2018 legislation and highlighted the following. The disclosed information can contain trade secrets and be the result of unauthorized access. Such things would be better prevented and explained. The same unclear situation is with personal data on whistleblowers, where and for how long it can be stored, who can have access to it, how long will designated authorities be allowed to keep this private information? Nobody knows. What are the express provisions to protect private information? So these questions emanate, Mr. President, and they will remain unanswered. We cannot trust this government, Mr. President. This government cannot be trusted with the powers of this legislation, as it can result in political abuse. Despite all the talk from the government, the actions show they don't understand the meaning of transparency and, most importantly, separation of powers. This is a government that caused the police merit list to disappear. This is a government that gutted the Procurement Act. So with all those blunders, how can they now want to set a standard for the entire country to follow when they have failed to do so in 9 years? Does the government value the view of the Chief Parliamentary Counsel? My colleague Senator Mark raised the issue of the Chief Parliamentary Counsel. Let me read the role of the CPC as stated on the Ministry of the Attorney General's website. The Chief Parliamentary Counsel heads the legislative drafting department, which plays a critical role in the implementation of government policy. In 2016, the CPC raised massive concerns about the 2015 bill, yet the AG brought the identical bill in 2018. So they're flying in the face of great advice. They don't take him on. And today the government is debating the bill that is identical with the 2018 and 2015 bills. And of course, we always ask, where are the regulations? The regulations of Procurement Act, they took 8 years before they started to get regulations for it. They deliberately gutted the Procurement Act with simple majority, moved it from special majority to simple majority, and they took years to bring on the regulations. We're debating something here, and they will take years to bring in the regulations in this, and we wouldn't have a clue. And they're boasting that they will bring it by affirmative resolution. But what's the purpose of bringing affirmative resolution when the whole bill is flawed? The whole bill is flawed. This bill is a special majority bill, yet the regulations which will stipulate the operational elements of this bill are not being produced for scrutiny. And this will end up just like the procurement bill, with the regulations languishing for years. Let me deal with Clause 6. My colleague Senator Mark raised some issues on it. Clause 6 says, instead of having the employee report to an internal whistleblowing officer, have them report to the designated authorities directly. Mr. President, there is a great risk for an employee being exposed or facing repercussions by reporting to an internal whistleblowing officer within the company, given how small societies we are. The worker may not even feel comfortable or deterred from reporting such cases, knowing they have to remain working in the same entity. The only option for making disclosures should be the designated authorities, where the worker will feel safer and more secure. This bill has about 22 designated authorities, but which one will they go to? So, should we not consider, like some of these countries, replace all these designated authorities with one central body for easier access and security? Clause 6 allows an employee to make a disclosure to any of the designated authorities stated in Schedule 1, like FIU, Customs, EBC, or Equal Opportunities, or even the DPP's office. Instead of having 21 different designated authorities as listed in the schedule, would you not consider one distinct whistleblowing organization? One, as 2 or 3 of the countries that we know about have one organization. I think it's the United Kingdom has one organization that they could report their matters to. This would prevent citizens from becoming confused as to which authority they have to report issues to while offering more security. Could whistleblowers make disclosures through an attorney, as opposed to going directly to the internal unit or designated authority? My colleagues this afternoon have been bringing in the issues of the role of the attorneys. Jamaica allows for disclosures to be made through an attorney, as opposed to going directly to the internal whistleblowing unit or designated authority themselves. They haven't read anything. They haven't guided their thinking and their thing by what is happening around in the rest of the world. At a certain level, they can't rise above that. So if we have one designated authority. This would allow for greater secrecy, security, and veracity of information, which this bill that they want to be able to have and to deal with. Clause 7, the issue with the reliability of the disclosure made. This raises issues about the accuracy and reliability of disclosures given an event is likely to occur but may not occur. And the fact that a person can be wrongfully accused as no specific identity is required. So what protective measures are being put in place to verify these disclosures before an individual or entity is investigated? These are some questions that we're asking. Who determines if the employee has reasonable grounds to make a decision? Clause 7.1 says an employee can make a disclosure if they believe they have reasonable grounds that improper conduct has occurred. What defines reasonable grounds? Is it the whistleblower determining the reasonable ground or the reporting officer? How will the employee be able, as a non-lawyer, to determine what is reasonable grounds? So you see, all these questions linger. All these questions are there. And I'm sure the Attorney General, when he tries to wind up, will not have the answers to these because they're open-ended and they can't find an answer to that. Summary of Clause 10. This clause states an anonymous disclosure would not be a protected disclosure. However, if the identity of the person making an anonymous disclosure becomes known, the disclosure shall be deemed to be protected disclosure as if it had not been made anonymously. So, Clause 10, by not protecting the anonymous disclosure, the identity of the person could be revealed. Additional, protecting disclosures from illegal interception. Given the need to protect the employee and the age of technology, the bill is silent on what is being done to protect the anonymous disclosure from illegal interception, as Senator Mark had spoken about a while ago this evening. Clause 10, anonymous disclosures allow for false or vindictive information being spread. Clause 10 allows for an anonymous disclosure to be made. However, Clause 7 allows all disclosures to be made on reasonable grounds. So, however, Mr. President, in the society we live in, many times reasonable grounds are still based on rumors, false news, fake news, and hearsay. And this undoubtedly can be very detrimental to the innocent reputation of many firms and individuals. So, Clause 11, how could every employer be required to employ whistleblowing reporting officers? How many companies do we have in Trinidad? AG, must say about 40,000 companies. These 40,000 companies have to employ whistleblowing reporting officers? Well, will parlors and roti shops will fall under the definition of employer and they're employing people? Or required to employ whistleblowing reporting officers? So this bill is so nonsensical, without any merit, without any thinking. So you talk about an employer. There are thousands of employers in this country who will have to now have whistleblowing reporting officers. But that's a joke. So there should be a specific classification of entities required to do such. And Clause 11 would place a burden on small and medium-sized businesses. And what is the skill set of this required for such an officer? What oversight is there to ensure private companies actually set up whistleblowing reporting units and investigate? Clause 11 requires employers to appoint whistleblowers reporting officers. Many times, private firms put their own interests ahead of society. What oversight is there to ensure that whistleblower units aren't simply existing on paper, but are actually investigating reports? Are we going to have specific regulations on how these units are to operate across all organizations, or leave it up to the organizations? Will the government conduct training or leave it up to the firm? All the legislation speak about is setting up the units, but not how they will work. The need for safe regulations to govern the manner in which internal whistleblower units are set up. If internal reporting units are set up in a manner whereby the entire company can see who enters the office or location of the internal whistleblowing unit, workers could be targeted or feel less likely to make disclosures. You must have regulations, Honorable Attorney General, to deal with the physical security of records within units, because if workers believe disclosures can be easily accessed or stolen, reports will not be made. So you must implement safe regulations for the operations of these units. What criteria can be used to designate or appoint a whistleblowing officer? The whistleblowing officer must be able to inspire confidence and guarantee confidence for workers' disclosures. Firstly, they must be competent to deal with disclosures. So who and what qualifications must they possess? Or could a company appoint a janitor in a firm to be the officer? All these things needed to be spoken about and dealt with. They're vague and they don't tell you anything. So you want us to accept this piece of legislation you're bringing forward, and really there is no depth in it. And if top management is appointed, it may also act as a deterrent for workers to make disclosures. So, Mr. President, I just want to go back to this little point on the CPC. The CPC, which is the Chief Parliamentary Counsel, warned the government about the constitutionality of these clauses as it tolerates the commission of criminal offences for the purpose of making a protected disclosure. Clauses 18 and 19 of this bill were the identical clauses 16 and 17 in the 2015 bill, which the CPC advised on. The CPC commented on those clauses by saying they infringe the right to initiate the proceedings in court, breaching Section 5(2)(e) and H of the Constitution. That Section 5 of the Constitution says that Parliament may not deprive a person of the right to a fair hearing in accordance with the principles of fundamental justice. The CPC pointed out that these clauses tolerates the commission of criminal offences for the purposes of protected disclosures. So he gave his advice, they have not taken his advice, and they're still coming to ask for us to support it. So I think I have dealt with a number of these clauses, Mr. President. And this bill, as my colleague had said, would weaponize against innocent citizens, like Emailgate. Here in our society, it's Movelang culture we're in. Here in our society, we are known for Movelang, known for making up stories against individuals as Emailgate, or creating lies for purely vindictive reasons or self-gain. We must never forget that a sitting member of this parliament in the other place brought fake emails against a sitting prime minister then from a so-called whistleblower.
Mr. President,
today those emails were proven to be fake. Imagine now, Mr. President, what will happen
There's a point of
when you
order.
implement...
Senator, there's a point of order. Point of order, Senator, Minister of Tourism. What's the point of order?
46.6.
Okay, so...
Yeah, I moved on, Mr. President.
Right.
Yeah.
Move on.
Yeah,
Move on,
I've
please.
moved on. I call anybody name.
You identified persons by
Imagine who the cap fits wearing. Who the cap fits wearing. You know.
Senator Gopeesingh, have a seat, please. When I ask you to move on, just move on.
All right, President.
Thank you.
Honorable President, I always listen to your admonitions and so on. Imagine what will happen now when you implement some of these provisions, which could simply be hearsay. Innocent people will be targeted. So this open-endedness of this bill will open the floodgates for vindictive, revengeful, and abuse of innocent individuals. The bill says you can make a disclosure if you believe something will happen. Imagine reporting without proof that wrongdoing has occurred. If you imagine something will happen, this bill says you don't need to identify the person while you could make the disclosure anonymous. So you're making a report on somebody you don't even know. Worst, accused individuals have no way of having a civil remedy to challenge these procedures. How could you accuse me of something and I can have the ability to redress. Mr. President, you must have been young. I went through this thing in 2002, 22 years ago, when the government of the day tried to lock me up. It went through the courts for 2 years. And the chief magistrate at that time said these charges are not known to law. The prime minister at that time said I got off on a legal technicality. And it went to the High Court. And the High Court took 2 days to listen to this. And he himself, the judge, Justice Myers, says these charges are known to law. So when the prime minister says, Karunaa says his bosom body is his bosom body, fine, we are bosom buddies for 50-something years. But he said, I don't know what happened to him since he turned UNC. It's because they tried to lock me up. Yeah, say I turned
Big time.
Okay, so number one, 46.6 is at play. That is imputation of improper motives. And I would ask you to retract that statement. That statement cannot stay on the Hansard record as it is.
I retract that statement, Honorable President.
PNM, wicked PNM.
So, accused individuals have no way of having a civil remedy to challenge procedures. So now workers who want revenge for being fired for their own failure could make false claims against the company. Political parties could have men of straw filing false disclosures against entities or individuals. Worse, Mr. President, people gossip. They may simply be gossiping and someone use that info to make a disclosure. So, and then you have competing firms could have employees derail another company with fake disclosures. The legislation comes at an economic cost as well, Mr. President. Businesses will be forced to spend money to set up these whistleblowing units. If this legislation is implemented, some businesses could be financially exploited by workers who threaten to make false disclosures. Some businesses could lose money over false disclosures or accusations. And this bill doesn't protect whistleblowers enough, Mr. President. The bill protects from demotion, firing, litigation, etc., but it doesn't speak to the more sinister element of harm or crime or murder against the whistleblower. I will come to that pretty shortly, Mr. President. State expansion. The bill is bringing the private sector under the scrutiny of the state, when all private sector organizations and companies and so on have to file these things with the possibility of political interference. You bring in the private sector and all these companies have to file these things. And so you're bringing the private sector under the scrutiny of the state with the possibility of political interference. This legislation will place private sector firms under scrutiny from the 21 designated authorities controlled by the state. While these authorities are supposed to be independent, they are often controlled through political appointments. The politicization of these once independent designated authorities, there are 22 of them, including the DPP, FIU, Auditor General, etc., may cause problems for private sector firms. Mr. President, will journalists be protected under this law? If a whistleblower gives information to a journalist and they publish it, will the journalist be protected? Will the whistleblower be protected? In recent years, we have seen media houses being searched after they publish certain stories. We have seen prime ministers walk into a station after a radio announcer said something against them. Given that culture, will we protect journalists? So, Mr. President, I want to move on next to some areas of further discussion on this bill. This government has really failed in every aspect of governance and now continuing to try to deflect from their failures and incompetence. Yet, in the middle of this economic and social crisis, this legislation is just their latest attempt to distract from your inability to govern our nation. This bill, which was already defeated due to serious breaches of constitutional rights, is back here again as an attempt to deflect attention away from the crisis this government has led us to. The government has spent the last 9 years covering up and hiding information from the public domain. Now they want to try and pretend they care about those who expose corruption. It is a government of secrets and cover-ups. The citizens of this country are very intelligent, Mr. President. They are judging this government on what they have done, not what they say they are doing, because they know those are two different things. Does the PNM seriously expect the population to believe?
A point of order. 46-1 and there's some 46-6 as well. And what's going on?
It's a government.
There's a bill in front of us. What is
Mr. Browne, it's a government. I'm not calling.
Allow me to rule, please.
Sure.
So again, Senator Gopeesingh, just tied to the bill that is in front of us. It sounds as though you're closing, so I would ask you to continue closing. You're not closing? Well, you finish at 10:52, so you have just over 5 minutes left.
8 minutes.
Continue.
I thank you very much for the continuous guidance. I appreciate it, Honorable President.
I wouldn't get back to the president.
Mr. President, when a member of the Police Service Commission blew the whistle that a high-ranking government official broke the law and intercepted the Police Service Commission merit list at the President House, this government crashed the whole Police Service Commission. In fact, whistleblowers at TSTT have recently been victimized, according to a news report from the Trinidad Guardian, 2 senior workers. So, when a former government minister was accused of sexual harassment, public monies were used to settle the matter in court, and the details sealed with a non-disclosure agreement. When this government refused to lay the NIB reports in Parliament, which they are obligated to do under the law, the leader of the opposition took legal action to force this government to follow the law. How can this government continue to protect those who expose lawbreakers when this government themselves are biggest lawbreakers in the land? And will stop at nothing to ensure that they will stop at nothing to ensure that they mute any whistle blown at them for their wrongdoings. That is victimization, that is discrimination, and that is detrimental action. It is right there in the bill at Clause 4. Mr. President, let's not forget about the Minister of Energy, under whose watch the NGC board wrote to the Minister of Finance asking for indemnity for the board losing $440 million. And what did the government and the Minister of Energy do? Attack the media for carrying the story saying they are UNC agents. So according to this government, if you expose their corruption, you're not a whistleblower, you're a UNC agent. This government wants to protect whistleblowers just as long as the whistle is not blowing on them. The PNM lashed out at the Integrity Commission, accusing them of being in league with the opposition. So why this whistleblower bill is not sound? The whistleblower bill says it is about tackling corruption. The long title reads, in part, an act to combat corruption and other wrongdoings by encouraging and facilitating disclosures of improper conduct in the public and private sector to protect persons making those disclosures. The whistleblower bill is nothing but a big showboat sailing to nowhere. Secrecy, corruption, and oppression are the building blocks of the PNM, and that will never change. The PNM has never been about transparency, accountability, or good governance. This bill is nothing more than lip service. It is all for show, to give citizens the impression that the government is working. And to make it look like the UNC does not want to support any laws to expose corruption, this is because we do not want to, this because does not protect whistleblowers, it endangers them. Mr. President, we see all the time around in this country people who had been on the whistle protection witness protection program. witness protection were being murdered all the time. And so when somebody gives evidence and reports somebody, you think they feel safe? Would they feel safe? Mr. President, the amount of people who have been...
Senator, you have 5 more minutes.
Yeah, sure, thanks. The amount of people who have been murdered while waiting for cases to be called is phenomenal. And this country has no witness protection program. Murder attacks on state witnesses, Trinidad Express. State witness murdered 3 days after 3 men committed to stand trial.
Yes, so Senator Gopeesingh, I understand what it is you're trying to do, but I haven't gotten the connection just yet in relation to this whistleblower bill. So don't go too deeply into the witness protection program.
What they see or what they know, and to a whistleblower officer and so on. Do you think that there would be no repercussions for that? People see somebody committing a crime and they're afraid to talk about it. And these are situations now with this whistleblowing legislation where you're to report something. People are losing their lives from having been at places where crimes were committed. There was a case recently where a woman went to make a report at a police station to identify a witness, to identify someone. And before she reached home, she was dead. And her partner was dead as well. So this here is not the safeguarding whistleblowers, you know. They will be in very imminent danger, Mr. President. So this thing is not going to work. All they feel that they could bring in whistleblowing legislation to help the situation. So, Mr. President, we can note how the PNM has persecuted whistleblowers, and this is a perverse law. This is not a whistleblower bill, but a witch hunt bill. This is not about holding the government to account. It is about the government using the resources of the state to witch hunt the opposition. It is about the PNM using the government to persecute the UNC.
Senator, have a seat.
Yeah.
So that last statement is in breach of Standing Order 46.6. Again, thank you.
And we must go back to Basdev Pandey time. Everybody will remember that in the 1990s. So what about the Wilson Nelson indemnity scandal? It illustrates how this government intended to use this to persecute the UNC. In the meanwhile...
Again, Senator, you just said it again. That is in breach of Standing Order 46.6. So I would ask you to refrain from making that connection and that statement.
Okay. What about the whistleblower who revealed the extent to which Kate Middleton's investigations were politically focused in a leaked document? What about the whistleblower who revealed that this government purchased Israeli spy software, Pegasus, to hack into WhatsApp communications? So, Mr. President, the PNM do not want to protect whistleblowers. They want to cook up cases against the opposition, use false claims under the claims of whistleblowing, protect their political lackings from being exposed in order to make sure that
Senator Gopeesingh, have a seat. Senator Thompson-Ahye.
Thank you, Mr. President, for allowing me to join this debate on the Whistleblower Protection Bill 2022. Mr. President, many, many moons ago, when I was a teenager, I was convinced that my father's mission in life was to stop me from having fun. I loved to whistle, but Daddy would say, "Stop whistling in the house." I wish he were alive today so I could say to him, Daddy, you know government bring a law to protect whistleblowers in the house? He probably would have said that for a person who reads so much and with so many dictionaries in the house, he was surprised I did not know the meaning of whistleblower. This is no laughing matter. This is a serious bill. It has a long, long title that explains its import. An act to combat corruption and other wrongdoings by encouraging and facilitating disclosures of improper conduct in the public and private sector, to protect persons making those disclosures from detrimental action, to regulate the receiving, investigating, or otherwise dealing with disclosures of improper conduct, and to provide for other matters connected therewith. Clause 1 gives the short title, the Whistleblower Protection Act 2024. Clause 2 indicates its commencement on a date to be fixed by the President by proclamation, and we hope that it would come soon after the bill is passed, which depends on the government. Clause 3 is the interpretation section and explains many terms, including the purport of the legislation, to whom it applies, to which action it refers, and the meaning of many terms used in the legislation. Although the bill speaks of combating corruption and other wrongdoing by encouraging and facilitating disclosures of improper conduct in the public and private sectors, when one looks at Clause 3, at the definition of designated authority to whom the bill applies, and you see the offices or bodies listed in the schedule who are caught by the legislation, it would seem that the bill is not as wide-ranging as it could be, but limits or circumscribes its actions and its targeted groups to a rather narrow segment of legal and societal groups. The scheduled designated authorities are Auditor General's Department, Board of Inland Revenue, Bureau of Standards of Trinidad and Tobago, Central Bank of Trinidad and Tobago, Children's Authority of Trinidad and Tobago, Custom and Excise Division, Election and Boundaries Commission, Environmental Management Authority, Equal Opportunity Commission, Fair Trading Commission, Financial Intelligence Unit of Trinidad and Tobago, Integrity Commission of Trinidad and Tobago, National Physical Planning Authority of Trinidad and Tobago, Occupational Safety and Health Agency, Occupational Safety and Health Authority, Office of Procurement Regulation, Office of the Director of Public Prosecutions, Office of the Ombudsman of Trinidad and Tobago, Regulated Industries Commission, Trinidad and Tobago Police Service, Trinidad and Tobago Securities and Exchange Commission. The list seems long, but as I said, it seems as though many office holders were outside of the net. And I can be forgiven for erroneously believing, as I had, that the legislation doesn't apply to many office holders, but more of that anon. Mr. President, my love for learning is insatiable. I belong to a number of international organizations whose conferences I attend. Some years ago, at an Association of Family and Conciliation Courts conference in Tampa, Florida, we were shown a video made by a whistleblower. The video showed a middle-aged man playing golf. Nothing wrong with that. We know many middle-aged men who play golf. This particular video, though, the man who was playing golf was a judge. That judge should have been attending a conference paid for by the state, but he chose to absent himself from the conference to play golf. The video was made by his clerk, whom he did not treat very well. And he shared the video. It went viral, and that judge was fired. The clerk became a hero for his whistleblowing. I was in law school in 1981 when our Prime Minister, Eric Williams, died. I was asked to run for office. I know that would catch your attention. As president of the Students' Representative Council. Having won the election, as part of my duties, I had to attend academic and examination council meetings at home and in Jamaica. Whenever I visited Jamaica, I made it a point to collect their tutorial sheets and on my return advise students that these sheets were available to them. I thought it important because some of our courses were joint courses, and they should know what was happening at Norman Manley Law School because the examinations would be joint. I took my time and prepared answers to the questions on the tutorial sheets. Mr. President, I was shocked to see some of those very questions appearing on the exam paper. We had not been taught some of the topics on the exam paper. I clearly recall 2 questions dealing with damages for breach of contract arising out of distress and disappointment in holiday cases. The worksheet referred to an article which was not available in our library. A few days before the exam, I located the article in the New Law Journal in the office where I had done in-service training. I was outraged. After exam, I wrote the principal, telling him about my findings and concerns. At the meeting in Jamaica, I disclosed what I considered as improper conduct by the Jamaican tutors. The then Director of Legal Education, Aubrey Fraser, told the tutors they must return the next morning, a Saturday, to discuss my concerns. Every single tutor was livid. They looked daggers at me. Even though I was then a mere student, I stood my ground and presented my case of the Jamaican students having had an unfair advantage. It seemed to me that was the reason the exam results in Trinidad were always not as good as Jamaica's. It was not because we didn't have a proper law school, as was touted. I myself did exceedingly well in the final law school exams, but it was only because I had studied those Jamaican tutorial sheets and not because I was brighter than my colleagues, and that offended my sense of justice. When the government pays for someone to attend a conference abroad and the attendee absents himself or herself to go on tours in the foreign country or to go shopping, or government pays for employees to attend an online course to enhance the job performance and the employee disregard the course, or a principal removes a child legitimately on the list of successful SCA students in favor of someone not assigned to her school, but whom she wants to favor, and you can ask a former General Secretary of the PNM about that, and also my sister, those are acts of impropriety or misconduct involving public funds. Now, the sums involved may be small, but remember what our former president said about streams going into rivers and rivers going into the seas. Thank you very much, Senator. 13 years ago, I received a phone call from a regional chief justice. He said he was about to pay some bills, but thought he should check with me first. He explained the circumstances to me. I promised to have my secretary photocopy, then email him some signed documents that would be of assistance to him. When he received the documents, he phoned me, and I could hear the pain in his voice. I can't believe my eyes, he said. These are my judicial officers. At first, I had concluded that these acts of impropriety fell outside the ambit of our whistleblower bill, as the perpetrators were not named or within the designated authorities in the schedule. I had planned to recommend an amendment to our legislation to accord with the Barbados Whistleblower Protection Act 2021, which defines in its interpretation section, clause 2, persons exercising public functions as A, public officers, B, members, chief executive officers, managers, directors and employees of state-owned enterprises, and C, any other person who holds a legislative, executive, administrative, or judicial office in the government of Barbados, whether appointed or elected, permanent or temporary, paid or unpaid. My original intention was to pontificate and advise my government that when we draft legislation such as this, we should not consider that we do not have a problem with particular office holders, but that we are seeking to put systems in place to avoid such a situation. It is neutral, not ad hominem legislation that we are crafting. It is not who sits in the chair today, but who could sit in that chair tomorrow. There are no sacred cows. In case you're thinking that this bill is not about little things, it's only about big matters like foreign bribery, matters of that ilk, remember what our former president said. So I was going to commend the government, asking them to look at the Barbados whistleblower legislation. However, I must now eat humble pie, which does not taste so good. What I did not do before was to take into consideration in the interpretation section the definition of public body, which reads, public body has the meaning assigned to it by Section 4 of the Public Procurement and Disposal of Public Property Act 2015. Having done so, I have to sing another tune. I can see clearly now the rain is gone. I can see all obstacles on my way. Now, according to our Public Procurement Act, public body means the office of the president, the parliament, the judiciary, a ministry or a department or division of a ministry, the Tobago House of Assembly, or a division of the Tobago House of Assembly, a municipal corporation established under the Municipal Corporations Act, a regional health authority established under the Regional Health Authorities Act, a statutory body responsibility for which is assigned to a minister of government, a state-controlled enterprise, a service commission established under the Constitution or other written law, or Chapter 2504, or 2905. This bill, our bill as drafted, is wide-ranging and captured within its net many fish as destructive and big as the infamous Tobago shark. Clause 3 details the nature of detrimental action that can befall a whistleblower, if not protected under the law. When you examine our definition of detrimental action and compare it to what obtains in Jamaica's Protected Disclosure Act 2011, Guyana's Protected Disclosure Act 2018, and Barbados Whistleblower Protection Act 2021, we observe that the laws across the jurisdictions are almost identical. They seek to protect whistleblowers being unfairly subject to disciplinary action, demoted, harassed, intimidated, or victimized, transferred against their will, unfairly refused transfer or promotion, given adverse references, and similar penalties. The improper conduct that this bill requires to be reported is fairly wide and includes A, criminal offense, B, failure to carry out a legal obligation, C, conduct that is likely to result in a miscarriage of justice, D, conduct that is likely to threaten the health or safety of a person, like putting Vicin in the water for Trinidadians, conduct that is likely to threaten or damage the environment, conduct that shows gross mismanagement, impropriety, or misconduct in the carrying out of any activity that involves the use of public funds, act of reprisal against or victimization of a whistleblower or person related to or associated with a whistleblower, conduct that tends to show unfair discrimination on the basis of gender, race, place of origin, social class, color, religion, or political opinion, or willful concealment of any act described in paragraphs A to H. Now, Clause 4 is an unusual but important clause, as it relates back to disclosure of conduct which may have occurred prior to the enactment of the law, Mr. President, when one takes into consideration the far-reaching and long-term effects that the improper conduct may cause, this provision is justifiable. Clause 5 stipulates that the Act binds the state, which indicates that agents of the state are not automatically exempt for acts performed in the execution of their duties. Clause 6 gives the parameters for making a report, timelines, and manner for disclosure of the improper conduct. Clause 7.1 outlines the circumstances under which a disclosure of improper conduct may be protected, including the necessity for good faith and reasonable belief not made for personal gain, and follows internal procedures. While Clause 7.2 lays down that a disclosure is not protected if the whistleblower discloses information which he knows or ought reasonably to have known is false. Mr. President, I foresee that there might be difficulty in determining reasonable belief. We learned as law students that sometimes a convincing witness may be at times a mistaken one. At the conference in Tampa I spoke of earlier, I hired a taxi to take me from my hotel to the venue on the first day. The following day, I got the same taxi driver. He seemed delighted to see me. And he said, I told my wife about you. I was puzzled and asked what he meant. He said, I told her I drove Judge Maybelline. He was crushed when I told him that not only was I not Judge Maybelline, but I knew her only by watching her on television just like he did. He kept looking at me through the rearview mirror and wondering, I felt sure, if I was traveling incognito. Clause 9 refers to anonymous disclosures and the circumstances under which they may be rejected or processed. Clauses 10 to 12 details the requirements for the appointment of and duties of reporting officers for internal disclosures and their duties. And clause 13 to 16 deal with external disclosures to a whistleblowing report agency of a designated authority, its composition and functions, guidelines and procedure for the performance of its functions. Clause 17 to 19 describe the immunity from criminal, civil, or disciplinary liability afforded whistleblowers who make protected disclosures, the circumstances under which such protection may be lost, namely when the whistleblower was the perpetrator of or accomplice in the improper conduct. And this provision, our 18, is the same provision that we find in the Barbados legislation, the Guyana legislation, and the Jamaica legislation. So it's nothing that is peculiar to Trinidad. Clause 20 provides protection for the whistleblower by prohibiting disclosure unless within certain parameters of information that identifies or could lead to his identification unless the whistleblower consents in writing to such disclosure. This is important as disclosure can have very serious consequences for a whistleblower. This section also details guidelines for sharing information between the designated authority and its units. Clause 21 now provides remedies to a whistleblower who is in danger of or has suffered detrimental action in breach of the protection he is entitled to under this legislation to apply to the High Court for relief, and the nature of the relief the court can make, including granting an injunction, reversal of the detrimental action, damages, and or compensation. While 22 details the offenses that may be committed under this whistleblower law and the penalties on conviction. Clause 23 outlines the matters with regard to disclosures that are required to be kept secret and confidential, such as the identity of the person and of the material supplied, and the penalties for failure to comply. Now, this can be a real challenge for us, the question of keeping secrets, for as Earl Lovelace said in Justina's Calypso, it ain't have no secret in this place. But we have to persevere. Clause 24 sets a penalty of $15,000 and imprisonment for 2 years on summary conviction for obstructing a whistleblowing reporting officer or director or other officer of a whistleblowing reports unit in the performance of his duties. And I wonder if this penalty is a bit low in the circumstances. Clause 25 lays down a penalty of $30,000 and imprisonment for 5 years on summary conviction of a person who, knowing that a document or thing is relevant to disclosure or the processing of a disclosure under the Act, destroys, mutilates, or alters a document or thing, falsifies a document or makes a false document, conceals a document or thing, or directs, counsel, or causes in any manner a person to do anything mentioned in paragraphs A to C. Clause 26 now prohibits inclusion in a contract of service or other agreement in between an employer and employee, and any provision which purports to exclude the protection provided for under the Whistleblower Act. And that's very important because, of course, employers don't want to be exposed, and therefore they would try to tie you in so that they would have no fear of that happening. Clause 27 provides for amendment of the schedule by order subject to affirmative resolution of Parliament. And I say glory, hallelujah to this, and we know why. Clause 28 provides for regulations to be made for carrying into effect the provisions of this whistleblowing legislation. And these regulations are also subject to affirmative resolution, so somebody is listening. Mr. President, I should like to propose an amendment from the Jamaica's Protected Disclosures Act 2011. Section 27 of that act provides, this act shall be reviewed from time to time by a committee of both houses of Parliament appointed for that purpose. 2, the first such review shall be conducted not later than 3 years after the appointed date. Now, I heard it mentioned in a negative light, the fact that people are changing and amending their legislation. But to me, that is something positive, because things are going on all over the world. We are developing all kinds of things in technology. And you find that as we discover certain things, we may need to change our legislation to fit a particular need. So there's absolutely nothing wrong in amending legislation from time to time. It's not a fault, it's nothing wrong, and I commend this to us for our inclusion. Thank you very much, Mr. President.
Senator Hislop.
Thank you. Thank you, Mr. President. It is an interesting time to be coming in this late at this lovely hour. I hope that I do not put any of my colleagues to sleep. No. Mr. President, I want to thank you for the opportunity to contribute on this piece of legislation before us, a piece of legislation that I would consider extremely important and vital to the governance or the good governance of Trinidad and Tobago. I also want to take this opportunity to compliment the Prime Minister for sticking to a campaign promise since 2015 to make sure that this legislation comes to fruition. It took some getting. It was started in the first term of his government and lapsed. But we are now at this juncture, and I think it is an important juncture for us to be at as a country. A juncture that says that we are taking or making significant strides in treating head-on with corruption. And I don't think anyone, any citizen or anyone in this House is going to shy away from the fact that Trinidad and Tobago over the years have had to deal with a scourge that is corruption. And it takes a real government to put itself in front of the magnifying glass. It takes a real government to put itself under scrutiny. Because this is what this legislation is doing. This legislation is seeking or is placing this government. This government is taking a decision to scrutinize itself, to set up a legislation so that citizens could scrutinize the government, so that employees within state entities can scrutinize what is going on. And if there is something to report, if there's a whistle to blow, there is now a mechanism after this legislation is passed to do that. You know, I sat, Mr. President, through 2 contributions from the opposition. And as challenged as I was, Mr. President, by both contributions, I had to sit as a member of this House. I had to sit and absorb, because I had to contribute. All right? Your colleague says endure, but I will say absorb. You see, the UNC, Mr. President, will never support whistleblower legislation. We don't expect them to support whistleblower legislation. And for Senator Gopeesingh to keep on the rant that the PNM is seeking to go on a witch hunt. Well, you have cocoa in the sun. It had to be that you have something that you're afraid of. Because if this government, Mr. President, is willing to put itself under a microscope. If this government is willing to do that, then I would think that members opposite will be willing to support this legislation, because they will now have a legal framework, an avenue. Well, that is why they're afraid, Mr. President, because it's retroactive. It has to be, that's the reason. Has to be. Because yes, all the scandals that transpired under the People's Partnership, we know it is in the record of Trinidad and Tobago. And that may be the reason why the UNC is afraid of the whistleblower legislation. That is why only one member, Mr. President, and they are suffering from rising. Because one member saw it fit, Mr. President, to stand with the government and say, I'm doing this. And all of a sudden, the MP for Komuto Manzanilla is a pariah. Up until 2 weeks ago, or a week ago, he was a colleague. And because he took one decision, let me move on. Because he took one decision, Mr. President, to vote with the government on what is considered good legislation. And it's not only the government is saying that it is good legislation, you know. I will show, Mr. President, that there are entities who have commended the government for taking this bold step. Senator Gopeesingh, Mr. President, went down a road this evening. And both Senator Gopeesingh and Senator Mark are speaking to that there is no definition of improper conduct. And I don't know if both my colleagues on the other side, Mr. President, did not read the legislation. I don't know if we have a different vision on this side, because the legislation clearly states improper conduct means A, criminal offense, B, failure to carry out a legal obligation, C, conduct that is likely to result in a miscarriage of justice, D, conduct that is likely to threaten the health or safety of a person, E, conduct that is likely to threaten or damage the environment. And I think Senator Thompson-Ahye read them out as well. And so I don't know if it is that the government and the independents have a different piece of legislation than the opposition. I am at a loss. And we keep, Senator Gopeesingh kept speaking to the fact that there were shortcomings. But for what reason, Mr. President, Senator Gopeesingh had a challenge sharing with us what the shortcomings are. And that is the challenge when you come to a debate with a prepared speech. When somebody, right, and if I'm to go, Mr. President, we're talking about regulations. And I have a piece of document in my hand, Mr. President. Where am I? Page 19, regulations, saying that there is no framework for the legislation, that he's asking the question whether or not we are allowing entities to create their own framework. And if I'm to look at, this is clause 28, the minister may make such regulations for the processing of disclosures and other information collected under this act, for the retention. Mr. President, there's a hum. A hum. For the retention of disclosures and other information collected under the act, for ensuring that all information that is relevant and necessary for the purpose of this act is retained by whistleblowing reports units, prescribing the length of time during which disclosures and other information collected under this act may be retained by whistleblowing reporting officers and whistleblowing reports units. for the destruction by whistleblowing reporting officers and whistleblowing reports units of information in their possession which is no longer necessary for the purpose of this act. For the conduct of independent reviews of information retained by whistleblowing reporting officers and whistleblowing reports units to ensure compliance with this act and its regulations. And G, generally for carrying into effect the provisions of the act. This is the framework that the entire process is to be built on. And for members opposite to come and say that it doesn't have any, Mr. President, I am challenged by the level we are at this time in this debate. And if I'm to just touch on Senator Mark, Mr. President. He talks about reporting and what's the word? I can't even pronounce the word. Anonymously. Yes, anonymously. For whatever reason, the pronunciation just left me. Anonymously made disclosures. And he's saying that there's what he shared with us, that there is no protection. Yeah, there is no protection. And if I'm to go to Section 9, Mr. President, subject to subsection 4, disclosures made anonymously is not a protected disclosure. It's right there. Senator Mark was saying that when a disclosure is made anonymously, it is protected. That is what he said. That the whistleblower is protected when he makes, or the anonymous whistleblower is protected. That is what he said. But based on the legislation before, Section 9 says, subject to subsection 4, disclosures made anonymously is not a protected disclosure. Subject to subsection 3, a whistleblowing reporting officer or whistleblowing reports unit may receive and process an anonymous disclosure and may take the disclosure into account in determining whether improper conduct has occurred. Where a whistleblowing reporting officer or whistleblowing reports unit, after having taken into account all the relevant circumstances, considers that the information in an anonymous disclosure is likely to be defamatory or libelous, the officer or unit shall reject the information, but keep a record of it in the event that the person who discloses the information becomes known and liable to criminal or civil proceedings. It's right here. So I don't know which legislation that Senator Mark read. Clearly, from the contribution, Senator Mark clearly did not read the legislation or came with a preconceived idea. The opposition said that hopefully they had a caucus. The opposition said that we're not supporting the bill. And that's what they came in to the House with. And thankfully, Mr. President, we had an SC clear up the issue about, I think it's Section 7. And we didn't have to rely on a BL. To identify for us what Section 7, what Section 7. I am challenged, Mr. President, when a member of this House could say that the whistleblower should say that he's going to blow the whistle.
Like how?
That just defeats the purpose of the legislation. If we're doing whistleblowing legislation, so I must tell you that I go in I have information that you may be involved with something illegal. So I must come and tell you, Mr. President, my colleague, Senator Nizam Al-Lising, I understand you are involved with something. I'm going to report you. I'm going to blow the whistle. That defeats the purpose of why we're here. And there's a difference between reporting a crime versus breaking a confidentiality agreement. And I think it comes in, your fiduciary duty comes into play if there's a crime taking place in an entity. How do you, as a citizen, you have to balance your moral compass, whether you stand on the premise that I see something, so I must say something. And Mr. President, that's where I would leave my colleagues on the other side for now. I commend this bill. You know, there's a passage that says, a passage of scripture that says, the heart is deceitful and above all things, deceitful, wicked, and above all things beyond cure. But that's the human nature. That is the human nature. And because we are who we are susceptible to shortcomings. And corruption is a people issue. Because you have systems in place, you have laws in place, but it boils down to whether or not you as an individual, Mr. President, is going to do something that is corrupt. And so it boils down to a people issue. And the reality is governments come and governments go, but what remains constant? People. And if we come to this house as legislators, as Minister of Foreign and CARICOM Affairs said in the previous debate, that we have a responsibility as legislators. What are we doing? And if we come to this house to put legislation on the books of Trinidad and Tobago that will seek to strengthen the systems that we have in place, to regulate people, then I can't see what is wrong with that. And you know, it is said, I heard it over and over again, that this is bad law, and nobody supports the government, and the UNC will support good law. But you know what I find interesting is that the good favor that we had for the polygraph bill, if I should just show it, just a couple hours ago, has gone out the door completely with whistleblower. And it goes back to the point of whether or not people have cocoa in the sun, Mr. President. That they're afraid of the piece of legislation. And I want to say, the entity that was referred to that basically decides whether or not, the entity we've signed on to, decides whether or not we are corrupt country or not, Transparency International, has said that they welcome the whistleblower legislation. They welcome it. They welcome a government in the Commonwealth, a government in the world instituting legislation to regulate itself and to seek to wipe out corruption. And if we're to read from Newsday article, Sunday 23rd, June 2024. The Trinidad and Tobago Transparency Institute applauds the passage of the Whistleblower Protection Bill in Parliament on June 21st and calls for its swift, uninterrupted passage in the upper house. That's what we hear. Swift, uninterrupted. Whistleblower legislation has been identified as one of the key tools in the fight against corruption. By TT Transparency Institute, our advocacy has been unrelenting for several years, and we are delighted at this development, it said in a statement. Mr. President, the article goes on to say, from Transparency International, this legislation is meant to provide a safe space so that witnesses and victims of corrupt practices can feel assured that their disclosures of improper conduct in the public and private sector can be made under the protection of this legislation from detrimental action. And we went through the history of this and why we're here. The bill states, and you know, they want to say that the MP for Komuto Manzilena is one of our friends, but the article referred to the fact that he broke ranks with his opposition colleagues and voted for the bill, resulting in 22 votes for and 15 against. This Transparency Institute has given the government of Trinidad and Tobago the thumbs up on this piece of legislation, Mr. President. And if I am to quote from a Guardian report, if I'm to quote from a Guardian article, 26/36/2024, Business Guardian, Afra Raymond. I don't think Afra Raymond is a friend of the. Afra Raymond and the government has had several run-ins. So I wouldn't say that he is a friend. But Afra Raymond, a chartered surveyor and managing director of Raymond and Pierce, said most fraud and white-collar crime is reported by tips. So the effective tool has to be, if you see something, say something. We also need to push for more effective investigations and prosecutions, but first we need what? We need high-quality information. And that's why you need a whistleblower, because the reality is there's information, Mr. President, that a whistleblower will have that nobody else has. And that is the reality of it, and would have, as Mr. Raymond says, would have high-quality information. Raymond, a former Joint Consultative Council president, said the Association of Certified Fraud Examiners in 2014, the Global Fraud Survey study identified that whistleblowing is the best method of detecting fraud. This is not the PNM saying this. This is what an independent entity gave in a 2014 report, that whistleblowing is the best method of detecting fraud. Tips are consistently and by far the most common detection method. Over 40% of all cases were detected by a tip, more than twice the rate of any other detection method. Employees, Mr. President, accounted for nearly half of all tips that led to the discovery of fraud. That's what this study showed. That's what this study showed. And one of the things that's interesting, make sure I have it. I want to go to another entity, Mr. President, the Greater Tunapuna Chamber of Industry and Commerce. And they said, Mr. President, the whistleblower legislation enhances transparency and accountability, protects individuals who report misconduct, promotes ethical business practices, ensures legal and regulatory compliance, and strengthens public confidence in both public and private institutions. That's what we're seeking to do. By adopting and enforcing such legislation, the country can foster a more robust, transparent, and trustworthy economic environment, ultimately contributing to sustained economic growth and development. When potential whistleblowers know they are protected, they are more likely to report misconduct, leading to more effective oversight and compliance. And this is what the Chamber has detailed in their support of this legislation. And if I'm to jump to an editorial, Mr. President, editorial from all the way back in 2015, an Express editorial March 18, 2015. It says, according to a 2013 report from Transparency International, 3 fundamental requirements for such legislations are accessibility and accessible and reliable channels to report wrongdoing, 2, robust protection from all forms of retaliation, 3, mechanisms for disclosure that promote reforms that correct legislative, policy, or procedural inadequacies and prevent future wrongdoings. This is what, in a 2013 report, Transparency International reported as the 3 fundamental requirements for whistleblower legislation. And I believe, based on the legislation that we have in front of us, Mr. President, that the legislation covers all 3 aspects, all 3 fundamental requirements, Mr. President. And you know what's interesting? In that editorial, the writer goes on to say that in that context, and that's the context of us creating this legislation, Dr. Rowley has set a worthwhile but difficult goal, and this is before we were in government. Because this was a promise, a commitment that Dr. Rowley made as opposition leader, that once the PNM forms the next government, whistleblower legislation is going to be paramount. And the editor says that in that context, Dr. Rowley has set a worthwhile but difficult goal. And this government has proven over and over again that we are not afraid to make difficult decisions. Over and over again. Even if it means putting the even if it means the government is putting itself under a microscope. As the 2015 election campaign continues, his exposition on this issue may prove one good measure of how prepared the PNM and Dr. Rowley himself are to take over the reins of government. This is what the editorial says. It showed how prepared the government was. But the opposition at that time was to take over government. But Mr. President, I want to move to another area. That is the work of the Parliament as it relates to whistleblowing recommendations. And what's interesting, I have in front of me, Mr. President, that there are 2 committees in this Parliament, 2 joint select committees that are chaired by opposition members. Public Accounts Committee, chaired by MP Tanku, and the Public Accounts Enterprise Committee, chaired by none other than the leader of opposition business in the Senate, Senator Mark. These committees, Mr. President, had several inquiries with several government agencies and entities. And I want to read very quickly a couple of things coming out of this, Mr. President. The entities that they met with would have been the Trinidad and Tobago Fair Trading Commission, Office of Procurement Regulation, Public Complaints Authority. That was those entities they met with the Public Accounts Committee. The Public Accounts Enterprise Committee met with the Trinidad and Tobago Mortgage Finance, now Trinidad and Tobago Mortgage Bank. They met with MTS and NP, National Petroleum. What we have before us are reports that came out of those inquiries. 4th report of the 12th Parliament, 5th report of the 12th Parliament, 16th report of the 12th Parliament. This is under the Public Accounts Committee. Under the PAEC, we have the 7th report of the 12th Parliament done into Mortgage Finance, now Trinidad and Tobago Mortgage Bank. The 11th report of the 11th Parliament, MTS. 16th report of the 11th Parliament, NP. What I find interesting, what I find puzzling, if not inconsistent, that the very same opposition members who led committee inquiries, Mr. President, within which whistleblower policy is clearly considered as important at the level of individual public entities, simultaneously take issue with the very same thing being addressed by an overarching legislation. So, Mr. President, our colleagues on the other side, who chaired committees that gave recommendations that whistleblower policy should become part of these entities, are now having a challenge with an overarching legislation that would be more significant or more stringent than a policy. And so they're in favor of a policy for an entity, but they have a challenge with an overarching legislation. And if I'm to go to some of the recommendations, Mr. President, Omnibus report examination of the audited financial statements of state enterprises, NSD, SL, ETech, NFM, and so on. A whistleblowing policy provides standard guidelines within which organizations respond to the ethical or moral concerns of their employees. The TTMF's whistleblower policy includes the process of communicating ethical concerns internally and forms part of the reference policies of the Code of Business Conduct that were reviewed by employees and confirmed in writing. Despite this commendable initiative, there were no incentives in place to individuals who were willing to provide information, right? The recommendation of the committee, Mr. President, the TTMF should revise its whistleblower policy to include incentives for persons who give valuable information and are willing to testify about crime in the TTMF. That's a recommendation. And that's a recommendation for a policy. I think it was mentioned that is something that could be looked at, incentivizing. But that is another discussion all by itself, Mr. President. But the point I want to make is that recommendation after recommendation, it says that this report, the examination of the audited accounts of the National Maintenance, Training and Security Company, MTS, the recommendation is that MTS should establish a formal whistleblowing policy by June 30th, 2018 and report on its implementation to the committee by June 31st, 2018. So the committees that are chaired by UNC members, Mr. President, are recommending whistleblowing policy for entities, but are here today and in the other place voted against whistleblower legislation. And it points again always, Mr. President, to the hypocrisy of the UNC. Reporting to NP. NP should consider having a channel for whistleblower reporting directly to the company's internal audit departments. That's the recommendation in the report, Mr. President. PAC. The TTFTC should report to Parliament on the status of the development, completion, and implementation of the whistleblower policy by July 31st, 2022. Recommendation from the PAC. And we could go on and on, Mr. President. But this is the hypocrisy that we have to deal with on a regular basis when it comes to good law coming to the House, and the opposition has a challenge with the legislation. And I don't know for what reason. Has me wondering whether or not they are concerned about their own skin and are worried that this piece of legislation could cause some of them to get some warming, as they used to say a long time, get skin burn. Yeah? But there's a cost of corruption, Mr. President, because of wrongdoing. That's what you would get your skin burned for. Wrongdoing, only wrongdoing. Mommy wouldn't beat you for anything other than wrongdoing. But there's something that sometimes I think we overlook, Mr. President, and that's the cost of corruption. And the thing about it is that not only does corruption cost the country in dollars and cents, but there's something called the quality of life. And I'm reading from a Commonwealth magazine, Commonwealth magazine, dated the 15th May 2023. Curbing $1 trillion cost of corruption, more important than ever, says Secretary General. And at the opening event, the Secretary General said, while we tend to think of corruption in purely monetary terms, the truth is that it costs us the quality of our lives.
Senator, you have 5 more minutes.
Thank you, Mr. President. No country, region, or community is immune. It damages education, health, justice, democracy, prosperity, and development. And it is one of the biggest impediments to achieving the Sustainable Development Goals. That's what corruption is. That's what corruption does. Tackling corruption brings multiple benefits. Poverty is reduced, economic stability and growth are increased, and standards of living are raised. Because there's a cost that we incur as a country, as a world, when we allow corruption to continue. And once again, I want to make the point that this government has taken the bold step, Mr. President, in putting the microscope on itself in bringing this legislation. And there's also an issue when it comes to small states and the cost that is incurred by small states to deal with corruption. Could you imagine when you consider maybe all the money the revenue that Trinidad and Tobago would have lost through corruption over the years? How much greater as a country we could have been? How much greater as a country we could have been if we were not losing millions of dollars through, or billions through contracts that were, clauses that were removed from contracts in the last minute before an election, and projects that are overpriced, and live sport, and on and on and on. Could you imagine, Mr. President? But I want to touch on one last thing before my time expires, Mr. President. There's a concept called 6 degrees of separation. And in our society, where everybody knows everybody, in the more developed nations, it is called 6 degrees of separation, or 6 handshakes. So it will take you 6 people to get to somebody of note. You have to know 6 people or 5 people in between to get to that 6th person. But in a society like Trinidad and Tobago, I think if the developed world is 6 handshakes, Trinidad and Tobago may be 1. And then if I'm to drill it down to my home island, it is 0. Because in Tobago, everybody's related in some way or the other, Mr. President. Everybody's connected. Let's say that. Everybody's connected. Everybody's connected. You know the movers and the shakers just by being in the village. Just by you going to the same school. You're working in you're going to the same church. So if you want to meet a contractor in Tobago, well, they're playing football together. Well, they're linemen by Basso together. You're going to church together. You're linemen by Barcode together. And when you have legislation that can protect a whistleblower in an island like Tobago, where in the recent times we've seen an uptick in corruption, uptick in the last 2.5 years, significant uptick in corruption. It gives an individual who knows somebody the ability to report the person anonymously, or to report or to highlight the corrupt activity anonymously. And it changes the culture. And I know what the challenge is with this legislation. I think Senator Vieira spoke to it. What we're seeking to do, Mr. President, by not only this legislation, but the polygraph and all the other legislations that the AG will pilot and continues to, we are seeking to change the culture in Trinidad and Tobago. The culture, there needs to be a, we can't take it for granted and just accept the fact that, hey, we corrupt and we could roll so. That if I need to get something done, I carry a brown bag, I carry a drink, and I'll get it done. And so, Mr. President, as I close, I want my full support to this legislation. Because what we're seeking to do as a government is to create a culture shift, is to create an environment where corruption is no longer the norm in Trinidad and Tobago. And for this, I give my wholehearted support. Mr. President, I thank you.
Senator Dillon-Remy.
Mr. President, at this late hour, I am going to say thank you for allowing me to join this very, I think, intriguing and interesting and important debate. And I have listened very closely to my colleagues who have gone before me. And I would start by saying there is no way, Senator Hislop just said something. He said that it's a people thing. He said that corruption is a people issue. And I know that was stated again by, I'm not sure who else said that. And he also said the legislation that are being piloted or put in place, they are seeking to change culture. And I would just like to say, as I sit here and listen again to my colleagues in this honored place, I'm concerned about one thing with this legislation, and I hope that it is not indeed, as the opposition says, that this is going to be a tick in the box to make sure that Transparency International would no longer have to say about Trinidad and Tobago that we don't have legislation. And therefore, by putting the legislation on the books, we are very happy. It would not work for Trinidad and Tobago. If we are interested in indeed shifting the culture, just putting something on the books will not get us there. I am hearing the opposition saying that this is something that the PNM is putting to get at the opposition. I would imagine that that also says to me, I'm thinking in my heart, I would think the best of them, that they really want the legislation, but probably they want the legislation to be a bit more robust than what is happening. I am going to assume that. I'm going to assume that. I am going to assume that. I'm going to assume the best. They want it a little more robust than what is happening right now, because I do believe that they want to see corruption disappear in Trinidad and Tobago. I am going to believe that. I am going to believe that. Well, I am going to believe the best of them. So therefore, I would want to know as to what would have happened in the Joint Select Committee that they would have had with this legislation, because I understand that this legislation at some point in time was put before a joint committee, and my understanding is that the opposition did not participate in it, or they were not very involved. I don't know. But I would think that if something like this would have come to a joint select committee, that hopefully the opposition would have sat down with the government, well, because in a committee we are there as committee members, and seek to put something indeed more robust than we have here right now in place, so that they would not be complaining that this legislation is not good enough. Because I would, as I said, I would think that we are here and we indeed want the best for our country, and whatever is being discussed right now and whatever we are seeking to put in place now is something that we would want to make sure that in the future, our children and our children's children will be able to say, listen, something was done in this generation to shift to move looking at the index, the corruption index, and Trinidad and Tobago sitting way below other Caribbean countries. It is heartbreaking. And I know all of us in here don't want to see that. I am confident that all of us don't want to see that. And we want to see change. Right now, I think we have probably a little difference in terms of how it should happen. So, one, that this is not just something that is being put on the legislation to tick. And two, that hopefully the opposition will indeed come on board and probably put some, recommendations for changes to make the thing more robust. That at the end of the day, we would get something that we would be proud of as Trinbagonians to make sure that this thing is shifted and it does not become. So, Mr. President, culture change is very difficult. We all know that. Trinidad and Tobago did not get like this overnight. And therefore, the change in culture is not going to happen overnight. And again, putting a legislation in place is not going to change the culture. Because the people that you have to put in the system who will become the people to make the changes inside the system, if they are corrupt too.
Mr.
Business.
Mr. President, I beg to move that this Senate do now adjourn to Wednesday, July 3rd, 2024 at 10 a.m.
Honourable Senators, the question is that this Senate do now adjourn to Wednesday, the 3rd of July, 2024 at 10 a.m. Those in favour say aye. Aye. Those against say no. I think the ayes have it. The Senate now stands adjourned to Wednesday, the 3rd of July, 2024 at 10 a.m.